Representatives from the Commonwealth Public Sector Union, CPSU, and also the Australian Federal Police Association to give evidence today. For the Hansard record, would you please state your full name and capacity in which you appear before the committee? Can I ask the CPSU representatives to do that first?
Thank you, Chair. My name is Arundhati Tandell and I am representing the CPSU as a Senior Industrial Officer.
My name is Osman Chu and I'm representing the Community and Public Sector Union as the Senior Policy and Research Officer.
Thank you. And the AFPA?
My name is Alex Caruana and I'm the National President of the AFPA.
And my name is Giles Snedker and I'm currently the Acting Legal Manager in the AFPA.
Thanks. So although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. Can I now invite perhaps the CPSU first to make a brief opening statement and then the AFPA and then we can go to discussion. You don't have to make an opening statement if you don't want to. We can cut to discussion, but that's up to you. So CPSU, did you want to make an opening statement?
Thank you very much, Chair. We might take the opportunity to be able to make an opening statement. So thank you for the opportunity to appear before this Joint Select Committee. The Community and Public Sector Union represents people working across the Australian Public Service. Our members work in agencies from Services Australia and the Tax Office to agencies including the Federal Court and the Australian Commission for Law Enforcement and Integrity. We strongly support the creation of the proposed National Anti-Corruption Commission, and we have publicly advocated for the creation of a National Anti-Corruption Commission that is independent, properly resourced, transparent, and with broad powers to investigate all forms of corrupt conduct, including integrity regulation and oversight at the political level. Corruption compromises the work of our members as Australian Public Service staff. A National Anti-Corruption Commission will give them the confidence that the integrity of agencies is being upheld and actions are being taken to ensure that agencies are free of corruption. The creation of the National Anti-Corruption Commission is an integral element of a framework for ensuring integrity at the Commonwealth level to better promote public trust in integrity of the Commonwealth public sector, the Parliament, and more broadly, the system of government. We believe the inclusion of grey area corruption risk areas is essential to cover potential areas for such conduct, such as in relation to government outsourcing, contracting and subcontracting arrangements. And we welcome that the proposed Anti-Corruption Commission has broad jurisdiction to investigate serious or systemic corrupt conduct, including in these areas in relation to contractor and labour hire arrangements that may be used by the Commonwealth and decisions relating to the outsourcing of government work and the award of government contracts and grants. The National Anti-Corruption Commission's investigation and inquiry powers and functions should not, however, be used as an alternative for dealing with allegations that concern disciplinary or misconduct issues which do not meet that threshold requirement which is set out in the bill regarding systemic or serious corrupt conduct. And those types of issues rather should be dealt with through existing internal agency disciplinary and investigation processes. In relation to getting the balance right, it's important that due consideration and individual privacy concerns and public interest in those balance of those issues are considered as part of this process. The CPSU believes that enabling public hearings when it is in the public interest, while ensuring a default of private hearings to protect against unfair prejudice to an individual or to a public servant's reputation, their privacy, their safety or well-being when called to give it evidence, does this. The bill addresses these issues in our view. Underpinning the success of an anti-corruption commission will be enforcing best practice whistleblower protections. Public servants must feel safe, and I should say parliamentary staff, so members of parliamentary staff, should also feel safe to refer allegations of corruption and provide information in relation to corruption issues, including as part of any investigation process. Public servant whistleblowers will have protections under the bill, we understand, equivalent to those under the Public Interest Disclosure Act in relation to disclosures. However, we note that whistleblower protections in the PID Act have some deficiencies, which have been identified in the Moss Review in 2016, and also a further inquiry by the Parliamentary Joint Committee on Corporations and Financial Services, which was an inquiry into whistleblower protections in the corporate, public and non-profit sectors. Well, acting on the recommendation of those inquiries or those reviews and reforming the PID Act to ensure that they are in place when the NAC commences operation should be a priority. We note that access for disclosures and potential disclosures to trade union support and advice needs to be considered as it is absent currently from the PID Act, and it was recently considered by the International Labour Organisation at its recent technical meeting on the protection of whistleblowers in the public service sector. That ILO meeting found that protected avenues for whistleblowers to receive independent advice and support from appropriate bodies, including workers' organisations, is an important element of effective whistleblower protection. And lastly, the creation and design of the National Anti-Corruption Commission must involve staff. The CPSU notes that the ALP government has committed $262 million over 4 years for the establishment of and the ongoing operation of the proposed National Anti-Corruption Commission. However, there has been no indication as to the level of staffing as far as we are aware in relation to the proposed staffing for the effective function of the Commission. So given that it is proposed ACLEI staff will form part of the new National Anti-Corruption Commission, it is crucial that ACLEI staff and their union are meaningfully consulted and involved in the development of the proposed commission to ensure that there is an effective transition to the new model. Thank you, Chair.
Thanks. Do the AFPA want to make an opening statement?
Thank you, Chair. I promise I'll be brief. Thank you again for the time for us to present here and to be consulted, and we look forward to working with the committee and the commission when should it be established in the future. Our concerns are spelled out in our submission, but very broadly, they are again mirrored to what CPSU have said in that funding, staffing and resourcing are paramount. We need to make sure that they are funded, that it is funded, staffed and resourced appropriately. This has an impact onto the AFP because ACLEI currently borrow and second staff members from the AFP to assist with investigations, but also importantly, where there are forensic evidence and things like that, the provisions of the AFP are often used to facilitate some of that investigation. So it's really important that that's recognised when this is put up. Oh, apologies, sorry. We also welcome the public hearings or where there is balance in that sense, and we also we are open to exploring the better definition for what exceptional circumstances mean, so it can't be watered down one way or another in either side's favour. As we've previously submitted, we think it's important that doesn't matter where you are in the public space, that you should be held to the same level of scrutiny. And lastly, the appointment of a commissioner. This should be transparent and it should be an open process, whilst ultimately a public or a political appointment. And we think there should be a transparent process into that appointment.
Thank you.
Thank you.
I've got a few questions, so I'll lead off. Can I first ask the CPSU, you're the main union for workers in the Commonwealth public sector, is that correct?
That is right, Chair.
And how many members do you represent?
So we have a number of different jurisdictions. I don't know specifically in the public service how many.
All right, can you come back to us with that? On page 3 of your submission, you say we all witnessed under the former coalition government a significant increase in privatisation and outsourcing of public services, which increased the potential risk of corruption. Can you explain to us how the provision of public services by non-APS staff has increased corruption risk?
Yeah, I'm happy to take that, Chair. I think members have reported to us just significant concerns about the extensive use of contractors, non-competitive processes, and the undermining of the merit principle in the APS. So I thought I'd just sort of give two examples. So in one agency's members previously reported to us that contractors were being extensively used, and then were also being made non-ongoing employees without a competitive process and were being used to fill acting positions at higher levels. So sort of pushing out existing APS staff. And I think another one where there has been significant concerns has been about the previous government's plans to privatise the visa processing system, which would have created a privatised monopoly, which thankfully didn't occur. So in that instance, there were only 2 bidding consortiums selected to participate for a limited tender, but both of whom had known extensive links to the then government. And if it had gone through, the winning consortium would have been set to pocket billions in revenue annually. So concerns were raised about these extensive connections and shared links, which saw public confidence in the probity process eroded. And I think this was exacerbated by the fact that the Secretary of the Department of Home Affairs stated on the record that privatisation of the platform was not necessary. So I think 2 examples of some of the concerns that we've had and have been raised with us, but we're happy to provide further information on notice. But I think having the scope to investigate these kinds of instances would provide a lot of reassurance to the community and APS employees.
Thank you. So are you satisfied the bill before the committee appropriately captures the conduct of contractors?
Yes, we are.
Thank you. To the APA, thanks very much for your thoughtful submission to the inquiry. Could you just outline to the committee who you represent in both the police and the law enforcement agencies?
Sure. So we as AFPA, I think, we look after sworn police officers, sworn PSOs, or protective service officers, and unsworn staff within the AFP. We also look after a handful of other agencies like Police Integrity Commission, Crime Commission, where there is a link to the AFP, including some members that are seconded across to ACLI.
Your submission states that the NAC bills represent the vast improvements on the Commonwealth Integrity Commission framework proposed previously, but which was never legislated by the former government. Briefly, can you tell the committee what you think the current proposal got right that the previous proposal got wrong?
Sure, thank you, Chair. Look, our main concern was the fact that the previous bill didn't allow there to be equity, or there was no equity amongst public officials. So police officers, public servants or senior public servants and politicians were held to different levels of accountability. So where you had, and this is not inconceivable, a police officer doing corrupt actions with a public servant or a politician, the police officer in this instance would always, in every instance, lose their job probably be subject to public hearing, whereas the others may not be, and may even continue working. So we were strongly against that. We're not as the AFPA, nor my members, we're not scared of the scrutiny. We're not scared of the National Anti-Corruption Commission. We are the most highest scrutinised public service in Australia. We welcome it, but what we think is for fair and equity, what needs to happen, and what this bill has addressed, is that equity across the board, so everybody's held to the same level of accountability.
And that's really what you're saying, isn't it? That your members should be subject to the same regime as public servants and politicians. That's what you asked for.
That's right.
And that's what this bill delivers. Is that correct?
Right. That's correct.
Thank you, Mr. Wallahan. Yes.
May I just ask, Mr. Chu, when you gave evidence just then about the example, I think you said the visas being outsourced, visa processing, and you gave that example of contractors being given acting positions at higher wages or higher rates. Did you offer to provide other examples for the committee to help in its deliberations?
Look, I'm happy to provide some further examples on notice to the committee.
If I'm late to the party and everyone knows, Chair, I'll let it go through, but that's the first I've heard of something like that.
No.
The party doesn't start until you arrive, Cinder Still.
I think
Stop reading my playbook.
We will take you up on that, Mr. Chu,
thank you. Thanks, Chair.
to give us those examples. I think it would be helpful because we take what you say in relation to the coverage of contractors. I think, Mr. Wallahan?
Thank you, Chair, and thank you for both groups for appearing today and your submissions. It's greatly appreciated. I just wanted to clarify the numbers that I have for both of your organisations and tell me if that sounds about right. And then I wanted to ask both about the public hearings test, which is a live issue for this committee. Does the AFP, you represent 7,400 members. Are all of the members of the AFP in your association?
No, we represent 4,000. We have 4,000 AFPA members.
And is that because some of the AFP members are not part of the association or they don't pay their fees?
Yeah, that's right. And there's also contracted staff to the AFP that aren't eligible for membership under our association.
No worries. Thank you. And for the CPSU, I might have this figure wrong, but I noted somewhere on a website there was 155,000 APS employees, so that's not including contractors. Does that sound about right? And do you know the rough percentage? I know you're on notice to give the exact number, but that are members of your union?
Apologies, I do not have that information with me, but we will be able to provide it on notice.
That's all right. Thank you. So if I could just go to the specific issue of public hearings, and perhaps if I could start with the CPSU. Where am I? So on page 4 of your submission, it's titled Broad Investigation and Public Hearing Powers. And you both note the importance of public hearings and then have a however. And you say must be required to have due regard to protecting certain things, and you include reputation, privacy, safety, well-being when called to give evidence. And a lot of those are mirrored in the draft provision in section 73 on the discretionary factors. I just wanted to, there's one that's not there, and I just wanted to get your opinion on it, which is that if one of your members was potentially subject to a criminal charge and a criminal trial, do you think one of the considerations for your members should be the prejudice of a future fair trial?
Yes, I can take that question. Thank you very much. We did that. Leaving that out was inadvertent. If that is included in the draft bill and in the explanatory memorandum.
Sorry to interrupt you. It's not in the draft bill. There's an argument that it's covered in some other discretionary areas, so for full disclosure, but it's not expressly in the draft bill.
Right. Yes. So our view in relation to public hearings is that it is important that the reputations of those and the privacy concerns of those individuals is protected from unfair prejudice, and that the default being that the hearings occur in private. We probably are open to the idea of there being some clarification in the legislation in relation to defining exceptional circumstances, which would either make it preferable or appropriate for evidence to be given in public rather than in private. But in terms of your specific question about prejudice in relation to criminal cases, I suppose we would note that some of our members, our CLEI members, we have spoken to before, and when they were asked about their views on private hearings and public hearings, there was a general consensus that private hearings can work better than public hearings, noting that the standard of proof for ICAC in New South Wales, and recently here, is on probability, and findings cannot be made about guilt. So there's a lower level bar in terms of hearings in front of an anti-corruption commission as compared to in a criminal case. So public hearings could potentially impact on the ability to prosecute corruption afterwards because of any media attention, and could impact on any criminal matters as well.
Thank you. Yesterday we heard from the Australian Psychological Society, and they represent 20,000 plus members who are mostly psychologists. And we heard from Dr. Davis McCabe, who's the president-elect. In their submission, they address the issue of public hearings and the effect it has on someone's mental health and the consequences of that. And in the submission, Dr. Davis McCabe, or the association, the society, makes the point that individuals who experience public humiliation and shame can suffer major depressions, suicidal ideation, extreme rage, severe anxiety, and even psychosis. And then down the bottom they say this, and this is what I'd like your opinion on. For many people, their professional persona is core to their self-identity, and any damage or threat to it is therefore amplified. Is that observation something that you recognise as being important to your members? Oh, sorry, I'll get to, the same questions will go to AFP as well, but for CPSU.
I mean, we haven't heard the testimony in full, but from the quote that you've provided to us, yes, our members, they have they gain great personal value from the work that they do in the public service, and the important work that they do for the benefits of the Australian community. And so I would concur with that view that their mental health will be very much linked to the pride and the I suppose the status that they receive from their work. Osman, did you want to add anything on to that?
Yeah, I mean, I guess the other aspect when thinking about the Australian public service is that, while the majority of Australian public servants, work across the country, 40% of the APS is located in Canberra. So I think that also should be a sort of consideration given, the ACT is a particularly small jurisdiction with public administration being the largest industry. So I think that does make it a bit different from, I guess, some of the other jurisdictions where it is far more spread out. So people often know each other, yeah.
Oh, thank you. I didn't know that percentage. Thank you. Thank you for that answer. So the same questions to the AFP. If I could go to your submission on public hearings, you say, you specifically note the point about the exceptional circumstances test, and you say will evolve over time. When you say evolve over time, do you mean that it will evolve through the Parliament, or do you mean that it will evolve as some cases come before the courts and they define what those words mean, like it happened in Victoria?
Exactly what you mean, as it will evolve as the time progresses through the processes and through the court. That's why we think there needs to be a little bit more of a definition around it, just to give it a left or right arc so it doesn't evolve too far away from the intent of what the term exceptional circumstances mean, where it could be exceptional. One could presume that exceptional circumstances could be for police officers only and not for other public officials. So we would like to see that exceptional circumstances across the board is linked definitely across the board to any public official.
No, thank you. And I do respect and acknowledge your points you made on equity. They were well made. If I could then go to the same questions that I put to the CPSU, and again, I don't want to give special status to any group, but the fact is that the Commonwealth has a lot of federal police officers and Defence Force members, and I wanted to get your perspective on the importance of professional persona being core to your self-identity, and if there's been any studies or any experiences that you've had as an association for when members lose that and what it means to their mental health.
Sure, look, it definitely, our default position is for private hearings, except for exceptional circumstances, particularly because of the mental health of the members, but also because of the fairness going on if it does evolve into a different type of a trial or a different type of a hearing. But certainly as police officers, not just police officers, but PSOs and unsworn members, there is a personal identity linked to the job that they have where they're working for the AFP and the job that they do and the role that they are performing for the community. So there is a lot of pride in the job that they do. So when someone is essentially put out in the public and that's stripped away from them, whether that could even be internally through the AFP, we do notice that there is a marked mental health factors that start occurring, and that could be from minor as embarrassment, not wanting to come to work, right through to proper depression or diagnosed depression and so on. So we are very mindful of that side of the house. However, we do feel that it is important to still have an opportunity under exceptional circumstances where it is in the public interest to have those public hearings, to make it clear to the community that we are being fair, we are being transparent, and when something bad happens, we're not going to hide away from that, noting that there will be or may be some mental health issues associated with that.
And on the list of discretionary factors that the Commissioner may consider, do you think this committee should turn its mind to whether an express reference to prejudicing a fair trial should be considered?
I think so. I'll turn to my legal colleague.
No, I mean, from our point of view, I think, there should be some reference to future implications to that particular individual if the hearing is in a public setting. Not only in terms of the impact on that individual, but in terms of impact on the justice system as a whole, with any prejudice and towards that particular person. We, from an organisation, from the AFPA's point of view as well, we often see simultaneous investigations into our members, both at a criminal level and at a internal level. And I've long had issues with the potential harm that obviously that can do, even though there is meant to be a separation. I think it should be. I think the committee should turn its attention to the notion of what the potential detriment could be to a person who is before a committee for corruption, and whether that would actually have detriment to that individual or, as I say, the justice system being able to actually prosecute further down the track.
Thank you. And my final question is to the AFP Association. What are the current staffing levels like? Is there pressure in your organisation, like there is across the economy, for staffing? And do you think that will be magnified as many of your members might actually get employed or seconded to the NAC?
Yeah, look, resources-wise, staffing from the membership, we are stretched. Certainly in the ACT jurisdiction, ACT policing jurisdiction, very stretched. But as we move out into helping other agencies with other projects or other NPPs, NPIs that come up, that we are AFP's often drawn on as subject matter experts to assist. Certainly with the creation of the NAC, which we support, appropriate funding, resourcing and staffing needs to occur so that that impact onto the AFP is minimal, or the AFP can bolster their resources, certainly around forensics and cybercrime and digital forensics. They can bolster their resources in there so that when the NAC does turn to the AFP for assistance when it comes to assessing the evidence, the digital evidence that comes in, that those resources are there and we're not stretching an already stretched organisation.
And finally, can I...
That's finally.
No, it's not a question.
Your last question.
No, it's an observation.
10 minutes.
Sorry, Chair, it's a final observation. I just want to thank both organisations and all of your members for your service to the Commonwealth. Thank you, Chair.
Thanks.
Thank you.
No, I want to go to Senator. We've got 10 minutes. You're on the list, Senator Shoebridge.
Thanks, Chair. And look, I suppose I should declare that I'm a member of the CPSU. I don't think that's going to deeply prejudice me in the course of this, but just on the record. In terms of the exceptional circumstances test, I think my understanding, you all agree that the test should be uniform. There shouldn't be a get-out-of-NAC-free card for politicians or any other class. Do you agree with that?
That's correct. That's the whole point of why I think we need to have a definition, or at least a left and right arc, so it can't be watered down or a get-out-of-NAC-free.
Yeah, it's exceptional if you come in a police uniform or if you're, wearing a particular staff hat. It's got to be a uniform definition.
That's correct.
Does the CPSU agree on that?
Aye. Yes, Senator.
Yep. And then, as I understand it, the CPSU would contemplate some kind of clarity along the lines of a definition that says it's exceptional circumstances where it's preferable or appropriate for evidence to be given in public. Did I hear you correctly on that?
I suppose if any clarification is required, perhaps that could be included in the legislation.
Yeah.
We haven't turned down to what these factors would be.
Yeah,
Along those lines.
and then as the AFP says, if we put something in like that, it'll at least put some guidelines as to how that practice should develop. And I see you nodding, Mr. Karana, but that doesn't turn up well on transcript.
Oh yes, definitely. Yes, I agreed. So
Yeah.
just to give that guideline so that it can't be watered down.
Yeah, and something along the lines of what the CPSU suggested is a kind of guideline-y working starting point. Is that what you're thinking? Eyebrows don't turn up either.
To
to
me,
the
yes,
AFP,
yes,
yeah.
I agreed.
Yeah.
Yes, I agree.
Note, eyebrows raised. And all right, could I then ask just quickly to the CPSU? There's going to be a fair bit of shake-up amongst the staff of ACLEI. Has the government negotiated with you, and do you have some protocols about the security of the staff as the functions transfer over?
I might take that on notice. We are not aware of any discussions yet or any information that has been shared as to what the staffing arrangements would be. I'm not aware that there's been any discussion about how it would occur.
Yeah, but
I think, as far as I understand, the bill provides that all the roles of ACLEI and the functions will be subsumed within the NAC. That's my understanding.
But your members must be wondering what that means for them in terms of their job
Absolutely.
security. And has the government sat down and spoken with you about it?
Look, I think we'll take that on notice, as we haven't been privy to any of those conversations, but happy to take it on notice.
What about the AFP? Any of your...
Not to our knowledge. We certainly haven't been formally approached or consulted.
Right. And then lastly, to the CPSU, you say that it's not clear what the staffing arrangements will be like for the new NAC. Again, has the government come and discussed with the union a kind of framework or a basic staffing structure, so as you can be satisfied that there'll be enough staff to do the work your members will be required to do?
So Senator, going back to the previous question, so myself and Aru have not been personally involved in any conversations, but we're happy to take that on notice just to confirm.
All right.
Thank you. Dr. Haynes?
Yes, thank you, Chair, and thank you to our witnesses. Could I just take this question to the AFP in regard to this exceptional circumstances clause that you have concerns about? Given that there's 5 safeguards already built into the bill, there's also subsection 3, which says that the Commissioner is not limited in the matters to which they may have regard in terms of public hearings. Would you agree that it would be simpler if we have exceptional circumstances knocked out completely?
Look, that's a very good option, Doctor. I think that's a very good option.
Thank you. Could I direct this question to the CPSU, please? You raised grey area corruption, pork barrelling, in your submission and in your witness statement just now. Can you tell us, please, why this is important? And could you also elaborate if you think the legislation, as it's currently drafted, actually captures this and the capacity to investigate pork barrelling?
Thank you for the question. So I think it's important that the proposed National Anti-Corruption Commission does have the ability to look at grey area corruption risk, because it does undermine trust in government, and that makes it harder for the jobs that our members do on an everyday basis. Undermining trust in government makes it harder to deal with the big challenges that we face. So I think that has to be a priority. So in terms of the second part of your question, it was about...
Do you think the legislation as it's currently drafted is explicit enough that we can capture pork barrelling in this National Anti-Corruption Commission?
Look, I would say from the outset, that I'm not a lawyer, but as far as I can tell, it seems broad enough that it should enable that.
Could I ask you also, are you aware of the New South Wales ICAC Jersey review into pork barrelling or maladministration and the recommendations there about ensuring that that's captured by definition of corruption?
So I'm generally aware of that report, but I haven't read it, so I'm not across the details of it.
Thank you. Could I also ask the CPSU, you raised the issue of protection of whistleblowers as being very important to your membership. Could I ask you if the creation of a whistleblower commissioner or authority, a safe house for whistleblowers, would be something that you would support?
I think it, in a general sense, it is something that we would support, but we note that it is not in this proposed model. And also, I guess the Attorney General has said that the government will be responding to the recommendations of the Moss Review to better protect whistleblowers. So we're hopeful through that process there will be strengthened protections for whistleblowers from the public service.
Could I put to you, though, that I support this updating of the Public Interest Disclosure Act very much, and also reassured that that's going to happen. But beyond that, what we know is that there is no capacity for redress for people who do breach protection of whistleblowers, and international best practice is to establish such a thing as an authority, a safe house for whistleblowers. This committee has an opportunity to make recommendations, so I'm curious if such an authority would be something that both the AFP and the CPSU would be broadly supportive of.
And noting that the Moss Review doesn't contain that important architecture. So simply referencing the Moss Review won't answer that question.
Yes, but also noting that the Attorney General's on record that he's going to update the Moss Review, and that he wasn't just going to respond to the Moss Review. So, with all of those caveats, have you got have you an answer?
From the association's point of view, we think the devil will be in the detail. As long as it's an appropriately funded and resourced, and it does have the correct amount of nous to be able to prosecute or to pull people into line where need be, then it would be an appropriate resource for whistleblowers. If it's just there because it's there, then there's no point in having it.
Yeah, absolutely.
Thank you. I guess my final question is around the independence of this National Anti-Corruption Commission and the importance of budgetary oversight, the importance of appointing a commissioner who's not politically aligned, for example. The bill has provision for a statutory oversight committee of the Parliament, which would have due regard to appointment of the Commissioner and the budget. As it stands, the legislation has it set that there would be a government chair with the casting vote. I'm eager for your opinion about whether we should explore a different model for that oversight committee that would give a non-government member the chair position, or that we could have other models within that may have two members of both the opposition and the government that need to agree on the appointment of a commissioner or on budgetary oversight, for example. Could I have both unions' views on that?
Sure. Certainly from the AFPA point of view, that's something that we would welcome, where it isn't swayed by the government of the day, that there is a truly independent commissioner in there, and either of the model, any of the models that you've described are good options. But certainly where you've got the ability for government to for want of a better term, stack the decision, that sort of erodes that independence and sort of erodes the perception that commissioner is a truly independent appointment. So I certainly am happy with the proposals that you've put up, and I think that they're great ideas, and I think the community it will meet the community expectations, certainly my members' expectations as well.
Thank you. No more
Chair,
questions.
I've just got a supplementary question following from... Quickly. This is a really important point, but in terms of the questioning from Ms Haynes, you seem to indicate, and I'm not sure this was your intention, because no doubt this submission reflects the input of your members, that the exceptional circumstances phrase might, from a simplification perspective, be excluded. But isn't that important to maintain exceptional circumstances as indicated in your submission, to make sure the default position is private hearings?
Sure. So thank you for the question. The exceptional circumstances phrase, if it's going to be included, it needs to be defined, so that therefore it can't be watered down. If it was to be excluded, it's our understanding that it would default back to the other regulations and the other points that are in the legislation or that are in the bill currently. So therefore it would negate the fact that there would be exceptional circumstances, because it would by default fall back to those other provisions that are listed in the bill.
But you're happy with the existing wording in the bill?
I think the bill currently provides enough.
Okay, that's...
Could I just make a point
no,
there?
No, no, you can't, because it's called to, and I have to go to Mr. Lim. Mr. Lim.
Thank you for coming, everyone. Yeah, exactly. I only got one question for AFP and one question for CPSU. So my question to AFP is, in your submission, you noted that a few staff from AFP will be required to assist NAC in the early days, and it build and recruit people with specialized capability and investigation skill. Do you have a rough idea on how many officers this may be required and the impact it may have on AFP ability to carry out its function?
Yeah, thank you for the question. And look, that's a great question, and it's going to be difficult to quantify until we know exactly what the remit of the NAC's going to be. If the NAC's going to be a standalone organisation with its own forensic capability, with its own intelligence capability, etc., then the impact on the AFP to set it up will be significant, but at the back end of that, once it's set up, would be reduced. If it's going to be running at the current model, similar to the current model, where ACLI are relying on some of the resources to concurrently do investigations, then as the commission grows and the remit of the commission grows, then that is going to be drawing down on resources from the AFP and taking away their ability to do some other investigation. So consideration needs to be given as to how big or how small the NAC's going to be and what exactly that agency is going to be made up for. I personally, I don't see any merit in duplicating, having two forensics, digital forensic resources, two telecommunication intercept resources. I still think using the AFP's resources is the way to go. That will mean resourcing the AFP to cover the resources that a NAC will be drawing down on when they're doing their own investigations. But to give you an exact number, it's really difficult without knowing how big or how small the NAC's going to be.
Thank you. Question to CPSU is, am I correct to understand from your submission that the CPSU support the NAC jurisdiction extending only to serious or systematic corruption and other form of alleged misconduct, such as breach of APS Code of Conduct, should continue to be subject to assessing processes?
Thank you for your question. Yes, we are of the view that that threshold requirement is pertinent in the nature of how investigations occur into disciplinary matters and misconduct matters that concern our members. So where that threshold is not met, existing internal agency investigation processes and disciplinary matters, processes should be where those issues are dealt with. However, in the case where the corrupt conduct is of a systemic or serious nature, then of course it is suitable for the NAC to make its discretion as to the treatment of those issues.
Thank you.
Thanks. Ms. Lawrence, have you got one question?
Just one to the AFP Association. So we heard from the AFP themselves as providing a witness, and they spoke about how within their current practice they have a corridor that allows them to look at criminal investigations separate to perhaps administrative ones, where there's perhaps information sources that are coming through that need to be quarantined. Thinking about the NAC, where there'll be investigations undertaken that abrogates legal professional privilege, do you feel confident with the way the bill is drafted, but secondly, how you feel the mechanics of that will operate within the NAC to ensure that there's natural justice if a matter has to go through to criminal prosecution?
Yeah, sure, I might defer. Sorry, Giles, throwing you under the bus.
No, that is fine. And yeah, thank you for the question. Yes, I mean, as probably the AFP stated, currently they can do, and they do, undertake internal investigations of conduct, whilst there is also criminal investigations being undertaken. Currently, as it stands within the AFP setting, I do have some reservations in terms of if there's enough separation of information potentially, given that it's the AFP doing a criminal investigation and also an internal investigation. From my take on this on the NAC, I am confident that there will be the ability to actually separate, and obviously, especially if there is non-public hearing, private hearings, to be able to separate the jurisdiction of NAC in terms of undertaking, obviously, conduct here, and obviously, things like the AFP undertaking their own internal investigations. I mean, those investigations in the AFP as well are very, they seek, because they are bound by the Act, even those investigations are bound by, secrecy and privacy, confidentiality, to the extent you can't even talk to your partner about you being potentially investigated unless you actually have authorisation to do so. So, but in terms of the NAC, getting back to the question, yes, I am confident that there will be provisions in place to actually create that separation of information.
Thank you.
Chair, I think that there's a degree of ambiguity about the AFP's responses on exceptional circumstances that Dr. Haynes was trying to clarify, and I really think we have an obligation to clarify that. If Dr. Haynes could be allowed to address that briefly.
Well,
we're just leaving it in the ambiguous situation now will not help the committee in its deliberations.
well, the written word says they agree with exceptional
right there.
circumstances. The written word said that. Then they said that it could be out. Anyway, it could be
sounds to me like we should clarify it.
Taken out, and then they said
Which
it
is
could
why
be.
I asked the
Sounds
Which
to
is
me
why
like
I thought there was a clarifying question, but okay. But we
Thanks.
are eating into the the next session. But if you want to clarify, ask a clarifying question,
Thank
but
you.
quickly.
Yes, if I could clarify. given your concerns around the exceptionality of some people being excluded from a public hearing and the 5 safeguards that are already in the bill, plus the additional clause that gives the Commissioner regard to any other matters, would it be more straightforward? Would it be simpler? Would it be your view to strike out exceptional circumstances and take away that confusion?
Point of order, Chair, that's a misleading question. It started with exceptionality of people being excluded. It was a completely separate issue.
Do you think that... Oh, I'm going to ask it because I'm not going to go backwards and forwards, okay? Do you think that the way in which the bill is currently drafted with exceptional circumstances covers the field?
With the exceptional circumstances clause included?
Yes.
I think we would need to create a definition or at least give some clarity as to what exceptional circumstances are.
Thank you. Thanks. Okay. Is that clear? Thank you.
Or we could delete it.
Well, that's not what I said. Thank you. Can I say thank you very much for your attendance today and also for providing the submissions that you put forward. I think we did ask for some additional information from the CPSU. If you could provide that to us within 5 days from today, you will be sent a copy of the transcript of your evidence and we'll have an opportunity to request corrections to transcription errors. Thank you very much again, and I will ask the other witnesses to come forward for the next session.
Thank you. Thanks, everybody.
Thank you.
Gee,
It's only...
it's a big sigh.
Wait till 4 o'clock.
Wait till 6:30.
6:30, no 4. Yeah.
Okay. Yeah, it is. Okay, so, thank you, everyone. I now welcome representatives from the Media, Entertainment and Arts Alliance, the Australia's Right to Know organisation, International PEN Melbourne Centre, the Australian Broadcasting Corporation and Free TV Australia. So I think there's some interaction between some of those groups. So it would be helpful if I just run through them and you identify for the Hansard record, if you could state your name and the capacity in which you appear. But I'll go through them. So the MEAA, who's appearing for them?
Good morning. My name is Adam Portelli. I'm appearing on behalf of MEAA.
Thank you. Australia's Right to Know?
My name's Grant McAvaney. I'm employed by News Corp Australia, who's a member of the Right to Know Coalition.
Thank you. International PEN Melbourne Centre? You're on mute.
Apologies. Christine McKenzie, President of the International PEN Centre.
Thank you. Australian Broadcasting Corporation?
Good morning. My name is Catherine Wilson and I'm appearing for the Australian Broadcasting Corporation together with my colleague Joe Puccini.
Thank you. And Free TV Australia?
Good morning, I'm Bridget Fair, I'm the CEO of Free TV Australia.
And I'm Natasha Eves, Regulatory Affairs Manager at Free TV Australia.
Thank you. So we can, although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I would normally ask you, I would give you the opportunity to do a brief opening statement, but that might chew into half of our time, given the number of organisations. But is there anybody that desperately wants to make an opening statement, bearing in mind that we do have your written statements?
And I think witnesses need to mute when they're not speaking.
And you need to, thank you. You need to mute when you're not speaking because we can hear it. Is there anybody that does want to make a statement, an opening statement?
Chair, if it pleases the committee, we'd like to make a brief statement.
You haven't got a written thing, so that would be useful. Thank you.
And we are a member of ARTK, and I imagine that Mr McAvaney is likely to speak to the specifics of the submission, but we'd like to make a brief statement.
Thank you. Go ahead, Mr Portelli.
Thank you. Thank you, Chair and committee members, for your time today and providing us with the opportunity to address you. The Media, Entertainment and Arts Alliance, MEA, is the union and professional association for Australia's journalists. We have more than 5,000 journalist members working across our country. All of those journalists, as a requirement of their membership, are required to uphold the MEA Journalist Code of Ethics. Importantly, Clause 3 of the Code requires that where a source seeks and is granted confidentiality, that must be respected in all circumstances. We welcome the acknowledgement of the bill of the importance of journalists and their sources in a healthy democracy. The Commission will rely on a variety of sources to provide essential information, and our members, journalists too, will rely on a wide variety of sources in their investigations. If we look back on the recent spate of royal commissions into banking, aged care and indeed many other inquiries, they've been sparked by courageous whistleblowers telling their stories to journalists. They've turned to journalists because other avenues to expose illegality and wrongdoing have been closed to them. They've turned to journalists as a last resort, as the only people they trusted to tell the truth. Journalists can never reveal the identity of a confidential source. To do so would be a breach of their ethical obligations. This principle has been accepted by parliaments across the country. The principle is rigorously observed regardless of how that ethical requirement could imperil journalists. And in fact, between 1989 and 2007, some 7 journalists were convicted because they observed their ethical obligation to protect the identity of a confidential source. And 3 of those journalists were in fact imprisoned. The introduction of shield laws, which has taken close to 20 years to gain full coverage, is still not perfect. Several jurisdictions do not apply the shield for their Anti-Corruption Commission investigations. And worse still, the statute books still allow whistleblowers to be pursued by going after journalists they work with. The committee, of course, will recall that in 2019, the home of a Canberra journalist was raided at dawn by police seeking to identify a confidential source. The next day, the officers of the ABC were raided about a separate story. That raid utilised a warrant that gave police extraordinary power to seize documents and access computer systems. These raids were conducted in response to news stories. These stories were true, they were published in the public interest. However, they may well have embarrassed the government of the day. Committee, while this bill to establish an NACC, in our view, provides some protections for journalists and whistleblowers, it falls short of what is required for genuine protection. Protection that can be bypassed by other laws, or a shield that is not comprehensive or uniform across all jurisdiction, in our view, still imperils whistleblowers, journalists, and the public interest. As the submission from Australia's Right to Know coalition, of which we're a member, explains, the bill contains some really promising recognition of the important role of journalists and journalism, particularly in Section 31. However, this isn't matched by the warrant provisions and other secrecy provisions in the bill and other existing legislation's provisions that interact with the bill and its processes. The bill and the related issues arising from the interactions with existing legislation outside of the bill may very well neutralise the effectiveness of any protection for journalist sources. Greater effort, in our view, is needed for genuine protections for journalists and their sources. Whistleblowers seek to bring light to illegality, wrongdoing and corruption. They should not suffer for that, nor should journalists be published for simply telling the truth. Thank you.
Thank you. Senator Scarr?
Thank you, and thank you very much for the submission, which I found extraordinarily helpful. We have only got limited time, so I want to really get to the nub of the issue. As I understand it, the fact that Section 31 has been included is a positive, but the major concern is the way the warrant provisions operate in practice. It can undermine in practice the ability for a journalist to protect the identity of their source. Because, for example, a warrant could be issued. When the warrant is executed, material can be found, written material, computers, whatever it is, that actually identifies the source in practice. Is that one of the key components of the concern?
That's it. I hope my friends don't mind me answering first. I have the most eye contact here, so I'll jump in. That is it. In short, it is a very, very narrow protection for identifying the source only. When asked a question or subject to a production document, as far as search warrants and all the other things that can come either from this legislation or other pieces of legislation, that information can still be found out.
So if you've got those wide powers in terms of the issues of warrants, which can result ultimately in the identification of the source, it actually undermines the intent of Section 31, which is to actually enable journalists to protect the identity of their sources. Is that correct?
That's correct. Essentially, once you have any form of document, telephone conversation, email communication, WhatsApp communication, your ability to protect the source's identity becomes virtually impossible with a warrant scheme that's in place.
Okay, and that practical issue then raises an issue for me under clause 6.8 of the explanatory memoranda, and I'm going to quote it to you so you don't have to run to it. But it says, and this is in relation to the power of the Commissioner to start own referral inquiries, right? So matters which aren't referred directly to them, but of their own initiative, which I think is a very important power, and it says this: the Commissioner would be able to conduct a preliminary investigation to confirm whether a corruption issue exists, to enable them to make an informed decision about whether, and if so, how to deal with the issue. And then in 6.8 it says that the Commissioner may become aware of a corruption issue in any other way, for example, through media reporting. So in the explanatory statement itself, it's saying that the Commissioner can actually become aware of a corruption issue through media reporting. So that's obviously a significant public good, that the Commissioner has become aware of the corruption issue through the work of the media. But at the same time, you have this incoherence in the framework, because under the same Act, there's an ability for warrants to be issued which could ultimately identify the source, which had originally led to the media identifying the corruption issue, which has enabled the Commissioner to look into the corruption issue. Is that a fair comment?
That is a fair comment, and I would see it as it's almost a two-edged sword. It's an acknowledgement that it's the front page of the paper or the Four Corners broadcast or whatever it might be that draws attention to the issue. The flip side is it's an acknowledgement that it's the media that might have the information, which is almost going to draw attention to the ethical issues that they might have, depending on how the warrant scheme or otherwise is implemented.
So if as a Parliament we're going to acknowledge the important role of the media in terms of the identification of corruption issues, and that's actually identified in the Act, at the same time we need to appreciate the fact that one of the reasons why the media is able to report on those issues is because of the importance of keeping sources confidential.
That's right.
Okay. Thank you. Thank you, Chair.
Senator Sterling?
Yeah, thanks, Chair. I'm mindful of the time, and I'll be led by you, Chair, but I want to put a question to all the witnesses at the table individually, and I think I've got Mr. Portelli's view very clear, and Mr. McAvaney you've touched on too, but feel free to add. Do you all support the formation or the establishment of a National Anti-Corruption Commission?
Bridget Fair here from Free TV. Yes, I mean, we are supportive of a National Anti-Corruption Commission, provided there are sufficient protections for journalists in doing their jobs, and that we don't become an arm of the Commission by virtue of our own investigative activity and being co-opted by the Commission.
Thank you. Chair, I'll let you get the peck in order if it helps.
I'll jump in. Right to
sure.
know. Yes, of course. I think I would see it as akin to courts, tribunals, other investigative bodies. They perform an important role. We just don't want the good that the public interest journalism creates to be undone by any of the procedure involved with it.
Right. Thank you, Mr. McAvaney.
Pen?
Thank you very much for the opportunity, and I'm very pleased to be here in person before. it's a relief, I think, that this legislation is coming before the Parliament. We're very pleased to see it, especially after some of the egregious incident in prosecutions that have been happening for the last few years. We do support very much the NACC, but I've been around long enough to know that power will always try to trump over transparency. And so we're very concerned about the common good and hoping very much, particularly in regard to whistleblowers, that their rights can be protected and that the danger of reprisals against them will be seriously looked at. I won't say any more than that, just in answer to your direct question.
Thanks, Ms McKenzie.
ABC.
Thank you for the opportunity to answer this question. Yes, the ABC is broadly supportive of the bill. However, we have a concern that other witnesses here today would not have, and that is about the unintended consequence of the definition of corrupt conduct, which is found in Section 8, and its possible application to the legitimate work of ABC journalists. We've addressed this issue in our written submission, and I'm happy to speak more about that to you today.
I'm in your hands, Chair.
And I think, is that the MEA and
yeah.
Do you want to elaborate, or they were fine? I think that's everybody's.
Yes, committee. We also are supportive of a anti-corruption commission and one that has robust procedures and protections for journalists and whistleblowers.
Well, thank you very much, everyone. And Chair, I just have one question I want to put to Free TV Australia. So if I can talk to you, Ms Fair.
Sure.
Your submission argues that contractors to government should not be captioned by the provisions of the bill, and that's on page 7. So I'm a little bit confused. Could you just clear it up for me? If a contractor to government is engaged in serious or systematic corrupt conduct, can you tell the committee why they should be excluded?
Well, I think that was just a concern of ours because obviously we're sometimes selling airtime to governments. So we are contractors to government and don't want to, by virtue of our commercial activities, be caught up in the scope of the bill.
I'm sorry,
We're just selling services to the government.
Because you're selling services to
So anyone who just sells any goods or services to the government will potentially come within the scope of that definition, and so we believe it's overly broad. I understand your concern. You're saying you don't want people who actually have an incentive to bring about corrupt practices. I'm saying there needs to be some further thought because pretty much anyone who interacts with government will be caught within the scope of this bill.
I just have to say this. I can't leave it as a thought. Thanks, Ms Fair. But I'm going into Senate estimates round 52 in the next week, and I'm so excited. But over the years, I have witnessed and heard so many times where contractors' eyebrows are raised, but the beauty of it is they've been protected by governments and the bureaucracy who refuse to just answer questions. So it does give me grave concern. Chair, I'm sure that will open up the opportunity for other senators, other members of the committee that may want to follow along that lines with your indulgence.
Thank you. Senator Shoebridge?
Oh, thanks, Chair, and thanks everyone for your evidence and your submissions. Could I drill down into the warrants and maybe have a little closer look at the drafting of the bill? I think all of you support having Section 31 in a general way, but it's how Section 124 operates in relation to search warrants a number of you have engaged in. And can you just clarify for us, first of all, it looks like the drafters have added additional protections in 124 2A and 2B to pick up journalists. And 2A and 2B seem to be mandatory when the search warrant is proposed against a journalist and there's a mandatory public interest test. Am I misreading that?
And there's another component. So if you're looking at 2A, paragraph B, it's in relation to secrecy provisions only. So it isn't it doesn't capture journalists broadly. That's not the case. It's only in relation to those specific provisions.
But so I understand that. So in relation to secrecy provisions, do you think 2A and 2B work in relation to secrecy provisions? Just looking at that narrow scope.
Well, perhaps if I can go first. I mean, the right to know's view in a nutshell is no, it doesn't go far enough. Again, it's a good start, and we acknowledge that search warrants as a matter of course now, generally other than some provisions that came in relatively recently in Queensland, don't require the rights or interests of journalists to be considered at all. But where it still falls short in our view is it's still a warrant that will be issued issued secretly without notification to the organisation or journalist whose interest it might affect. And there's essentially no testing of those public interest angles.
Right.
And then we flesh that out in writing. So I'm just
I
trying
see
to be
that
brief,
points
but-
1 to 5 on page 4 of your submission.
That's right.
You do that.
And there've been, that sort of formed part of PJCIS submissions and lots of submissions in the past.
I'm not going to try and minimise them, but there's kind of substance and process distinctions, and I know the process are absolutely critical for the reasons you put. But if in terms of like the substance of the law about requiring a public interest tests and the interest of a journalists to protect their sources to be protected, if we deleted 2A subsection B, in terms of the substantive protections on warrants, putting to one side how they're applied for, if we deleted 2A subsection B, would the substantive protections be sufficient? And if not sufficient, greatly improved.
Yeah. If any of my friends think I'm jumping in too enough, I'm sure they'll sort of cut in. We would say, broadly speaking, no. If you remove that, okay, again, that's a good start, and I don't want to keep labouring that point. But if we've got any situation where, on the one hand, we're acknowledging the importance of a journalist's right to protect their source, and on the other hand saying, however, there's a discretion here, we can have a think about it and have an argument about it, but in this case, you'll have to disclose your source. You've got two inconsistent provisions. So if you're not protecting your source, you're not protecting the source. So introducing a public interest element, however it's phrased, and we would also say that's not a particularly high threshold here, that the issuing officer has to consider. You're not protecting the source. You can't protect the source.
Does anybody else want to jump in at this point? Is it your starting position there should just be a prohibition on a warrant that discloses the source?
Yes, I think in the context of public interest journalism, if you've got a protection not to answer a question or produce a document, the same should go for a warrant. It's just looking at form over substance again. Okay. It's different forms being used to try and get at that confidential source. It has the same effect.
Yeah. Bridget Fair?
Yeah, I think we're saying that we understand that there may be times where a public interest has to be weighed. But we don't think that the current drafting really gets us there in terms of it's just a bit of a, it's too easy to satisfy. And really, the drafting should be aimed at ensuring that these warrants would only be issued in very exceptional circumstances.
Maybe we could move the exceptional circumstances provisions from Section 73 and whack them into Section 124.
Possibly.
You could, two birds with one stone. So I understand your primary point is that there should be a prohibition. If there's not a prohibition, the public interest test here should more expressly talk about the importance of protecting a journalist source and maybe put an exceptional circumstances test in or similar.
Yeah, almost a presumption against, almost like a presumption against issuing the warrant, except when you can really make out a very strong public interest to do so.
Right. And in terms of the process points, can you think of an existing statutory arrangement that would allow the warrant to be contested, if you like, to have either perhaps you know, if not the journalist, then another officer in there testing the warrant? And I can think of some state-based examples.
Well, there is the journalist information warrant scheme, which, you know, we've pointed out a number of flaws in, and those are addressed in this submission through ARTK, which we also support. But even and there were a number of recommendations from the PJCIS about strengthening that regime as well, none of which are reflected here. But it should be acknowledged that contested warrants work perfectly well in jurisdictions like the UK. So it isn't the case that being a contested warrant would mean that somehow this whole system had to fall down. It is possible to have a contested warrant scheme that is functional. If that's not considered to be satisfactory, then what's in here and what's in... There's a number of warrant schemes across a number of pieces of legislation, including this one, all of which have very inconsistent provisions and none of which have sufficient protections for journalists.
So if there is going to be the warrant scheme continued, then a new 2C, which is giving the journalist the right to contest the warrant, is your starting point.
Look, contested warrants have been across the board a firm position of the media sector. But in any event, to the extent that the government or previous PJCIS hearings have recommended some kind of halfway house, even those recommendations have not been adopted in this bill.
And then could I take you to another point, which is the non-disclosure provisions? Would you support a public interest defence if there's a breach of a non-disclosure direction?
I'd need to go and have a bit of a think about that, but we, don't generally support the issue of non-disclosure requirement as a matter of course, and they seem to be very easily able to be issued here.
And from an advisory perspective, if I can add, it's very difficult to say, all right, we'll breach the order, and then we'll hope that we'll get a public interest defence. So it would make me instantly nervous, giving advice to a journalist to the effect of, don't worry, we'll have a public interest defence on the other side. It's very bold to breach, so certainly. And I would need to consult further on this and can take it on notice if needs be, but I think the defence, okay, again, that may be better than what's there, but it needs to flip it around and be the presumption that we can report, not the other way around.
A presumption against non-reporting.
That's right. Yes, that's right.
And I think you all support that.
Yes.
And then
we don't believe non-publication orders should be made other than in very necessary circumstances. So there should be, a prohibition on making non-disclosure orders against media companies, except where very,
compelling
compelling reasons exist. Yes.
All right. And then lastly, on the exceptional circumstances test for public hearing, you seem to all be of the one view that is an inappropriate constraint on public hearings. Is that right?
We generally support, things being public. That's what the media is about.
Did any of you have the benefit of hearing the evidence of IBAC, the Commissioner of IBAC and the Chief Commissioner of ICAC yesterday, who both gave strong endorsement for more public hearings in terms of accountability for their own organisations and accountability to the public?
Yes, and Media's view, like the others here, is that good government, open government demands public hearings, and it was certainly telling that two of the people who are really at the front line in the two biggest states in Australia dealing with their own anti-corruption commissions have got particularly strong views on this subject, and we think when you've got people like that giving you that opinion so forcefully, it's something you should listen to.
Can I just ask a supplementary?
Yeah, of course.
Can I just ask Free TV, so you would support a public hearing, even if that public hearing would then jeopardise a criminal trial because everything should be public. Is that right? Because you think everything should be public.
I don't think
Well, I think that's not what we said. I think we just have a general view that, sunlight's usually the best disinfectant. So things transparent, generally papered by people knowing about what's going on.
But you could see
where people's rights may be jeopardised are obviously something that the Commission needs to weigh. But at the moment we've got a presumption in favour of private hearings versus presumption in favour of public hearings.
Sure, but you could see why there would be a need for private hearings.
Sure, I can understand that may happen on occasions.
Because I think
there may be national security issues. There may be all sorts of good reasons. But at the moment, the presumption is private versus public.
But a particularly difficult scenario going forward for your employees and members would be if a journalist who had been the subject of compulsion, perhaps a warrant, compulsory hearings, was being forced to disclose sources, threatened with imprisonment, and if that was all happening in private, it creates extreme difficulties in terms of the public's right to know and your ability to protect your employees and members, doesn't it? And that's the kind of nightmare scenario for journalism, isn't it?
We would say that's frightening.
Yeah. And particularly given the Commissioner's powers to put non-disclosure notations on summonses to attend hearings and the inability for a person who's the subject of that notation to seek for that to be reviewed or for it to be removed.
Mr. McAvaney said that's a frightening prospect. Do you endorse that characterisation?
Yes.
Right,
100%.
Thanks, Chair.
Thanks, I think that is... Dr. Haynes?
Thank you to all our witnesses. Thank you for your submissions and your appearance today. Could I turn your minds to whistleblowers? Generally, the submissions from all your groups speak to the need to protect journalists and their sources, which are often referred to as whistleblowers, and that's the word I'll use for the purposes of today. Could you describe to me, and I don't mind who answers this, how are whistleblowers who seek to expose wrongdoing in the federal government currently failed by the systems in place? Who wants to have a try?
Well, I'll jump in. I mean, in relation to this specific bill, there are not probably fair to say insufficient protections for whistleblowers, particularly those which speak to the media, which is our specific interest. They are often required to follow very specific steps, or they're able to actually make their views known, and this can sometimes expose them to internal, actions. And whistleblowers should be free to make their views known and protected in doing so.
Could I ask if anyone could describe to me the typical experience of a whistleblower as observed by media representatives?
If I can perhaps talk broadly, and I suppose talking from having worked for several different media organisations, and so I'm going to be deliberately broad to preserve confidentiality, but obviously you have a whistleblower who is worried from day one about what can happen to them. Can they be sued? Can they be sacked? Can there be criminal penalties for the disclosure of what they want? And usually the best thing the journalist can give them is the promise that they'll never identify them, whether legally compelled to or not, which feeds back into the fact that we would say that the protection for journalists is a protection for the whistleblower themselves as well. I have also seen, and I apologise, I can only give this anecdotally, but I've seen whistleblowers disappear changed their mind about assisting, because when you start to delve into the practical consequences for them on an individual level, if they keep going forward and keep assisting, it scares them off. And good stories disappear as a result.
Thank you. There's been quite a lot of discussion around the Attorney General has made very clear that he will be updating the Public Interest Disclosure Act, taking up recommendations of a 2016 review into that Act to improve it. But there's also a proposition that we've been exploring around a safe house, a whistleblower commission or authority that would in fact be international best practice in the protection of whistleblowers. Could I have your view on the establishment of such a commission or authority?
I think that's a question the ABC would need to take on notice, Senator. In our submission, we say we broadly support the reforms to the PID Act and those coming in at the same time as this legislation, but we can give further thought and respond to that question later.
Thank you. Would anyone else like to comment on that?
Yeah, I think I can only say that the specific, giving a fairly specific answer that's impossible for me today, but other than to say the more protections for whistleblowers, the better. It's an important part of the media doing their job.
Thank you. And just to come back again to the public-private hearings debate, maybe this question to the ARTK. We've talked a lot about non-disclosure notations when someone appears in private at the NACC. Can you just tell me a little bit more about that and why the private element of that is particularly important versus the public element of that?
I think broadly, and a good place to start, and I understand they may have slightly different considerations, but if you look at some of the rulings over the years from various courts and tribunals and inquiries and royal commissions, things that occur in open more than anything help the public actually have confidence in the process that's occurring. So in this kind of situation where the purpose of the legislation is to expose corruption, it's exposure and transparency, we would say that having the light shone on that helps that procedure. Otherwise, you have people who are raising complaints who felt that they couldn't trust the people or were found not to be able to trust the people they thought they could at the higher levels. They go to an organisation for assistance who looks into it, who says, trust us, we're going to do this behind closed doors and we're not going to let people report on a lot of it, but trust us, it will be okay. Our view is the more that happens in public, and certainly as the Chair indicated before, there may be times where certain things might not be, there may be justification for that, sure, but the starting position should be, if we want to have public confidence in this system, let's have it open, not the flip side. That's our view broadly.
And just for clarification, because I wasn't sure I picked it up before, but if the hearing is in private, how does it impinge on the process for media organisations seeking to contest warrants?
I think there's two separate issues. There's the issue of the hearings happening in private and therefore they can't be reported on, which is separate to the warrant being issued initially and not being able to be heard on it in any event. And I think in that case there probably wouldn't even be a hearing for the most part. So I think I'd say that as two issues, unless I've misunderstood the question.
I was trying to unpack that.
No, that's okay, and I apologise if I've missed something.
No, thank you very much. That's all right.
Can I ask a supplementary question just in relation to hearings with respect to warrants? And I think there are a number of important points made in the submission. The first is that if it does have an impact with respect to sources and journalists, etc., the warrant should be heard, in your view, by a superior Court judge as opposed to a magistrate or a member of the AAT, because the importance is such that it requires that level of consideration. Is that correct?
That's right. And am I cutting off your question?
No, keep going.
I was just going to say then there's two parts of that. It's to make sure that those wider interests of the wider public interest issues are looked at as much as the specific circumstances. That's part of it. But part of that process, or what we would see as important, is being able to be represented in that process, because you might have someone like a public interest advocate or someone who can go along and talk about the interest of public interest journalism, but a lot of the time they're going to just be talking in kind of broad brush textbook grandiose kind of way, whereas the journalist actually involved can be a bit more specific about how the public interest has an impact on that case.
So just teasing that latter point out, it's vital that in the course of the process where authority is seeking the warrant, that the hearing be contested so that the arguments against can be properly considered by the Superior Court judge, or the public interest properly weighed, as opposed to it being a sort of an academic exercise where the judge is trying to anticipate what the public interest is. The benefit of a contested hearing is you've got the actual journalist or their organisation putting the solid concrete arguments in favour of the public interest to make sure the disclosure of the source, etc., does not occur. Is that correct?
That's right. And usually you have the person whose interests are affected being represented. You don't have someone they've never met.
Correct. So that's
making submissions for them.
Exactly. So that's the most effective way to consider to weigh the public interest, and that's important. And I think you've made the point very well in that regard. But also, you address the argument that might be put that there's a danger. And I'm playing devil's advocate here, and I know what your response is going to be because I've read the submission. The devil's advocate would say, well, there's a danger if that sort of contest occurs before the execution of the warrant, that a journalist or anyone could actually actively seek to destroy information, etc., that might fall within the ambit of the warrant. But isn't the answer to that just doesn't occur in practice, and that the media organisations have a track record of being responsible in that regard?
No, it doesn't. That's right. And maybe if I could answer it a different way. So this isn't put this way in our written submissions, but when a media does a big story, they know it's going to be looked at. I mean, it's not going to be a shock all of a sudden that there's an investigating body. So the media already know that these things are going to happen, and I can say from experience, they're not running around deleting hard drives, ripping up their notepads and swallowing them, any of that sort of thing. They know this process is going to occur. It's just not that world where they go, oh, okay, all of a sudden there may be a search warrant, we better get rid of everything. So those concerns just aren't warranted.
And those concerns aren't justified by the reality of what's occurred in the past?
No, not at all. And I just tend to think, and I'm stepping out of it a little bit, but I mean, if you find out the search warrant's being executed, I mean, we're not... The evidence is going to be a notebook or a hard drive in any event. So certainly in practice, I don't think any journalist goes ahead and destroys it. But look, let's say hypothetically they did. Having a contested hearing or not isn't going to be the difference between someone doing the wrong thing.
And it would arguably be contempt of court or...
Absolutely.
To do it in any event.
So I can indicate that, I mean, broadly our view is that, I mean, once you're on notice, you've got some real legal issues if you go ahead and walk out to the dumpster and start getting rid of everything. It just doesn't work like that. It can't work like that.
And the other practical issue is it seems somewhat pointless to have the contest after the search warrant's been executed. You really need to have a process prior to the issue of the search warrant and the execution of the search warrant, as opposed to trying to deal with it ex post facto. Is that correct?
Yeah, or we would say, I mean, it's much harder after the fact, and the investigating officer will already have the information. There may be undertakings that they have to give, but they've got it.
Okay.
So there's still a concern, how do you unsee something that you've...
Yeah. Now, one last supplementary
Can I just
question.
add
Oh,
something?
sorry.
Sorry, can I just add something there? Quite often, a search warrant isn't the first
Chair, but yeah, sure, you go
step in
ahead.
obtaining information. Quite often a media company will have received a notice to produce or other requests from the investigating body for information. So, this idea that somehow search warrants, if they're contested, will lose the element of surprise. It's not really the first step in the investigation process by any organisation. So, and then, of course, there is the ethical consideration of making sure that you comply with the law and don't destroy information, which I think most reputable media companies comply with every day.
Sure. Can I just on that point, is there anybody else that wanted to answer Senator Scarr's question before he asks his next question?
Well, Chair and Senator, I would simply make the additional point, which also is provided for in the submissions that Mr McAvaney was speaking to. The UK has introduced contested applications with search warrant, and there's certainly no evidence that has resulted in destruction or relocation of material. So that's some of the experience of the jurisdiction that's looked at contested warrants.
Sure, and they've extended it further because, as I understand it, it includes journalistic material, but it's also personal records which a person has acquired in trade, employment, which is held in confidence, and human tissue or tissue fluid taken for the purposes of diagnosis and medical treatment. So you're advocating that we should actually re-look at our warrant system totally and completely, not just for journalists, or are you just talking about journalists?
I'm simply making the point, Chair, that one of the most common arguments that is made around providing a contested hearing process regarding warrants is the sort of the boogeyman of destruction of material, but there's certainly no evidence that's occurred in the UK context. Although I take your point, we're not exactly comparing apples with apples.
No, yeah, it's not just limited to journalists. It's a wider thing, and it's probably come out of a range of other cases. I understand it, but not to be cynical, but I will. You're advocating that Trust Us where journalists view that we wouldn't do the wrong thing or destroy information, therefore we should have this. Is that sort of sums it up?
Well, sorry.
I wouldn't put it...
I don't think we're saying Trust Us, we're journalists. We're just saying that we have a particular position in our democracy and we take that responsibility very seriously, and there are other protections available, such as people being prohibited from destroying information that are also important protections.
Sure.
And there are already consequences for destroying it.
Perhaps that was a bit flippant. It was very flippant. But I think the other thing that we're balancing in all of this, right, so if I go to another point that we're balancing, is we've heard that, because you've said, well, all the hearings should be, be in public. We should be able to shine a light on it. But sometimes members of the public are not in the frame, but they are witnesses, and they, as I take it, you're saying they should be, that should be in public too. So they worry about their reputation, they're concerned about what happens to them, how it affects them. And we've heard some evidence to that effect where they're not in the frame for charges, but they're evidence. But am I taking right that you're saying, well, that should be in public, and how they perform should be a light should be shone on that totally and completely? Is that what you're saying?
I think we'd say that there should be a presumption. The starting presumption should be that should happen in open, such as it would with criminal allegations, disciplinary hearings, these kinds of parliamentary proceedings. I mean, reputations can be affected, but they're being weighed against the confidence in the system and all those other
Sure, but
wider issues.
What's also been pointed out to us, it's not a court, right? So this is like an investigatory process, right? So it'd be like saying every interview that the Federal Police does of a person who is a material witness should be publicised and broadcast. That's sort of the equivalence that other people are saying. Is that what you're saying?
We would say, especially where there are hearings concerned, it's actually more like a court or tribunal than it is a police officer in there behind closed doors.
It's not actually. So it's an ongoing royal commission, and it isn't quite like a court or a tribunal. So, but anyway, I'm not going to argue the legal point about it, but I think that's what I'm just playing devil's advocate in this, because that's what those people are saying to us is, look, if you're a public servant who's hasn't got any not performing corrupt behaviour, you get called before a NAC equivalent, you're questioned. Do you want to add to that by having it in public so that it can be broadcast and your name can appear on the front page of a newspaper? And you might have done no wrong. You just might have cried when you got questioned. And somebody snaps the picture, puts it on the paper, and your life has changed forever. Those are the kind of things that people say to us.
Yeah,
you get what I mean?
I understand, but that's what, as I see it, what we're heading back to is that is media reporting and the risk with it, and why things should be open. That may be a byproduct, but that's not a reason to restrict or suppress.
Well, the people who are advocating for reputation are sort of saying that that person's reputation and the way in which they see themselves will be harmed forever.
But if that's the case, there is nothing restricting, other than in limited cases, the identification of people who've given statements to the police. The media could say, John Smith went to the police station today and give a witness statement. There's no restriction on that. So once we start to liken it to one thing, I think it can start to expose holes. If you look at the purpose of the legislation as a whole, it's a process that should be about shining light, transparency, etc. And that's why I think in this instance, irrespective of that sort of comparison, I don't think it withstands the argument.
Oh, I understand your position.
That's our position. Yeah.
I get your position, but you can understand we've had other positions. Ms. Lawrence?
Actually a follow through anyway of the same line of questioning from the chair. So we did hear yesterday from some of the witnesses about the merits of having a public trial, particularly the New South Wales Commissioner spoke to the benefits of showing accountability to the public of the Commission, which I was a little surprised that it was so weighted to using it as an opportunity to show the public what the Commission does without recognising that there are other ways, perhaps not as exciting or dramatic as perhaps seeing people actually in the chair. And I share your perspective that from the media you would probably love to see everything on camera for the same reason. It's much more dramatic and gives rise to lots of exciting headlines. But the reports that are published, be they in private, would surely give you enough information to do your job, to report on the facts as they're found by a commissioner into corruption. Would that not serve the same degree of transparency without the downside of the reputational harm where someone is found not to be corrupt or is perhaps just a witness in the process, or where ultimately the matter is found not pursued through a criminal prosecution? Do you not feel that there is a fair degree of balance? And taking account too that notwithstanding what the New South Wales Commissioner had said, the public hearings are only 40%, which is obviously still quite significant and not to be diminished in any way in terms of its value, but there needs to be a balance struck, do you not think? Especially because there are other avenues for you to do your job from the reports that are published?
I'll let my friends jump in first before I...
Cool. So from our perspective, it's not what we would like. It's not what journalists or media companies would like. Great copy that's at stake here. We say it's about open and transparent government, and that's best served by an open and transparent hearings process. Just to be clear...
But are the reports themselves not part of that transparency equation? It's not like you're not knowing the outcome of a private hearing.
They're not guaranteed to be public.
That's right. So there's a couple of elements to that. Just to be clear, I don't think we are saying, or any of anyone on the line is saying that we are opposed to private hearings across the board. Our view, consistent with the submissions that Right to Know Coalition has submitted, is that the current bill's view of public hearings should be flipped. So the starting point is not that hearings are in private. The starting point is that we default to a public hearing model, and that still provides a discretion. That still provides the ability in exceptional circumstances to look where appropriate for those hearings to be conducted in private. So we agree that there's a level of balance here that needs to be drawn, but we think the flip side of the current proposal finds that balance and is the most appropriate.
So it is for the balance. Thank you. And another question, perhaps targeted to the ABC. I'm interested to understand a little further about your concerns that, unlike perhaps some of the other journalists represented here today, you are directly captured by the legislation as a consequence of being a government employee. I'd be interested for you to speak a little further to your suggested amendments to address some of your concerns.
Oh, yes, thank you, Senator, for that question. So our concern arises from the definition of corrupt conduct, which includes the misuse of information or documents by public agency employees, and so that would apply to journalists. Now, in 2019, the AFP raided ABC premises as part of an investigation relating to the alleged use of leaked documents. So we're more than aware of the risk for laws like this to be used against journalists by investigating authorities, and that this can occur even when the Parliament didn't intend for the laws to be used in this way. So that is why we've submitted in our written submission that there ought to be an express carve-out for the activities of ABC journalists from the definition of corrupt conduct. On that, the Commonwealth Criminal Code contains provisions covering the use of the secret government information. It's in Division 122. That part of the code includes a defence for journalists using secret government information in the course of their work. And by the introduction of that defence, Parliament has acknowledged the importance of not stymieing legitimate journalism. I don't see that value being reflected in this bill, given the absence of the carve-out for ABC journalism from the definition of corrupt conduct.
And did you want to comment further on your proposed amendments? You particularly mentioned in your opening statement about Clause 8 there.
Yeah, so I think it would be...
Section 8, sorry.
That's right. So Section 8 could be amended. Well, there could be a subsequent section which specifically excludes the work of ABC journalists, and the wording of that exception could be similar to the wording that you find in the defence in the Criminal Code, which I can find for you.
No, that's fine, thank you.
Yeah.
I think if the wording could come to us on notice, in an answer on notice.
Thank you.
And maybe considering picking up SPS as well.
Yes, no,
we're
mentally projecting that you're also talking about SBS.
SBS takes the same position, yes.
Yeah.
Yes.
Thank you.
Thanks.
Yes.
Senator Scarr, did you have a further question?
Oh, if I could, quickly.
I have a further question too, so...
Oh, do you?
Yeah.
Well, I might have anticipated your further question.
You may. You
we're
go
on the
first
same
then.
page quite a lot,
Thank you.
Chair.
No.
Can I ask two particular points in questions in relation to your submission, because I think they're important points. As a matter of practice, this committee should be aware that the concept of who actually knows the source, the identity of the source within a news organisation can extend beyond the particular journalist and the corporate body to perhaps editors and other people within the organisation. So when we're framing the relevant protection, it needs to take into account that practical reality. If I can ask you and perhaps some of the other witnesses to give us a flavour of how this might work in practice, where a particular journalist in an organisation has a source that's confidential, who else in the organisation might be aware of it so that the ambit of the risk of disclosure can be assessed, if that makes sense.
Yeah, I can answer if needs, but Joe Pacini would be ideal to answer this, I think.
Yes, please.
Yeah, thank you for the opportunity. Yes, particularly, it depends on the media organisation and the type of story. Certainly with broadcast television, the number of people who know the identity of a potential source is greater. Normally it's the journalist, the producer, potentially certainly the editor, and potentially the story is referred up all the way to the director of news, the managing director. All of those people are bound by the same obligation to protect those confidential sources under all circumstances.
And can I add to that? Sometimes the lawyer may also know, and if there's no ability to claim legal professional privilege in response to answering a question, and this is not in our written submissions, but it did occur to me there could be exposure for lawyers. We often try to avoid knowing, but sometimes that's impossible.
Yeah, understood. And then the second point I wanted to ask is, there seems to be a distinction, I'm not sure if it's intended, between the disclosure of the source as opposed to the identity of the source, as opposed to the disclosure of information provided by the source. But if the bill enables coercive disclosure, if you like, of the information provided by the source, the disclosure of that information could necessarily result in the identity of the source being disclosed. So that needs to be considered in relation to how the provisions are framed. Is that correct? Does that make sense?
It does make sense, and we would say yes, and we would say that it may on the face of it, you might think, oh, you're not giving anything away by handing over the documents, but once you start adding bits and pieces together, you start to paint the picture of who the source may be.
So an example of that came to my mind was if a warrant's executed, a particular document is found, and it's a printout of a system, presumably an investigator could run an analytical check through a computer system and find out which people printed that document, and that might provide a list of potential identities of the source. Is that the sort of example you'd be concerned about?
I might just jump in there if that's all right. I think that is one example. Another example is that only a certain number of people might have had access to that particular material. And so that helps narrow down at least a pool of people who could have provided that material.
So I'm trying to drill down further into the reasons for the second point that you raised in relation to the issues in relation to section 31 on page 3 of your submission. Is that the issue you were concerned about in that regard? Or is it broader than that?
I think it's twofold. I think broadly, Right to Know have made the point that you may also give a promise not to disclose certain bits and pieces of information, so it can get a bit muddy where you've got a confidential source and information you've promised not to disclose as well. Say you might talk to witness X, okay, and witness X is a confidential source. They tell you 10 things and they've said, but these 3 things no one can ever know. They can never know those 3 things. So once they're disclosed, you've breached another promise. So, but I think where we've really tried to limit the main focus is on how do you best protect the source. And that can also happen with, just thinking of some legal processes I've gone through, when we look at do we need to redact before we hand something over. It can be footnotes, head notes, little numbers, little squiggles, the way it appears on the page.
So that could...
it's endless. There's endless ways to identify the source.
So those issues could be ventilated in terms of the contested application we talked about in front of a judge, where presumably if it is appropriately contested, and maybe this is an argument that it's contested by the relevant news organisation and the journalists themselves, they can actually put those arguments and the judge could then make a determination and as part of an order could actually include redaction or limitations, etc. Is that correct?
Yes, and we would say that that's an example where the journalist is going to have a better idea than anyone as to what might give away the identity of the source. So you and I might see a printout of an email, we go, well, that could be taken from anyone. The journalist could say, no, I can tell because of this, that it could only have come from 3 people in the department.
Which is why it's important that they're part of the contest as opposed to a neutral public interest advocate.
That's right.
Okay, thank you.
Senator, if I could just add to that, please. Natasha Eves from Free TV. Just in terms of the exemption from legal professional privilege in clause 114, we've also recommended that be extended to confidential information communicated to the journalists. And so that would then cover off that question of not just protecting a source or informant's name, but also protecting the information that has been provided to the journalist.
And as I think I understand that, but also you want to extend it to anybody in the organisation that has the information. Extend it to the whole organisation as well.
And as Mr McAvaney said, any documents that could show the identity of the source as well, even if it's not the source's name.
Yeah, but your primary point is it's not just the identity, it's any information that's been given to you under an obligation of confidentiality.
That's correct.
Yep. And that protection should be for everybody in the organisation.
Well, those people who know that information, I mean, whilst a small group may know, it's obviously going to be kept quite confined because we're talking about a source. But those people who need to know, as David was pointing out, particularly in broadcast, because it's a group activity, there's more than one person going to be responsible for this story. Someone's not sitting there on a typewriter sitting alone. So there will be a group of people who know, and they should all be protected.
It might be people in the IT department, someone doing the data analysis. I mean, it goes beyond. Whoever's got the confidential information should have the protection.
Correct.
Yep.
Yeah, that was a question, in fact, that I was grappling with, the extension of who knows the source at least, but how far it goes and what the definition would be of that, and so whether you extend what a journalist means, which might be a bit difficult, or how you do that. Have you got any, I don't think, and I might have missed it, have you got any ideas about how you would frame that? Sorry?
31.2,
31.2, you'd fix that.
31.2, wouldn't you?
Well, can I ask? It's not, thanks very much, but I was going to ask Mr McAvaney what he thought about that, because I don't think you say exactly how you would do that.
No, to formulate something, I'd need to consult if I can take that on notice.
Yeah,
I think off the top of my head, I think that's right. I think it would be playing around with subsection 2, and it might be less on the journalist side, more on the media, media organisation means as far as the non-disclosure goes.
So, and that, if I go then to Mr Portelli, then that doesn't really, the journalists are covered by your code of conduct, or does the code of conduct cover everybody in a media organisation out of interest?
The code of ethics applies to members of the MEAA who were media workers. So that is in general journalists, but can also apply to journalists, photographers, and other media workers covered by our rules.
So you have that broad definition, not just journalists. You have like media workers as your definition. Is that?
I mean, we for example have sub-editors, photographers, alongside journalists that are members of the union and therefore subject to the code of ethics.
I don't want to open a DMARC dispute, but anyway, I get what you're saying. It's the definition of it. I think that is so that you would capture it all, because I don't know that journalist is the capturing of what you're saying, but you also don't want to capture, well, who do you want to capture? And I think that's the thing we're grappling with, but I think the discussion about that has been very useful from point of view. We are going to have to finish, but may I take this opportunity to thank you very much for your attendance here today. It is hard with a large group, but we appreciate the way in which you have, intervened and talked about these very important issues. A number of you, I think, have been asked to provide additional information, and I understand that you may have to consult with your organisations or members of your organisation, but could you please forward anything that you've been asked to provide to us, to the Secretary within 5 days, if possible. The other thing, you will be sent a copy of the transcript of your evidence, and will have an opportunity to request corrections to transcription errors. Can I also draw to your attention that there is a PCGIS inquiry into the surveillance parts of this bill, with submissions closing on the 30th of October. If you have not already engaged in that, you might want to consider whether your organisations want to engage in that inquiry and put in a submission, because there are some issues that you have raised in your submissions that would probably be of interest to that inquiry. Again, these things are interrelated, and I just draw that to your attention. So I will now suspend proceedings till 11:15, and again, thank you.
Thank you very much for having us.
Thank you, Chair.
Thank you. Thank you.
Thanks.
Thank you.
Commonwealth Ombudsman to give evidence today. For the Hansard record, would you please state your name and the capacity in which you appear before the committee?
Ms. Carmen Maragaya, Acting Senior Assistant Ombudsman, Strategy Branch.
Ian Anderson, Commonwealth Ombudsman.
And Penny Mackay, I'm the Deputy Commonwealth Ombudsman.
Thank you. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I now invite you to make a brief opening statement before we proceed to discussion.
Thank you, Chair, and I welcome the opportunity to appear before the committee. My office was consulted on the draft legislation and provided advice to the Attorney-General's Department about the interactions between my office and the proposed National Anti-Corruption Commission. Subject to passage of the bills, my office would have power to oversee the National Anti-Corruption Commission's use of covert and intrusive powers under various legislative regimes. We would have jurisdiction to investigate administrative actions of the National Anti-Corruption Commission. We would have the discretion, but not obligation, to make referrals of corruption issues raised by public interest disclosures that we received regarding other agencies. We would have mandatory obligations to refer public interest disclosures about my office that contain serious or systemic corruption issues to the National Anti-Corruption Commission. Would have the discretion, but not obligation, to refer information concerning complaints to the National Anti-Corruption Commission which raise a serious or systemic corruption issue, and in the case of potential corruption allegations or complaints about the National Anti-Corruption Commission, we could refer those to the Inspector of the National Anti-Corruption Commission, and we would be subject to the information gathering powers of the National Anti-Corruption Commissioner. I'm happy to take questions.
Thank you. Mr Zapier, do you want to start?
Thank you, Chair, and thank you for appearing before the committee. I'm going to ask two questions. The first relates to clauses 30 and 31 in your submission, and they're fairly lengthy, so I'm not going to read them out in full, but if I can take you to them, and then ask the simple question of, can you elaborate on both of those clauses for the benefit of the committee? And secondly, the Ombudsman's Office has, over the years, also had oversight over the Ackley Commission. Based on that oversight, do you support the legislation that is currently before us with respect to the National Anti-Corruption Commission?
Thank you. So in relation to clauses 30 and 31 of our submission, yes, it's an interesting concept. What is an administrative practice, matter of administrative practice in relation to a hearing? My jurisdiction generally under the Ombudsman Act is to investigate matters of administration, and the experience of my office is that it's a very broad notion. What is a matter of administration or relating to a matter of administration? It's not something that you could exhaustively define, for example. But it could be that there are matters that are administrative practices as opposed to matters of the legal conduct of a hearing. So, for example, the ways in which the National Anti-Corruption Commissioner engages with witnesses or prospective witnesses or legal representatives, people of that nature, prior to or following a hearing, those might constitute administrative practices. But I think that the general intention with respect to the oversight role of my office for administrative practices is it's about a belt and braces approach. It's ensuring that complaints can go to the inspector. The inspector will be focusing on particularly significant allegations, but there might be less significant complaints, and it's important that all complaints can in fact be considered and investigated by some form of an oversight body. So it's really just, as I say, belts and braces, that if there are things that arise that don't constitute matters that the inspector wants to look at, then my office has jurisdiction to look at them. So that's a brief statement about clause 30, paragraph 30. Paragraph 31, protection for journalists' informants. So the journalist information warrant provision that exists already in electronic surveillance legislation can be difficult to interpret for agencies who are considering whether they need to seek a journalist information warrant. So they have to consider, for example, is the person working in a professional capacity as a journalist, or are they the employer of someone working in a professional capacity as a journalist? And in our observation, that can be challenging for agencies. We normally suggest that an agency that is considering whether they need to seek a journalist information warrant from an external issuing authority should first seek legal advice to clarify for them whether it's more likely than not that they should go down that path as a matter of caution. And as we say in our submission, we think that it would be useful if the Attorney General's Department developed some further guidance on this question for the benefit of agencies who are considering exercising these coercive and intrusive powers.
Yep.
Sorry, you asked also about our views from ACLI. Yes, so we...
Based on your experience as an agency providing oversight over that piece of legislation, which I understand that the NAC legislation draws upon as well.
It does, and yes, we support these bills that are before the Parliament, and we support the notion of providing oversight in these ways for a body such as the NAC.
Thank you.
Can I just ask a follow-up? Do you anticipate that there would be some sort of MOU between yourselves and the inspector to try and figure out what that delineation is beforehand? Is that how you would see it operate?
Absolutely, Chair. We envisage an MOU with the inspector, and we also envisage an MOU with the NAC itself, because both of those bodies, the NAC and the inspector, could be considering looking at matters that we would still have the ability to look at ourselves. And the most important thing is that everything can be considered and looked at, that nothing falls between the cracks. So, for example, I mentioned in my opening statement that we have obligations to refer we have discretions but not obligations to refer corruption issues raised in public interest disclosures about other agencies. So if we decide to refer one of those to the NAC, we would like to be then able to engage with the NAC to have some clarity as, are they going to do something about it? And if not, then we will consider doing something about it. So it's that clarity as, is someone going to consider it? And similarly with the inspector, the inspector can receive complaints. The inspector can also refer complaints or other matters to myself and under the proposed legislation. And so that clarity both ways. Who's actually going to look at this issue, complaint, allegation, and ensuring that someone does in fact considering it, and there's no situation where an agency is saying, oh, we thought you were going to look at that.
So we've certainly been interrogating, I guess, how some of the state systems operate, in particular how the inspectors operate, and there's a wide range of models, and without simplifying too much, but I will simplify. In a couple of locations, particularly in Victoria, all of those functions are concentrated in the inspector. Do you see there'd be any trouble by sort of dividing those functions? So we've sort of been grappling with who should do what and how that's going to work.
So I guess I'm agnostic as to how it's done. I think the important outcome is that there be clarity as to which body has the jurisdiction, but also if that body is not going to look at something, should there be the ability to refer it to someone else. So if there was a change to how the functions of the inspector are described in the legislation, for example, providing the inspector retains the ability to refer matters to me that they're not going to deal with, then I think that would be an adequate way of going forward. But I anticipate that a body of this nature will attract a range of different complaints, and many of those complaints might be matters that, on the face of it, are not matters that the inspector would necessarily prioritise, but it's still important to look at those matters.
Because the inspector's jurisdiction is quite narrow in this act, but
yes.
I think Mr O'Brien was it?
Just to follow up, and just for my own clarification, so in relation to what we were just talking about with the previous witnesses, warrants under the Crimes Act, safe to search, your job is to audit things like that.
Yes, we have a particular role in oversighting a range of coercive, intrusive, covert powers exercised by a range of law enforcement bodies, and that would include the NAC.
So in terms of the NAC, it extends well outside the actual Act and its powers contained within the Act. And from law enforcement works within the law, but quite often they'll have directions coming down from above saying a certain practice is not within the spirit of the law and we want you to stop doing that. Is that your role?
So our role is to monitor compliance with the safeguards set out and processes set out in legislation. So where Parliament has bestowed powers, Parliament has generally said there needs to be compliant, it needs to be exercised in a particular way. So we're checking to say, were those powers exercised in the appropriate way? So if approval is sought from an internal or external issuing authority, was the right information put forward? Were the right tests considered? With relation to information that's then obtained, is it handled in accordance with the legislation? Is it deleted? Is it stored? Is it used? All of those things. And so it is a bit of an auditing function, really. And then we publish most of our reports. We either report to the Attorney-General or other ministers, or in other cases we publish our reports directly.
So in terms of where there is a bit of a grey area in terms of an investigation by the NAC, you don't make recommendations that aren't definite?
So I should say, for a start, when we're doing our auditing of those coercive, intrusive powers, we're typically doing it after the event to avoid any question of intruding into an operation that's currently underway. So typically we will be looking retrospectively at powers that have been exercised and how those powers were exercised. But yes, we don't make suggestions as to how they should be exercised looking prospectively, other than that they should be exercised in accordance with the legislation. And we will make recommendations, suggestions and comments as to how the agency needs to either train its staff differently, or change its templates for recording particular types of decisions, or change its processes for recording information about how information has been stored or deleted. So we make those kind of comments, recommendations, suggestions, but not about a particular matter.
Okay, thanks, Chair.
Again, because we had evidence from, I think, the Victorian Inspectorate yesterday that what they do is get it within short time while it's active. I think 5 days before they're going to do it, they have some sort of oversight and they check it at that time. But yours is like, as you say, after the fact.
Yes.
Thank you. I think Dr. Haynes had a clarifying question, then I'll go to Senator Scarr.
Yes, thank you, Mr. Anderson. I just wanted to take you back to your comment about an MOU, and I wondered about the efficacy of an MOU compared with actually writing clarification into the legislation.
So even with clarification in the legislation, if the legislation was to be changed, we would still seek to have some kind of a protocol MOU or something like that, because we want to ensure that we're on the same page, understanding what those provisions actually mean and how they're likely to be exercised. We still think it's useful for oversight bodies to have a strong working relationship.
So you think an MOU is sufficient to do that? We don't need to consider amending the legislation for clarification?
I don't think it's necessary to amend it just on that question of clarifying whether there's an overlap between our functions and the functions of the inspector. I mean, it might be that Parliament wants to amend it for other reasons, and other witnesses have given evidence on those matters. But no, I don't think it's necessary just to deal with the question of potential overlap. The main thing is, as I think I've said already, the important thing is an overlap is much healthier than having a gap.
Indeed. That's just what I needed to know. Thank you very much.
Senator Starr.
Thank you, Chair. And Mr Anderson, if I can first congratulate you on your appointment. I had previous experience seeing you at Estimates, and you always greatly impressed that committee. So it's a very well-deserved appointment. I wish you all the best in the role. Now I'll ask you some hard questions. The MOU you talk about, is that a public document? Would that be a public document?
I don't necessarily see why it couldn't be a public document. I mean, that would be a discussion that we would have with both the commissioners of the NAC and with the inspector. But I generally lean in favour of publication, transparency.
Okay, excellent. And some of my questions have already been canvassed in terms of potential overlap between the role of your agency and the inspectorate. And as I understand your evidence, the bigger issue would be if there were a gap and no one covered the oversight role with respect to a particular
That's
gap,
correct.
as opposed to there being some overlap. And if there is overlap, then that's something that could be dealt with in terms of the MOU. The Chair referred to the evidence we received from the Victorian Inspectorate, and every single exercise of coercive powers by IBAC in Victoria has to be reported to the Victorian Inspectorate. Is it right, am I reading your submission correctly, that your agency, the Ombudsman, there's only specific categories of coercive powers that are referred to the Ombudsman? So, for example, if a witness were compelled to attend a private hearing and make themselves subject to answering questions, that wouldn't you wouldn't be alerted to that as a matter of course under this bill. Is that correct?
I believe that's correct, and it's certainly the case that, yes, the requirements are relatively limited for matters being referred directly to us as opposed to being matters that we will have oversight of.
So it's mainly in relation to matters as a matter of course that would be referred to you for examination and reporting, subsequently issues around surveillance, telecommunications interception, those sorts of powers, as opposed to coercive powers that might be exercised by the NAC to require an individual to do something as a witness or someone who's the subject of inquiry. Is that correct?
Yes, our oversight isn't generally looking at whether it was necessarily an appropriate use of the power or appropriately seeking the use of the power. It's more about, has the process laid down by Parliament been complied with, as opposed to the individual purpose of that exercise.
Okay, so I'm going to ask you a question which might tend to go into territory which is, I'll leave it to you as to how you want to answer it, but the thoughts occurred to me, I can see the merit in terms of the Victorian model where every exercise of a coercive power has to be reported to the Inspectorate, and then we heard from the Inspectorate and they say they look at particular high-risk areas of exercise of coercive powers and they'll give priority to doing a deep dive, if you like, in terms of that particular exercise, and there is a real-time element to it so that they can take action quickly if required. It seems to me that if that model were adopted, there'd be a situation where the Inspectorate was referred all exercise of coercive powers. The Ombudsman would have referred to the office some exercise of coercive powers. Is there any issue with that, any practical issue, or that's simply something that could be dealt with in terms of the MOU? I want to avoid unnecessary duplication, which could lead to inefficiency, but in practice, Is that something we should be concerned about, or does it come back to your proposition, it's better to have overlap than a gap?
So I don't think that creates a problem, Senator. I think that if Parliament wants to have that kind of real-time monitoring, which is not what my office does in this space, then it could give it to the inspector. I don't see that our retrospective monitoring is going to create a problematic overlap there, and in any event it would be something that we'd be talking about with the inspector as to making sure that we both understand how we're exercising our respective powers.
Okay, excellent. Thank you. Thanks, Chair.
Thank you. Senator Shoebridge?
Thanks, Chair. There have been a series of reports by your office about repeated, I might even suggest systemic breaches of the checks and balances that agencies are meant to have for telecommunications intercepts. And the AFP has been repeatedly found to be in breach. Given that, do you think we should be considering some more overt protections if we're creating yet another agency to access telecommunications data in particular?
In one sense, Senator, I mean, if you or Parliament is concerned about the way in which agencies are exercising your powers, bestowing the power on one more agency doesn't change that underlying question as to are you satisfied that agencies are properly complying with the legislation. So I don't think that it raises a different question to give it those powers to the NAC. But in terms of what we see when we carry out our oversight, it's important to make the distinction between recommendations that we make, suggestions that we make, and comments or best practice suggestions that we make, because these might be terms of art for us, and so it's important just to expand upon that. We make a recommendation where we're particularly concerned that there's a serious or systemic issue. So that might be an agency that has failed over several cycles of inspection to actually engage with comments that we've made to improve their practices. For the most part, though, I should say, we make recommendations relatively rarely. We make a lot of suggestions and comments, which are really about things that we think agencies can improve upon, but which we don't think are of the same level of significance. And so when you look at our reports, you might be struck by there's a lot of comments in there about failures to comply, and that's correct, but we don't see that most of those failures are of the same level of significance. But nonetheless, it's not our duty to actually, I guess, make decisions as to whether agencies should have those powers or not. That's for Parliament, and that's why we carry out this role and we put all that information forward so that Parliament can be properly informed as to how agencies are engaging with those safeguards laid down by Parliament. For the most part, we do see continuing maturing of compliance with the requirements in the various pieces of legislation.
Well, I mean, your predecessor, just as recently as last year, said law enforcement agencies rely on a wide range of covert and intrusive tools to do their work, but to maintain public trust, these tools need to be properly deployed in accordance with the legislation which governs their use. Indeed, the Parliament currently has before it proposed legislation which will further extend the powers of law enforcement agencies in relation to being able to detect and disrupt criminal activity. A critical factor in effective oversight of such powers is that law enforcement agencies need to report to the Ombudsman about how the powers are being used. I assume, do you still endorse that position?
Absolutely. I don't see anything inconsistent there between what I've said and what my predecessor said.
But that came about in the context of repeated breaches of by the AFP of its obligations to report and its obligations to hold data, not just one-off breaches, but repeated breaches. And since then, I think there's been yet another report by your agency showing yet more breaches by the AFP.
And again, most of those breaches, in our view, were matters that warranted us making suggestions or comments about how the AFP could improve its processes rather than recommendations, which, as I said, we reserve for the most significant or systemic types of issues. So yes, I think the AFP in one of those recent reports had 22 suggestions, for example. And that's a lot of suggestions, and that reflects a lot of things we found where the AFP had not fully complied, but we didn't think that most of those, well, we didn't think that those 22 matters were of such a severity or significance. So it's important to say, yes, we want agencies to fully comply with all the safeguards, but I mean, that question for Parliament, I suggest, is weighing up if an agency fails to comply in one instance, is that of such significance that it should be prevented from using the powers or should have more onerous constraints put on it? That's a balancing exercise for Parliament.
It wouldn't be a fair review of your organisation's oversight to suggest it's one instance. Pretty much every report shows multiple instances of failure by the AFP.
Oh,
We're not talking about one instance, and you say, you know, if Parliament is concerned, you're the oversight body, you keep writing reports pointing out multiple breaches. Are you concerned?
I am concerned, Senator. I would like to aspire to a world where, in fact, Parliament's strictures are all complied with. I've met with the AFP Commission. I've raised these questions. I've written to at least one other Commissioner of Police where there were some things that particularly concern me in that agency. So yes, I am concerned, but I think it's also important to have balance in considering these, because it might seem startling that agencies are not complying, but then when we look at it, we say some of those failures to comply are of a much more minor nature. So yes, I would like to see agencies fully complying.
To get a better handle on it, would you be in a position to provide that correspondence to the committee so we can see the nature of the concerns you've raised, particularly with the AFP?
I'll take that on note. I mean, I've met with the Commissioner face-to-face of the AFP. The correspondence to another Commissioner, I'll take on notice as to whether I can provide that.
Thanks, Chair.
Thank you.
I should say, Senator, just if I may, just add to that, that Commissioner has since responded and advised that all those matters that I was concerned about have now been addressed.
Well, if we can get the whole picture, that would be useful.
Yeah, that would be useful. Ms Lawrence?
Just continuing on the same line, I'm interested in where you have found where an agency hasn't been fair or shown integrity as per your governing remit. What are the consequences beyond just pointing that out, and are there any remedies for the persons that have been impacted?
So as a general rule, we don't have powers to compel people to, or agencies at least, to compel agencies to act on our recommendations. We seek to engage with agencies to persuade them, and also through publication of reports and things like that to provide, I guess, transparency and assurance as to how agencies are behaving. So as a general rule, no, we don't have the power to compel agencies to provide a remedy or redress, but we certainly will recommend that in appropriate cases.
So do you feel that that needs to be an aspect that should be included in the bill where there has been an issue identified and a person's been wronged through the use of coercive powers or other powers that are available under the bill? Do you feel that that should be made explicit in the Act, that where the Ombudsman or other oversight agencies have identified an issue and an individual has been severely wronged, that there should be a remedy available to them? Is there an example of that anywhere in any other agency, to your knowledge?
None that come immediately to mind, and I'm not sure that we have seen actually practical examples of people being seriously wronged, as opposed to examples where agencies had the ability to obtain information coercively and may have, in handling that information, not fully complied with the safeguards. But they certainly had a case that would satisfy the legislation. So what we're seeing is not necessarily that there have been particularly significant consequences for individuals, as opposed to we're seeing that an agency has not fully complied with the legislation.
Right. But is that a consequence of your own process being limited to looking at the how and the mechanics of the conduct, as opposed to the decision to actually use those powers?
I think that's a fair observation, yes. That we're generally looking, again, at the procedural compliance with the procedural requirements, rather than at all the details of the particular exercise of the power, so not strictly all the details of the case. And remedies in that situation are more likely to be with courts who are looking at prosecutions and things like that.
So would that then, just going to the Chair's opening questions around the role of the inspectorate in other jurisdictions, would you see that being a power that's best vested with, like, an inspectorate that can look at the decision to use those coercive powers and other really powerful powers available under the bill before they're made, or do you feel that that's not necessarily an element that needs to be included?
If it was to be put in, I mean, it would sit neatly with what Senator Scarr was commenting on before, that question of having a real-time oversight by the inspector, for example. Does the inspector then have the ability to do something if the inspector sees something in that real-time oversight? So that would sit together well if you're minded to recommend that, Parliament was minded to seek that.
Okay, lovely. And I just was also interested in my other one question. In your other comments in your submission, I was wondering if you wouldn't mind expanding further on your concerns around clause 31(1)(a) 1 of the bill in relation to protection for journalists' informants. I was just wondering if you wouldn't mind expanding on that a bit further for us, please.
So I've already made some comments on that particular issue earlier in this hearing, and just to repeat those comments, the test for an agency to consider whether to seek a journalist information warrant is, are they seeking a warrant that's going to touch upon information of a person who is acting in a professional capacity as a journalist or an employer of such a person. And our observation is that in practice agencies can find that quite difficult, because when you have people able to engage with different forms of media and social media, is a blogger engaging in a professional capacity as a journalist, for example, and even down to practical questions such as even if someone is a journalist, and absolutely a journalist, but are they acting in their professional capacity when they're doing something, or are they simply a journalist who is doing something outside their professional capacity? So these are difficult questions in practice. So for that reason, we suggest that agencies get legal advice before they decide whether or not they need to seek a journalist information warrant, to delve into that more deeply. And as we say in that paragraph of our submission, we think that it would be useful for the Attorney General's Department to further develop some guidance for agencies about how to approach the test for a journalist information warrant.
Should the inquiry not be whether or not, should the inquiry be whether or not it's journalistic activity that's the subject of the warrant, rather than the status of a person being a journalist or not? That would seem to cut through a lot of that nonsense.
Well, I mean, it's both, in that it's a journalist acting, a person acting in a professional capacity as a journalist or an employer. So the status of the person in terms of whether they're a journalist or not is not the full answer.
Journalistic activity that should be the focus, isn't it?
Yes, well, I mean, whatever the test would be, whether it's journalistic activity or professional capacity as, I mean, that's a matter for Parliament, I guess. But the current test can be difficult for agencies to apply.
Thank you.
Thank you. Senator Scarr?
Just one follow-up question which I omitted from asking. The question was raised by a number of the commissioners, or at least one of the commissioners of anti-corruption agency, that there needs to be oversight of the inspector or inspectorate. What oversight does the Ombudsman have of the inspectorate under the existing law and under the bill? And in order to address that question, could those powers be expanded? So the particular concern was the inspector or inspectorate has a right to investigate serious or systemic corruption, potential corruption within the corruption agency itself. The inspector doesn't have an inspectorate sitting over the inspectorate, so who should best perform that function? Is that something the Ombudsman would perform in any event under its powers, or should there be some, and I don't want you to go necessarily into policy areas, but should there be some sort of additional provision in terms of the role of the Ombudsman?
So, Senator, we have this wide-ranging ability generally to look at actions of an administrative nature involving departments or prescribed authorities. So I'm fairly confident that we can look at some things that the inspector does, but not everything the inspector does.
Right.
And so it is that question of how many layers of oversight do you have? And I think that parliamentary oversight of the inspector will be an important safeguard in itself. But we will have ability to look at a range of things that the inspector does as well. It's, I guess, a question for Parliament as to whether that's sufficient or not. We have own motion powers, we can look at complaints, we can investigate a range of different things.
Okay. Okay. All right. Thank you.
Anyone else?
When you say the administrative actions of the inspector, does that exclude some of the inspector's functions from your oversight?
I have to say I haven't looked at that question in detail before coming this morning, but the inspector also has a range of immunities under the proposed legislation as well, and so there might be an intersection between some of those immunities for some of the things that the inspector does and our ability to look at their activities.
Would you be able to have a look at that and maybe respond on notice about what elements of the inspector's activities you think you could oversight?
I'll just check whether any of my colleagues have a greater ability to answer. I will take it on notice.
Yeah.
From our perspective, because the issue's been raised with us, and whilst the hope, the anticipation is, in the vast majority of cases, there'll be a good working relationship between the Inspectorate and the NAC. In a situation where it becomes a little bit fraught, perhaps, one can envisage the benefit of your office, perhaps, having a role.
It's the bee watcher difficulty that we're confronting.
Correct.
Yep.
Who watches the watcher of the watchman?
Yes, and for what it's worth, I mean, I'm the inspector of the ACT Integrity Commission.
Oh, well, there you go.
And from that capacity, I can say that one of the major sources of complaints I receive about the ACT Integrity Commission is its decision not to investigate certain matters. It may well be that in the ACT people are unhappy that there's no one oversighting my oversight of the ACT Integrity Commission.
And so we go on.
Yes.
Yeah. But I'm sorry, that is actually a really pertinent bit of experience, because if that's already happening in the ACT experience, your experience in that and reflections on that would actually be very useful for us dealing with this bee watcher problem.
We've received very few complaints, I should say, about the ACT Integrity Commission, but mostly the ones we have received have been about where the Integrity Commission has not decided that a matter was sufficiently significant to investigate.
So you have the experience to make you perfect for this expanded role we're proposing for you.
I won't comment on that, Senator.
Yeah, wherever you see ACT Integrity Commission, read NAC.
So I also, I think, asked the Attorney General's Department to look at a particular report in Victoria that the inspector published 2 weeks ago, and it was about the administration of the IBAC Commissioner in a jurisdiction that we don't have, but it was really about administration and about the failure to do things, right? And I asked them, did they think, who would do, was that covered by the Act? Would you have a look at that too and see if you think that would, so it's called Emma's complaint, I think. It was published by the Victorian Inspector 2 weeks ago, maybe. But it really goes to an administration matter of the IBAC and not dealing with a complaint and where they sent the complaint, which and the inspector thought it had not been handled well. But I can't see in this, would it come under administration, or is it where it would go? And your view on if it would be in your bailiwick would be interesting.
We'll have a look at that, Chair, and take that on notice.
Thank you.
One point that isn't clear from my reading of your submission is, if a whistleblower from the private sector goes to the NAC, are you satisfied that there's adequate protections? There seem to be protections extended to public officials under the PID Act, but have you satisfied yourself about whether or not a whistleblower from the private sector is adequately protected in this bill?
I might take that one on notice, Senator.
All right. And then that would be, I appreciate that. And then in terms of your role, and I think you're the agency that primarily oversees the PID Act.
Along with the Inspector General of Intelligence and Security.
Do you see any gaps in the extension of the PID Act in this bill, or any obvious or any improvements that you could recommend?
It's certainly easy to see some potential improvements with the PID legislation, and I note that the Attorney General has said that the government's going to act on the recommendations of the Moss Review, which it was 2016, but I think those recommendations have stood the test of time, and I think other witnesses have also said that in the 6 years between that review and now, there's bound to be other matters that could also be looked at. So I think that it's certainly a very good idea to look at the PID legislation, and I think the sorts of recommendations that Philip Moss made 6 years ago are still matters that would significantly improve the regime.
All right, but obviously, one of the key issues that's been repeatedly raised by by evidence in this inquiry is the need for perhaps a whistleblower commission. Do you have a view about whether or not A, that would be an advance, and B, if it should be part of the NAC or a standalone body?
So I think that certainly the question of support for whistleblowers, practice has shown that whistleblowers don't feel supported and would probably benefit from greater support. There's a question as to who might be able to provide that, and that's partly about is there a body or other bodies that can provide support, or alternatively it's about enabling disclosures to share information with or access different types of people who can provide them with support. So it's partly about the information security provisions, and it's partly about whether there's should be a new type of body to support them. I think that also the practical experience is that whistleblowers typically feel that they're concerned about reprisal, but the mechanisms for dealing with reprisal have very rarely, in fact, been invoked.
Well, it's no wonder they feel anxious about reprisals. There's at least 2 that I'm aware of that are currently facing criminal prosecutions for whistleblowing. So I ask again, do you have a view about whether or not a whistleblower commission, in one form or another, either expanding on an existing role, expanding on the NAC, or creating a new body, should be something that's considered if we're creating a body like the NAC and encouraging more whistleblowers to come forward?
I'm noting that the government have said that they're going to look at this, and that their intention, the Attorney General I think has said that his intention is that there will be amendments to the PID regime in place before the NAC actually commences. It might be that there is going to be already that exercise to look at and go through Parliament with amendments to the PID regime. As I've said, I think that there are certain amendments that could be made to make that regime more effective, easier for people to understand, easier for agencies to comply with. And the question of a whistleblower commission, I mean, you could certainly give a function to the NAC, or you could give a function to us. That's one of the recommendations of Philip Moss, that you could expand some of our oversight role with respect to PID, or you could have a completely new body. So I think those are all things that should be considered in this at this period, but whether you do it as part of these bills or under the anticipated amendments to the PID regime.
But either way, there needs to be some kind of agency with the resources and capacity to provide the protection that whistleblowers have been repeatedly saying they don't have at the moment, the support and the protection.
Well, I think consideration needs to be given to who can provide that support. And as I said, it might be you could, in fact, change some of the restrictions on the ability of disclosures to engage with other people about the disclosure, so that they would then be able to obtain support from existing bodies. So there is that question, would you do it by enabling them to more readily talk to other people and seek support, or would you do it by creating a new body? So those are 2 options.
Well, I'm confused about what support you provide whistleblowers at the moment, though. If they come to you, what support are you able to provide? Can you provide any financial support? Can you provide legal support? What support are you able to provide whistleblowers right now?
No, we can't provide those forms of support, but we do have whistleblowers who say, well, I would like to, in fact, talk to a range of people about this scenario, but I feel I'm constrained by the secrecy provisions in the PID regime. So if those secrecy provisions were tweaked, it might be that they'd be more readily able to talk to people who they would like to talk to get some of those forms of support. But no, we can't provide financial support or that. Our role is to ensure that complaints are being properly looked at, whether they're looked at by us or by the agencies.
Okay, so Mr O'Brien, you had
I've just got one quick question, and I don't want to open up a whole can of worms on this, but I'm going to take. You said they're also the inspector for the integrity.
The ACT.
Commissioner. So I'm led to believe that the ACT has exoneration protocols in place. Is that right?
If I can take that on notice, I will.
Okay, thanks.
Mr Zapier, did you have a further question?
Look, no, I'm fine. I'm conscious of the time, so.
Everybody else has got them, Mr Zapier, so if you want to go, you've waited patiently, it's fine. We're waiting on somebody to come online and they're not online yet. That might be our...
That's awkward for the Ombudsman.
Mr Anderson, I was just going to ask this question. With respect to the PID Act, is it your view that the Act itself is deficient, or is it the case that the administration of the Act sometimes fails us? You know, in other words, it's not always the legislation that's the problem, but rather those who administer it.
So I'd say both, Mr. Zappia. I mean, I think that the Act itself is quite prescriptive. It's not necessarily easy to work your way through, and a consequence of that is that agencies sometimes have difficulty administering it. Now, agencies sometimes have difficulty administering things for other reasons, but in our observation, the fact that the Act is difficult to apply and to work your way through complicates the challenge for agencies, but it also complicates the challenge for potential disclosures, working out, can I actually make a disclosure? Have I met these tests? What protection will I get? So I think that the Act, improving the Act would really help both agencies and potential disclosures.
And you're satisfied with the Attorney-General's statement that that Act will be reviewed as part of this process at some stage?
Well, it's not really a matter for me to be satisfied on. I think I've noted that he has publicly said that that's his intention, and so we'll look with interest to engaging with that process.
Thank you.
Dr. Haynes?
Mr. Anderson, thank you. Could you just answer for me, is it the role of the Ombudsman to investigate if there have been reprisals against whistleblowers?
So we have looked at whether... We've looked at how agencies have actually dealt with reprisal risk assessments, for example, and we recently published a report where we looked at 4 agencies who've had quite a lot of experience with public interest disclosures, and one of the things that we looked at was how well they do that reprisal risk assessment process. And so we made some comments in there about how agencies can improve how they do that and make sure that risk assessments are actually then implemented properly. But we don't necessarily look at whether there has been a reprisal or not. I mean, the matter needs to, I guess, come to our attention in some form, whether it's referred to us by a whistleblower who is complaining about what they perceive to be the inadequacy of an investigation and consequences. Otherwise, so, I mean, you could say this is a deficiency in the current legislation, that otherwise the onus is on the whistleblower to actually take that action if they perceive that there's been a reprisal and they've been damaged in some way. So there's a civil process, and there's also that includes the Fair Work Commission process. Yes, there is an offence, and there is an ability to have a prosecution, but that's a challenge in terms of will the criminal standard actually be met through an investigation of whether or not there's been a reprisal?
Am I right in saying there's no one then who actually does an investigation and assists the whistleblower should reprisals be made against them? It's up to the whistleblower to try and navigate their way through the legal system at that point.
Well, I'd rephrase that slightly to say that we can look at matters if they come to our attention, and then of course the AFP and the DPP can look at them if they think that there's a particularly significant matter that would warrant consideration of whether there's been a criminal offence. So there are agencies that can look at it, but it's a very difficult test to make.
And in your experience, do they ever do that? Have you got any examples where they have actually, the DPP has followed that through?
I'm not aware of any that they have. And generally, I mean, as a general comment, whistleblowers almost invariably feel that they have been the subject of reprisal action, but those matters have been very rarely upheld when it's been investigated.
Investigated by who, though?
So
I think we're going to have to stop. We've got our next person's on, but
when you say investigated, but investigated by who? It's no one's job.
So,
but this picks up the PID protections. This expressly picks up the PID protections, and which include penalties for reprisals. And that might make us feel good, but if nobody is actually going to punish somebody for reprisals, it's hollow words on paper. And my understanding of your evidence is there's nobody whose job it is to punish agencies when they take reprisal action against whistleblowers. That's what I'm led to believe from the evidence we've just heard.
The punishment can take a range of forms. There's civil proceedings which would be brought by the whistleblower. There's criminal proceedings that the AFP would brief the DPP on if they felt that the standard had been met in terms for a criminal offence. If we see that there's been poor administration by an agency in looking at a matter or how they've acted, then we can make comments about that, but we don't have the power to actually compel them to do something.
Okay, I'm going to close the session now, and thank you for your attendance here today. You have been asked to provide some additional information. Would you please forward it to the Secretary within 5 days from today? You will be sent a copy of the transcript of your evidence and will have the opportunity to request corrections to transcription errors. So again, thank you very much for your appearance today. Can I now welcome Professor Colleen Lewis, who is via teleconference.
Sorry, look, I'm via the phone because I can't get into the WebEx link.
Okay, I think we can certainly hear you loud and clear, so that is fine. So for the Hansard record, would you just please state your full name and the capacity in which you appear before the committee?
Yes, it's Dr. Colleen Lewis. I'm an honorary professor at the Australian Studies Institute at ANU. And then other thing I should say at the outset, I should mention in the full interest of disclosure that I'm actually an associate of the Centre for Public Sector Integrity, but I'm not, or public integrity, I'm not appearing in that capacity today. I'm appearing today based on my research into anti-corruption bodies that stretch back some 20 plus years.
Thank you. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. Given the giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament, the evidence given today will be recorded by Hansard and attracts parliamentary privilege. I now invite you to make a brief opening statement before we proceed to discussion.
Thank you, Senator. Look, there's a few points I want to raise quickly. One is exceptional circumstances. Learned and very highly respected experts in the anti-corruption field have expressed before the committee their deep concern about the inclusion of this barrier to the holding of public hearings. So too has the IBAC Commissioner, and Mr Redlich has personal experience with this and has been asking for years for this barrier to be lifted. And so have other commissioners of anti-corruption bodies don't support the idea of exceptional circumstances. So, I also don't support it because I just think it's a barrier that is unnecessary, and I understand that the decision on whether to hold a public hearing is at the discretion of the Commissioner of the NAC. That decision should not be constrained by exceptional circumstances. And it would be really interesting to know when that particular barrier was imposed and perhaps a little more information about why it was imposed. I understand that we hear time and time again that it's to protect the reputation from, being sullied by public hearings. And we've also been told by members of Parliament at the state and even at the federal level that anti-corruption commissions have ruined reputations. The kangaroo courts, etc., etc. But look, even for the claims about the ruining of the reputation to have any legitimacy, I would like to suggest that research needs to be done that goes back to the 80s when these bodies were first instituted. And we need a list of the number of public hearings held by anti-corruption commissions across Australia and how many have resulted in a person's reputation and career opportunities suffering as a result. And I really do think that this is the least the Australian community is entitled to receive, so that Australians can decide the wisdom or otherwise of the exceptional circumstances barrier. And also, I'd just like to say that public hearings are a preventive tool, and they actually bring forward new evidence, and they also act as a restraint on people who may be contemplating or involved in very minor misconduct from actually escalating that conduct when they see the consequences of going down the corruption path at a public hearing. There are other comments I'd like to make in other areas, but that's up to the committee to decide. But I just would like to add, if I may, that I did explain that I have other commitments that I would have to leave the meeting at 12:30.
Yeah,
and I was told that would be all right.
Yeah, no, we understand that.
Thank you.
I might go to some questions, Dr. Haynes.
Thank you very much for your testimony this morning, Professor Lewis. You're a noted professor of integrity. Can you elaborate on what this committee should be looking for when we're considering now this National Anti-Corruption Commission legislation?
Well, I would like to say that I think the bill goes, a long way to the kind of model that we really do need at the federal level. I think I have some concerns about third parties. I think the behaviour of third parties should be included because if their behaviour involves serious dishonesty when trying unsuccessfully to influence the policy advice of public servants or when trying unsuccessfully to influence the decision-making powers of ministers, it's still corrupt conduct. And I think also if we look at the moment, not at the moment, since the 80s, we've been increasingly contracting out work. That's what governments have been doing, and they're entering more and more into public-private partnerships. So I believe it's very important that, trying to dishonestly influence public policy is something that should be within the remit of the National Anti-Crime Commission. Another thing I would like to suggest, which most people may not agree with me, but that the committee gives really serious consideration to broadening the definition of corrupt conduct to include those grey areas and serious misconduct. And I'm making this point because serious corruption is rarely the starting point for corrupt conduct. People don't join an organisation and immediately start looking for the corruption opportunities that are available from having joined this public sector organisation. The path to serious corruption is overwhelmingly a journey down the slippery slope. And I think it would be advantageous for Australians that the NACC was able to intervene at a point before anybody had reached the depths of that slippery slope.
Thank you.
I'd like to congratulate the government on the prevention and education functions in the NACC. I think it's an enormous strength of the bill because a successful prosecution, as everyone knows, is an after the event approach, whereas prevention and education functions can actually stop corruption occurring. But just a word of caution in terms of the budget here. Based on the experience of the Criminal Justice Commission and the Crime and Misconduct Commission in Queensland, I think it would be a good idea to quarantine a part of the NACC's budget to this important preventive and education function. And I say this to avoid the situation that did happen there for a while. It was remedied, but still had consequences, whereby the work of the investigative division in the NACC would start to eat into the funds available to the prevention function. I'm sorry, I seem to be talking a lot here.
Actually, could I stop you there, Professor? I've got that clearly, that you're very, very interested in the prevention and education element of the National Anti-Corruption Commission. I am too, actually, around pro-integrity measures. I think it's incredibly important. Can I take you to this issue of the budget and ask your opinion around how we protect the budget of a National Anti-Corruption Commission such as this, and your views on the protection of that budget into the future? And I'm particularly interested in the oversight committee that is drafted and how that we can ensure protection of the budget.
The budget has to be arrived at by some form of independent person or small committee or something like that. It shouldn't be within the control of the government, because the history of anti-corruption commissions show very clearly that it's all very well to give them all the powers in the world that they need. You can have the most powerful anti-corruption body there is in the world, and if you don't give them the resources, in effect, they can't operationalise those powers. And that is a tactic that has been used throughout the history of anti-corruption bodies. So I would be most certainly making sure that the budget of the anti-corruption body is not a direct result of an executive decision.
Thank you, Professor.
Really am very strong on that. I think one way of helping in that regard is to not have the chair of the oversight or the monitoring review committee be a member of the government, because I think then it's too close to the executive. There's a casting vote being proposed. I personally, if I had the magic wand and could make the decision, I would have the chairing of that parliamentary committee given to an independent member of the committee. I think that would help to show that the government is really serious about its commitment to do politics differently.
Sure. Okay, can I ask, thanks very much, Professor. Senator...
chopping you off.
Well, I'm not... I'm conscious the Professor has told us that she has to leave at 12:20, and I would like to ask Senator...
12:30,
sorry, 12:30. It's 12:20 currently, or 12:19, and I wanted to ask Senator Sterle, who has some questions, to have that opportunity. Senator Sterle.
Thank you, Chair. Professor Lewis, I'm just interested if you had the opportunity to compare the bills that are in front of this committee with the previous government's, what was it called, Commonwealth Integrity Commission.
Yes, I've certainly had that opportunity, and I've been before committees to do with that disgraceful model on 4 occasions, so I'm very familiar.
Don't hold back, Professor.
No, I won't. I'm being very careful about how I express my opinions on that particular model.
Too generous, I
think.
Look,
that's fine. Then can I ask then, do you believe that the current proposal better serves the public interest?
Well, you've just set up a very low bar for that test.
Sorry, it better serves, definitely, but can it do better? Yes, it can. And I think for the points that I've raised there, I think will give a lot more credibility to the NACC and those people who are going to be involved in oversighting it. And if the new anti-corruption body is going to gain the trust of Australians, it really must be shown to be rigorous and set up in a way where politics cannot interfere in any way with the work of that anti-corruption body.
Thanks, Professor. And Chair, I am very mindful that there are other senators and limited time.
Thank you.
Other members, sorry, I keep saying that. Other members, sorry.
Others?
I'm not used to this joint committee work.
Mr. Anybody?
Oh, you want to go?
Mr. Zapier?
Thank you, Professor, for your presentation thus far. Given your lengthy experience in integrity commissions, are you familiar with the Australian Commission for Law Enforcement Integrity? And if so, is there any aspect of that commission's work that you believe could have been improved? Are there any matters that arise from the work of that committee that you have concerns about?
I did a lot of research in that area in its early days, so I think even if you look at the second reading speech when it was introduced, you will see that there was absolutely no real desire to establish it, and as a result, it was, grossly underfunded is the kindest thing that I can say about the amount of resources given to a body that was asked to go around and cover the whole of Australia, and it had, I think, at one stage when I was down there trying to understand it better, 4 or 5 investigative staff, and that was supposed to cover the whole of Australia. And the other thing that's somewhat of a disappointment is that there were virtually no public hearings held at all by the body. So it seemed to have developed a culture that was resistant to that. So I think the problem with that body goes back to the very way in which it was set up and the totally inadequate budget that it was given, and the way then, after over a period of years, little bits were added onto it as it went. So, that would be a model I would be resisting as much as possible.
Chair, I have a question that arises from that.
Yep, and then Mr. Wallahan after that. Yep. Senator Shoebridge?
Doctor, on the budget, the government has announced an initial 4-year budget for the NAC. But going forward, do you have a view about how the Parliament could best entrench an independent budget process for the NAC? Or are you satisfied with the current process, which is the NAC budget just goes through the usual budgetary processes and there's retrospective oversight by the proposed committee?
Retrospective is sort of after the event, isn't it? It would be very nice if there was a person, and maybe there's already an independent officer of the Parliament that could assist in this, but I think that the budget should be out of the hands of the executive. I know it's been set up initially for the 4 years, but as I said before, powers without resources means no powers. And we need this body. We've needed it for a long time. A lot of people are placing a lot of trust in the Parliament, and I've emphasised the word Parliament here to ensure that it can operate independently from politics. And the history of anti-corruption bodies show that the most undermining of anti-corruption bodies in Australia can be traced back to members of Parliament or political parties. And I've written on this. I wrote an opinion piece on this, which I'm happy to forward to the committee if they would find it useful.
Well, I think that would be useful, but also, there is a live example in Australia of a jurisdiction which has the proactive consideration of Integrity Commission's budgets, and that's the ACT. Are you familiar with that example, and would you recommend that as a model for NAC?
Yes, I think it is. It is a model that that could be well looked at and by this committee and recommendations made. I see there's an enormous responsibility on this committee to put the public interest before personal and party interests, and because their recommendations surely will influence government and the Parliament.
Thank you. Mr Wallhan?
Thank you, Chair. Thank you, Professor Lewis, for appearing. My first question is a follow-up on funding. Have you looked at how the federal courts are funded and done a comparison as to what a model might look like for funding here?
No, I've never done that, so I can't give any knowledge on it, but I'll put that in my list of things I would like to have a look at, though. Thank you.
But would you agree that the funding for federal courts is just as, if not more, crucial, given the constitutional requirement of separation of powers, and that therefore it would be an instructive model to at least consider?
Look, not having an in-depth knowledge, I have to be a bit cautious, but I agree with you entirely about the importance of separation of powers in our court system, and if it works, it would certainly be something that may well be worth looking at, but I can't comment on something that I really haven't done my research on, and I'm always very cautious about just giving an opinion that's not backed by research, so yeah.
That's okay. You noted that you are an associate of the Centre for Public Integrity.
Yes.
Did you have input into their submission before this committee?
Yes, I did. I looked at the draft and made my comments on that draft as other members. I'm on the committee that looks at anti-corruption issues more broadly. So yes, I certainly did.
No, I won't go there. I'm done. Thank you, Chair.
Thanks.
Okay.
Thank you very much for your attendance here today. I think you were asked for some additional information. I think that was the case. So if you could forward it to the Secretary within 5 days from today, we would appreciate that. You will be sent a copy of the transcript of your evidence, and we'll have an opportunity to request corrections to transcription errors. So again, thank you very much, Professor, for talking to us today.
It's Mark. Can I just make a very, very quick comment, and I mean very quick? I'd just like to refer the committee to the Criminal Justice Commission original model, where they have 4 part-time commissioners. And I think it's something that's worth looking at, because one of the part-time commissioners has to be a practicing legal practitioner with a demonstrated ability in civil liberty matters, and the remaining 3 must all demonstrate an interest and ability in community affairs. I think that's important, but just very quickly, the rationale behind that recommendation by Tony Fitzgerald was that an organisation that is focused on misbehaviour and can be quite a closed organisation is actually given the opportunity at the senior levels to have input from the outside, if you like, for other people of other opinions. So I think that's something that I've been going on about for years, but I'm not giving up on it. But anyhow, thank you for allowing me to make that additional comment.
Thank you very much, Professor. We appreciate your time.
Thank you very much to the committee.
Can I now welcome Mr. Chris Merritt from the Rule of Law Institute to give evidence today. For the Hansard record, would you please state your full name and the capacity in which you appear before the committee, Mr. Merritt?
My full name's Chris Merritt. I'm appearing as Vice President of the Rule of Law Institute of Australia.
Thank you. Although the committee does not require you to give evidence under oath, I should advise you that the hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. We do have your submission, but I now invite you to make a brief opening statement before we proceed to discussion.
Thank you. Thank you for this opportunity. And at the outset, I'd like to apologise for the absence of the founder of the Rule of Law Institute, Robin Speed, the co-author of our submission. Mr. Speed's in hospital having cancer treatment and apologises for his inability to be present. That said, the Rule of Law Institute supports the crackdown on wrong. However, we believe the bill that is the subject of the committee's deliberation can be improved. The changes we propose are outlined in our submission, and we're encouraged to see that some of the most important issues we have identified have also been highlighted by the Law Council of Australia and the Queensland Law Society. All are concerned about problems with the definition of corrupt conduct and the abrogation of legal professional privilege. But I should first explain a little about my organisation. The Rule of Law Institute is an independent, voluntary, non-partisan, not-for-profit organisation formed in 2009 to promote and uphold the rule of law in Australia. Its work is supported by more than 1,300 members. The objectives of the Institute are to promote good governance based on the principles of the rule of law. Those principles underpin the Constitution. For current purposes, they include equal treatment before the law, the presumption of innocence, the prohibition on retrospective punishments, and the right to be told in advance what conduct is considered to be unlawful. They require clear laws that apply prospectively. The purpose is to inform the community about its legal rights so people know what they can and cannot do. Together, these ideas are of fundamental importance. They form the basis of what is known in this country and in comparable jurisdictions as freedom under the law. These principles are intended to protect human rights by impeding arbitrary rule and regulating the power of the state. Aspects of the NAC bill undermine these principles by imposing vague standards with retrospective effect. The Institute has made submissions and attended parliamentary hearings in the past to ensure the principles of the rule of law are taken into account when assessing the role of the New South Wales Independent Commission Against Corruption. The Institute works with its sister organisation, the Rule of Law Education Centre, to educate and inform Australians about Magna Carta and the rule of law principles it represents. Our chief concerns with the NAC bill relate to the definition of corrupt conduct and the fact that the Commissioner would be empowered to do with criminal and non-criminal conduct. This is at odds with the idea that criminal conduct should be dealt with by courts, not administrative bodies. The NAC is not a court. It will be an agency of government. So in order to ensure it does not become a parallel system of justice, the bill should make it clear that the Commission is not entitled to run public hearings and produce reports on matters that could involve criminal wrongdoing, even if those reports are confined to findings of fact. Because it will not be bound by the rules of evidence, there is a risk that some findings of fact would be in conflict with subsequent findings by courts, which would undermine public confidence in both institutions. The bill should make it clear that criminal conduct falls under the exclusive jurisdiction of the justice system, the Director of Public Prosecutions and the courts, and that the interests of justice take priority over generating publicity at public hearings and producing findings of fact. This change is necessary in order to give effect to the idea that it's more important to convict wrongdoers in a timely manner than it is to generate publicity about them. The bill should require the Commissioner to suspend investigations and hand all files on particular matters to the Director of Public Prosecutions as soon as it becomes apparent that the evidence shows there is a possibility a crime has been committed. This could take place during a preliminary investigation or during a formal investigation. In order to give effect to the primacy of the justice system, matters of potential criminal conduct should never proceed to a public hearing and should be referred to the proper authorities at the earliest possible opportunity. This would eliminate the risk that justice could be delayed, possibly for years, while the NAC ran public hearings after running investigations that would not meet the standards required by the courts. This requires Parliament to decide whether it wishes to give priority to publicity and headlines, or whether it wishes to bring wrongdoers to trial at the earliest possible opportunity. As the bill currently stands, the interests of justice are subservient to publicity. In our view, that is fundamentally wrong. It would delay Judgment Day for criminals. In order to rectify that problem, Parliament would need to make an honest decision about what it is seeking to achieve by establishing this commission. If the purpose is to run show trials at the cost of delaying Judgment Day for criminals, the NAC bill, as it currently stands, will be a resounding success. But if the goal is to punish the worst aspects of public sector corruption, the bill needs to recognise that there is only one way of achieving that goal, and that is through the justice system. That means accepting that criminal misconduct should be referred to the DPP as early as possible. It also means accepting that those accused of the worst kind of corruption are entitled to rights that are available in the courts, but not at the NAC. Criminal justice makes provision for a full appeal, but the bill does not. Criminal justice respects the privilege against self-incrimination. The NAC bill does not. Criminal justice respects legal professional privilege, and again, the NAC bill does not. On the definition of corruption, we believe the could test in proposed section 8(1) subsection A is speculative, would encourage a lack of rigour and should be removed. It extends the definition to include conduct that could not adversely affect honesty or impartiality of a public official, but could have that effect. The could test invites the NAC to speculate about something that, by definition, did not happen, but could have happened. It is difficult to see what purpose this serves when section 8, subsection 10, deals with attempts and conspiracies to engage in corrupt conduct. The could test would seem to make it possible for corruption findings to be made in circumstances where there is insufficient evidence to show that corrupt conduct actually took place. There is insufficient evidence to show that a conspiracy or an attempt to engage in conduct took place. But despite all that, the Commissioner still believes corrupt conduct could take place at some time in the future. Our other major concern is with proposed section 8(1) subsection E, which is the last provision in the definition. It extends the definition to corruption of any other kind, which opens the door to matters that have not been considered by Parliament. If the goal is to give the NAC flexibility to deal with unforeseen circumstances, this should be done in a way that does not have the effect of transferring power from the legislature to the executive branch of government. To do so would be to repeat one of the worst mistakes that took place during the pandemic, when the Biosecurity Act, a law approved by Parliament, handed almost unlimited power to the Minister for Health. This is not a form of lawmaking that deserves to be replicated. The problem of unforeseen circumstance could be addressed by giving the NAC permission to make submissions to the Parliamentary Oversight Committee seeking urgent amendments to the Act. Another option would be to give the NAC authority to make draft regulations and have them laid before Parliament as disallowable instruments. The advantage of these methods is that Parliament, not the NAC, would determine the scope of the law. If subsection 8.1e, or if section 8.1e remains unchanged, it would be up to the NAC rather than the Parliament to decide what conduct beyond that listed in section 8 is to be considered corrupt. This would leave the NAC and the community uncertain about the standard of conduct that could be declared corrupt. It would open the door to the permanent imposition of retrospective standards. And I'll leave it there.
Thank you very much, Mr. Merritt. Senator Scarr?
Thank you, Chair, and thank you for appearing today, Mr. Merritt. I'd like to ask you a question around the issue of exoneration policies, and in particular, I note that section 158 of the draft bill, or the bill, provides, and I'll quote 158 subsection 1, the Commissioner may advise a person or a representative nominated by the person of the outcome of an investigation of a corruption issue raised by the person in a referral. So under section 158.1, that deals with the person who's raised a referral. They may be advised of the outcome. And then in section 159.1, in relation to a person who's the subject of an investigation, the provision provides the Commissioner must advise a person of the outcome of a corruption investigation if the Commissioner investigates a corruption issue concerning the conduct of the person and the Commissioner makes a finding that the person has engaged in corrupt conduct. But then in subsection 2 it says the Commissioner may advise a person of the outcome of a corruption investigation if the Commissioner investigates a corruption issue concerning the conduct of the person and the Commissioner forms an opinion or makes a finding about the corruption issue other than a finding that the person has engaged in corrupt conduct. So there seems to be a distinction drawn on the one hand between advising, it's mandatory to advise a person if they have been found by the Commissioner to have engaged in corrupt conduct, but it's not mandatory for the Commissioner to advise a person if the Commissioner forms an opinion or makes a finding about the corruption issue, which might include that they have not engaged in corrupt conduct. I would have thought that it's important for people the subject of these sorts of investigations to be advised if it's been found that they haven't engaged in corrupt conduct, so they've got some certainty with respect to the process. So I'm interested in your thoughts with respect to that matter.
Yes, look, I think I agree. I think it's just fundamental to fairness that if somebody is subjected to an inquiry with potentially catastrophic consequences, they should be advised one way or the other. In fact, I'd go beyond that. If there's a finding of corrupt conduct that subsequently turns out to be at odds or questionable in light of subsequent proceedings in a court, I'd say that the bill should make provision for a complete apology by the NAC to the person concerned.
Okay, so you're taking it a step further and saying in the circumstances where a matter's been investigated by the agency, by the Commission, and that it's subsequently considered by a court and the finding hasn't been substantiated, then there needs to be some sort of redress system to expunge the record, as it were, of any adverse finding?
Yes, look, this is what I'm thinking of is there needs to be a mechanism to address the problem that arose in New South Wales, where Murray Keir, the former State Emergency Services Commissioner, was acquitted of criminal proceedings by a court that arose directly out of a corruption inquiry where he was declared to be corrupt. Yet the Commission in New South Wales, ICAC, pursued him by writing a letter to his local newspaper after his acquittal, pointing out that he was still a corrupt person. The problem is that the New South Wales Commission appears to see itself as a parallel system that doesn't pay enough respect to the findings of a court. And it's my view and the view of the Institute that the findings of a court should prevail over any determinations by the Commission.
Okay, thank you. Thank you, Chair.
Thank you. Ms Lawrence?
Thank you, and thank you for taking time to put such a comprehensive submission together and with such a strong focus on ensuring natural justice. I was curious as to how you landed at 2 years for where you're recommending that an investigation should automatically lapse and not continue unless a court orders. How did you arrive at 2 years?
2 years seems to be a reasonable time to allow the Commission to do its work.
In whose opinion, though? Is that your opinion, or is that based on your research of average time it takes to do complex investigations, or how did you arrive at that?
It's an arbitrary figure, but it would balance off the fact that the person under investigation would effectively have their life on hold. So the shorter the period, the better, but it needs to be balanced against giving the Commission an opportunity to do its work.
So I don't think anyone would dispute the need for timeliness, but do you not feel that for the Commissioner's independence, he needs to, or she needs to take account of the complexity of an investigation, the length of time that needs to cover off? Yesterday we heard some, in a single case it can be 60,000 digital documents. Like the time it is needed to, analyse that information is obviously vast. Do you not feel that that should be a decision taken by the Commissioner as to how long an investigation time is required?
No, I don't. I think to do so would be to hand effectively arbitrary power to the Commissioner, and I think the interests of the Commission are one thing, but they need to be balanced against the interests of the people who come before the Commission. This needs to be a fair process that gives priority to both rather than an unbalanced system that could put people on tenterhooks, could put their careers, their businesses on hold for years. So there needs to be a limit.
Okay, sure, and I certainly agree timeliness. I'm not sure that I'd be brave enough to fix it at 2 years, knowing some of the cases that have been before different commissions, but definitely take your view on board. Thank you. With respect to a person being investigated, being limited to speak to family members, on the face of it, I completely understand, and it seems like a very harsh restraint, but we've certainly seen, from cases in Western Australia that corruption often then involves family members because they're often the beneficiary of the outcome of some of that corruption. So do you understand that there may be cases where it's important that the investigating officers put those limitations so they can fully investigate the case and ensure that they understand the full scope of corruption at hand?
Look, I understand the interests of the Commission in wanting as few restrictions on its powers and procedures as possible. But once again, if this Commission is to gain widespread community respect and be seen to be operating fairly, I think the least you can expect is that the people under investigation should be able to discuss matters with their families. I mean, people under investigation for homicide and terrorist offences are able to discuss matters, whereas there are restrictions in this.
Well, terrorism, they're not permitted to either, through the investigation phase. Okay, on number point 11, you talk about retrospectivity. I couldn't see any application operation of retrospectivity in the bill. I know they can look at past acts, but there's not. It's not retrospective, so they would look at the acts at the time they were committed. Do you feel the bill is reading differently?
But with respect, acts that take place in the past when they were perfectly lawful should not retrospectively be rendered corrupt by an act of Parliament subsequently enacted. That's the nature of a
does not do that. Mr. Merritt, that's not helpful, because you know for a fact that nothing in this Act makes anything, makes any change to the laws on corruption, doesn't make any corruption unlawful. You know that's not true, and it's unhelpful.
Thank you.
Senator Shoebridge, with respect, you're about to change a law and render something corrupt.
No. Well, with respect, that's not what the bill does, and it's unhelpful for you to suggest it does when you must know from a plain reading of it, it doesn't.
Well, I think we disagree on that point.
Ms Lawrence, anything further?
Thank you.
Thank you. Mr Zapier?
Mr Merritt, thank you for your presentation thus far. Based on what you've told the committee this afternoon, do I take it that you believe that each of the integrity commissions across Australia, that is the state and territory commissions that have already existed for some years, are also deficient in terms of the way they operate?
In what regard? If you have a specific point.
You've raised certain concerns which I would expect apply to the functions of each of the other commissions as well. So I'm just assuming that you would have similar concerns to what you have raised with this committee about the integrity commissions of the states and territory.
If you're talking about the ability of commissions to examine or to define under the umbrella term corruption, conduct that is non-criminal as well as conduct that is criminal.
Well, that's one of the matters, yes.
Yes.
And so my question would be, are there any of the jurisdictions who have now had integrity commissions in place, is there any one of those that you would suggest is a better model that we could look at than what we currently have before us?
Well, the best I can see so far is the reformed South Australian Commission, which, on my reading of it, doesn't conflict with the principles of the rule of law. I should make the point also that if the committee and Parliament needs to be very clear about what they seek to achieve. Remember what happened in New South Wales with the horrendous delays that afflicted the eventual criminal trial of Eddie Obeid and Ian McDonald. When they were convicted last year, it was for events that took place 14 years in the past. It took the Direct Public Prosecution 6 years to finalise an indictment after ICAC had completed its part of that process. That can't be allowed to be repeated nationally.
But remember, without the New South Wales ICAC, they never would have been brought to justice. They never would have been held to account for gross breaches of their obligations as ministers and members of Parliament. So are you suggesting they should have got off scot-free?
Again, Senator Shoebridge, that's a very long bow.
It's the truth. It's the plain,
you should have a look
plain, bald truth, and I can't understand how you don't accept it.
Look, if you have a look at what ICAC found against the Obeids and McDonalds, it found one set of wrongdoing which does not accord with the findings of the Supreme Court of New South Wales. They were much more limited findings of corruption. They were convicted, but ICAC's findings of fact in the Obeid and McDonald matter do not accord with what was found by the Supreme Court.
Well, you're the first witness to try and suggest that the Obeids and McDonalds were treated harshly in the New South Wales ICAC.
Okay,
Most of the rest of the country is glad that
With
happened.
respect, I did not say that.
Okay, can we go to Mr Wallahan?
Thank you, Chair. Thank you, Mr Merritt. I'd like to directly ask you about the issue of retrospectivity in Section 8. My colleague Senator Shoebridge is partially correct. It appears on my reading of the bill that it doesn't impose retrospective criminal laws. I don't think anyone could argue that. But if you go to section 8 and subsection 4, it says conduct may be corrupt conduct even though it occurred before the commencement of this section. And then in the explanatory memorandum on page 33, again, it notes that there's no retrospective criminal laws, but then it says that the definition under subsection 8 could enable a non-criminal application of corrupt conduct retrospectively. So I'd like to now take you to 8.1e. You referenced the Biosecurity Act, and that has, as many Australians discovered, extraordinary powers, extraordinary plenary powers. But those powers, correct me if I'm wrong, are activated in a present emergency. Is that right?
As I understand it, yes.
So they're not applied retrospectively in the Biosecurity Act?
Correct.
Whereas here in section 8.1e, and again, I'm not talking about criminal conduct, it talks about, and the explanatory memorandum refers to, emerging definitions of corruption. And when the Attorney General's Department were asked if there were any hypotheticals they could give us that didn't fit within 1A to D but would require 1E, they couldn't name any hypotheticals. So on the issue of retrospectivity, not including criminal conduct, is this even more concerning that an emerging definition of non-criminal corrupt conduct is applied retrospectively? Is that more concerning than even the situation we had in the Biosecurity Act?
Yes, look, I tend to agree. I think the limits, there needs to be clear limits on the definition of corruption. E goes far too far. If Parliament has difficulty in forming a concise description of what corruption is, it should not give unlimited power to the Commission to make its own rules. Effectively, that's what it would do. It would also have the effect, if you think about it, of making it almost impossible or very difficult to challenge the Commission's exercise of its jurisdiction. It would always be within its jurisdiction because it could always be able to say this is another form of corruption that was unforeseen.
And the principle we're looking at here, other than common understandings of fairness, is a principle of our democracy, which is the separation of powers between the Parliament and the Executive. That's a key principle we're looking at here, aren't we?
Exactly. It shouldn't be up to a branch of the Executive to effectively make laws permanently. If there's an unforeseen consequence or an unforeseen issue that arises, it's perfectly up to the Parliament or the Oversight Committee to monitor that and recommend an urgent amendment. That would be the best way of dealing with it, so that Parliament is always in control of the Commission's jurisdiction. The Commission would operate independently, but the law that it applies would be determined by Parliament, as it should be.
And there's another way, there's another branch of government other than the Executive, the Parliament, it's the judiciary. So if 8.1e is not there, if there are evolving definitions of corruption, again, that's well within the purview of the judiciary in a case that's brought before it to expand upon the definition of corruption, isn't it? They don't need 8.1e.
Yes, look, I tend to agree with that, but I prefer, in the best possible world, it would be preferable for Parliament to define quite specifically those acts which could amount to corruption. I think it's, if the problem here is to avoid uncertainty and provide clear standards of conduct for public officials, it's best done by statute rather than waiting for particular cases to be taken to court.
Thank you, Mr Mayor. I just have one more question on section 73, private and public hearings. The section 73, subsection 3, has some discretionary criteria that the Commissioner may turn his or her mind to. I have put to other witnesses, should an additional criteria be there that the Commissioner should turn his or her mind to the effect of the prejudice on a future fair trial?
Definitely. I mean, it should be obvious. It should be absolutely obvious. What's important here is the goal of this exercise to limit it to the operations of the Commission, or should it be viewed in a broader context of what do you do with people who appear to have been at odds with the criminal law? And to preserve a fair trial should take absolute priority.
And the argument has been put in response to that, well, that's what Section 73(4) does, which is a catch-all. It says it does not limit the matters. But would you agree that the principle of not prejudicing a fair trial is so fundamental that it should be made express in Section 73, subsection 3?
Look, I agree entirely, and Senator Shoebridge might be interested in having a look at the delays caused to the Obeid and McDonald case because of the prejudicial pre-trial publicity. I think it was 6 months that Justice Elizabeth Fullerton delayed their trial because of prejudicial publicity, which took place years. I think it was 6 years after ICAC finished its work.
No further questions. Thank you, Mr. Merritt. Thank you, Chair.
Thank you for your attendance here today, Mr. Merritt. I don't think you have been, but if you were asked to provide any additional information, would you please forward it to the Secretary within 5 days from today? You will be sent a copy of the transcript of your evidence and will have an opportunity to request corrections to transcription errors. Again, thank you for being available at such short notice. We appreciate your submission and your attendance. Proceedings are now suspended until 2 p.m.
Cool. Hey, Luke, am I
Evidence given today will be recorded by Hansard and it attracts parliamentary privilege. I now invite you to make a brief opening statement, if you would like to, before we proceed to discussion.
I think what the committee's got to understand is that the powers which acts such as bill under consideration are extraordinary. Unfortunately, they've become necessary because of the way in which the modern world operates. But against that background, bearing in mind that the powers are really an incredible intrusion into the lives of ordinary people and not so ordinary people, they should be exercised very carefully. And also, powers in the hearing should be protected so as to not to unfairly damage the reputations of people who appear before them.
Yep. So I think... okay, thank you. Mr. Malik, so I think we will go to Mr. Wallahan.
Thank you, Chair. Thank you, Mr. Malik. The National Anti-Corruption Commission regime is unique in that it will also cover the Australian Defence Force and some 90,000 members, full-time and reserve. It's in that capacity and your experience that I'd like to ask you some questions. Could you please outline your experience in defence and Veterans Affairs issues and institutions?
Okay, I joined the Defence Forces, the Citizens Military Force in 1966 until the end of 2018. I spent 7 years in the ranks before taking commission. My last 12 years in the Defence Force were the rank of Major General. I commanded all levels and sections of brigade, and my second last post
We might have lost you there, Mr. Melick. It's I'm not sure how the NBN is in Tasmania, but
Leaving the Defence Force, I was recruited, I think is the best way to express it, into the National Presidency of the Return and Services League of Australia, which I commenced in May of 2019. I was just re-elected for further 3 years. I've also appeared for victims and police officers, first responders, and about 50 Supreme Court actions for dealing with mental health issues, among other things. And in 1996 to 2000, I was a statutory member of the National Crime Authority, where I exercised coercive powers similar to envisaged under the Act. Approximately 500 occasions. In other words, I conducted about 500 hearings in that 4-year period. I also exercised the powers to compel production of documents and other records, etc. I was a part-time member of the New South Wales Casino Control Authority, and once again I exercised similar powers in that capacity. And now, I have similar powers.
thank you, Mr. Melick. The ongoing Royal Commission into Veteran Suicide, have you had any involvement in that, or have you been keeping a close eye on submissions and findings made in that Royal Commission?
I've been following it fairly closely. I've been present in a few hearings. I haven't given evidence. And the RSL made a fairly significant submission to the Royal Commission, and several of our state presidents have given evidence before.
Thank you, Mr. Melick. I'm going to read 2 lines from a submission that this committee considered and heard evidence from. It's from the Australian Psychological Society, and we heard from Dr. Davis McCabe, who's the president-elect. And the issue, there was 2 issues that Dr. Davis McCabe addressed. And the first one was about the importance of reputation and status on mental health. And I'll just read 2 lines and get your opinion. Dr. Davis McCabe said, individuals who experience public, as opposed to private, humiliation and shame can suffer major depressions, suicide ideation, extreme rage, severe anxiety, and even psychosis. And she makes the point that they become estranged from their group and have a loss of identity and place in the world. And makes the point in this sentence, for many people, their professional persona is core to their self-identity, and any damage or threat to it is therefore amplified. On the issue of identity, was that something that has come out in the Royal Commission into Veteran Suicide for current defence members and veterans?
It has, to a certain extent, but I agree with the comments made by the psychologist, and I can go back to my experience representing police officers who were questioned in the Police Royal Commission in New South Wales. That was an open commission, and several officers had not only had their reputation shredded, and then later been shown to be, the evidence was shown to be perjured, and there was no basis for it, but it also had incredibly deleterious effects on their mental health. And the result of that, we were successful in several actions because their mental health deteriorated to such extent they were no longer employable. I've also noted that when witnesses are preparing to give evidence in court proceedings, in open court proceedings, I've had people taken to hospital on suicide watch just in preparing to give evidence. So most people who are not used to court proceedings find it incredibly intimidating and stressful to be required to give evidence, especially if it's going to be in public.
And this is a hypothetical, so I'm asking you to speculate here, but your former role as a Major General, if there was a public hearing of a current serving defence soldier or officer or airman or sailor, is it probable that they would have to be stood down or separated from their current duties, whatever they may be?
It depends. If you're talking about an allegation of impropriety made against them, I think there's a strong chance that the Defence Force is fairly concerned about reputational damage. If a person is questioned in private, there's no chance of a reputational damage attracted to the Defence Force, and therefore the individual may be allowed to continue to serve until there's an adverse finding made against him. But if a public allegation is made against him, it depends on the individual commander or personal circumstances. There's always a strong chance, though. Put it this way: there's more chance they'd be stood down if their reputation was going to be raised in a public rather than a private hearing.
Thank you, Mr. Melick, and thank you, Chair.
Thank you. Mr. Zapier?
Thank you, Chair. Mr. Melick, given your extensive experience in public affairs, how would you describe, or what would you describe as the key ingredients of a successful anti-corruption commission?
I think the strongest part of any such commission is its educative function. Part of the problem we note in anti-corruption matters is that many people don't even know what the rules are. They don't properly understand conflicts of interest. In Tasmania, our two areas of major concern which cause us the majority of our work are local councils and tertiary institutions. We concentrate heavily on education, and I think the yardstick of a successful anti-corruption commission would be reducing its workload. It's important that you have such an organisation. People are aware actions they take that can usually escape detection can be brought to attention and examined. But I think you've also got to have a balance. If you're dealing with an anti-corruption commission, bearing in mind in Tasmania we have a misconduct commission as much as anything else. If we have corruption, we refer it to the police. You're going to have a national anti-corruption commission which is going to exercise coercive powers. You then have to be very careful about the balance of at what stage you refer the matter to the Australian Federal Police, whether you continue. As members of the committee should be aware, or are probably aware of X7, cases like X7 and Lee, you cannot compel somebody to provide information or give evidence and then provide that evidence to investigative authorities for the purpose of a criminal investigation. So the balance becomes fairly difficult, and I think it's very important that an anti-corruption commission recognises the fact there's got to be a crossover line, or there should be a crossover line where they should go no further and the matter goes to the police.
Mr. Melick, thank you for that, and I have to say some of your key words dropped out as you were presenting, but hopefully we might be able to get them in the transcript. My other question is this: do you conduct public hearings, and if so, under what circumstances?
No, we've got one part heard hearing at the moment, and that's in private. We've not needed to conduct hearings because we've received all the information we need by the exercise of our coercive powers. Documents will gain access to computer records and people interviewing. We have the way our act is balanced is that the hearings will be in public unless certain considerations are met. I think that balance is the wrong way round. I think the default position should be a private hearing. But I can't assist because, as I said, we haven't found the need to conduct hearings in the past, or integrity tribunal is what we call it down here. I do note that every hearing I had in the National Crime Authority and at the Casino Control Authority were held in private.
Thank you, Mr. Melick.
Thank you. Dr. Haynes?
Thank you for your appearance here today, Mr. Melick. Firstly, I just want to reassure you that the default position under this proposed legislation is private hearings, unless in the public interest and exceptional circumstances to hold them in public. Before I get to that, though, could you explain to me what the test is in the Tasmanian Integrity Commission to actually have a public hearing if you determined that it was necessary to do so?
No, it's the other way around. The hearing's in public unless we determine it appropriate to have it in private. And the sort of matters of consideration are the effect on a person's reputation, the question of disclosure of information which may prejudice other investigations. And I really should have all the things in front of me, but I can't remember the other conditions. But the one that always plays heavily on my mind whenever I make a decision about a hearing is reputational damage. Because a number of times we've commenced a hearing, the National Crime Authority, we were dealing with fairly nasty people, Russian and Italian mafias, triads, Yakuza, the whole lot, as well as the biking gangs. And a number of times we'd commence a hearing thinking somebody was guilty of sin, and by the time we got halfway through the hearing, we realised we'd got the wrong bloke. If that had been in public, the damage would have been incredible.
Can I just clarify, Mr. Melick, and I apologise because the connection's not so good. Are you talking at the moment about the Tasmanian Integrity Commission, or are you talking about something else?
I was talking about the National Crime Authority.
Thank you. Yeah. Okay. Sorry, I wasn't clear about that. Could
What
you?
would happen? Sorry.
Could you give me your assessment of the test for public hearings under this legislation that's before us, the National Anti-Corruption Commission legislation?
I think it's about right. I know some of my fellow commissioners around Australia think it's too strong, and that many of the acts have protection by a series of considerations before you make a hearing public. But my view is that hearings should be held in private unless there are exceptional circumstances. The trouble is when you commence an investigation, you don't know where it's going, and when you ask a question of a witness, you don't know what answers you're going to get. And a witness in a public hearing can come out with something completely unexpected, which would be incredibly unfair and prejudicial to the person being involved.
Mr. Melick, can I get your view on the public interest test and exceptional circumstances safeguards that are written in the draft legislation? Do you think those safeguards are strong enough? And could you comment on whether the phrase that leads into this should be may or must take into consideration these issues?
As far as I'm concerned, that it should be must, it should be mandatory that those issues are considered.
So,
and I thought the balance otherwise, sorry.
No, keep going.
And I thought the balance was otherwise appropriate.
Could you just give me your view then, if it was must consider those 5 key areas, in addition to the subsequent clause which said, and any other issues that the Commissioner may have regard to, what exactly the exceptional circumstances might be that would be in addition to those?
Now, I've just walked in, I haven't got the legislation in front of me because I can't put it on the screen and talk to you at the same time. But
I could read them to you if you wish. Would that be helpful?
Look, I think I can answer the question. If you don't think I've answered the question, we can go back.
Sure.
In my view, the rare times which you should have a public hearing, one, when there's no chance of criminal proceedings flowing therefrom. Mm-hmm. Secondly, when you consider that the public hearing may bring to light evidence that people aren't aware of and cause other people to come forward. And thirdly, and probably the most important, when it's for the purpose of educating educating the community.
Mm. So that's when you think they should be in public, is that right?
Yes.
Yes. So when
when they could be.
Yes. So when, in regard to this legislation, Section 73(3), in deciding whether to hold a hearing or part of a hearing in public, the Commissioner may have regard to the following, and I'll read them just because I'm conscious you haven't got it in front of you. The extent to which the corruption issue could involve corrupt conduct that is serious or systemic. B, whether certain evidence is of a confidential nature or relates to the commission or to the alleged or suspected commission of an offence. Any unfair prejudice to a person's reputation, privacy, safety or well-being that would be likely to be caused if the hearing or part of the hearing were to be held in public. D, whether a person giving evidence has a particular vulnerability, including that they're under the direct instruction or control of another person in a relative position of power. E, the benefits of exposing corrupt conduct to the public and making the public aware of corrupt conduct. And then 4, in addition to that, subsection 3 does not limit the matters to which the Commissioner may have regard. So I'm just wanting to check with you if you think those are reasonable and what exceptional circumstances may be there in addition to those things.
Well, I've covered all of those except the vulnerability question in my previous answer. So, in addition, I can't think of that. May arise, and that's the sort of matter the Commission would have to consider if it arose.
I'd be happy to take it on notice if you wish. What other exceptional circumstances if you wanted to put forward a view.
All right.
Mr. Berlick, I also want to ask you about the funding for such a body. And can I just ask you, in terms of the Tasmanian body, how is the budget determined for the Tasmanian body?
It's determined. We make submissions through the Attorney-General as to what we need, and it goes in the usual budget round. So it's determined by the government, not by Parliament.
Okay. And what role does the Oversight Committee in the Tasmanian Parliament play in determining that budget and making a recommendation to government?
I don't know if they have input or not. We have a joint standing committee which we report to and we speak to several times a year. Mm-hmm. They would no doubt make recommendations, because what we do is when we put in a budget submission, we provide them with a copy so they're aware of it. In fairness, we've been fairly well treated by the government, by both governments. Governments are both this way. So we had a rocky period where a government took a lot of money off us, and Commissioner, and our culture changed to a certain extent, and things have been a lot better since then.
Could I just ask?
Sorry.
Just before you go there, could you suggest to us what remedies may be available to protect funding to a commission? Mindful that you've mentioned a change of culture, and this is something we need to think about in terms of future-proofing this National Anti-Corruption Commission, how we can protect against changes of culture and the starving of a commission of funds. Would you have any suggestions for us around that?
Okay, I should say the Tasmanian Commission was never starved of funds, but I think there really should be a provision or some mechanism to ensure that there's independent funding to the Commission. In other words, there's always a problem if you get a very strong government with a substantial majority, which becomes subject to Commission focus, that they may decide that enough is enough and the money dries up or gets severely curtailed. As to what mechanism we put in place, I don't know. Can't say Parliament, because at the end of the day, if the government is strong enough, it controls Parliament anyway.
Could I just on this same point, Chair, is that okay?
Yes, go for it.
Commissioner, you said it's Senator Shoebridge here. You said that there was an instance some time ago where the budget was reduced by the government. First of all, when was that?
Oh, about 10 years ago, I think. And it wasn't because the Commission was investigating members of the government or anything like that. It was concerns about the effectiveness of the Commission and some of the processes.
All right. And by how much was the budget reduced in terms of the proportion of the budget? Are you aware?
I can't remember, 25%.
And was there any ability, or was there any place where that was independently reviewed? So, yeah, was there any place where that was independently reviewed in the Tasmanian system?
Only Parliament.
And
There's no provision for it. There's no.
sorry, Commissioner, did you want to?
No, we just have a joint standing committee that consists of members from all parties and both the houses.
And is that chaired by the government with a government majority?
I don't think so, actually. The chair's an independent. I'm just going through it in my mind. It's fairly evenly spread.
Well, perhaps you could provide us on notice what if there's a requirement for a non-government majority on that committee or a government majority on the committee. But
as far as where there's no requirement at all, it's I'll investigate it. I've never actually considered it. I've never considered it because the committee is actually it works fairly well and it's non-partisan.
all right. And then did the committee form a view about the budget cut?
I wasn't around then, so I can't comment.
Yes, Commissioner, just to take you to another area around jurisdiction of the Tasmanian Commission. The jurisdiction that governs your commission has a narrow definition of a public official and can't investigate those who are not public officials but may have tried to influence public officials. How many times have you started an investigation with a genuine view that there is an important issue to be pursued and then had to stop the investigation due to issues with your jurisdiction?
Can't recall any. We have a problem with the fact that members of Parliament, when Parliament is prorogued, are no longer subject to the Commission. We've made some recommendations in relation to that. There was a review done about 6 years ago which made a series of recommendations, and the government's in the process of implementing the majority of those recommendations. But generally speaking, I can't recall one. You've got to bear in mind, I'm the Chief Commissioner. I don't actually run the Commission. It's run by the Chief Executive Officer, and we see the results of an investigation when it comes to us. That's one of the things we're looking at the moment in the legislation. But I don't recall such a matter. Bearing in mind, as you say, it's fairly narrow. The definition of what we can investigate is fairly narrow, but it does actually cover a fairly significant ground. Because if you have somebody who is dealing with somebody attempting to influence and continues to deal with them, that conduct could well become misconduct.
It would need to become misconduct for you or you would need to have a suspicion that it was misconduct for you to investigate. Am I right in drawing that conclusion?
Yes. Well, yes, there's definitions of the sort of conduct we can investigate, and all matters are triaged before an investigation continues. And some matters are triaged. Some matters are not continued because of the triage stage, because either the person is considered the conduct's not considered to fall within the definition of misconduct. The person is not somebody who's a designated public officer, which means who we can investigate, or we consider the matter to be so minor as not be worth the resources to investigate it, or we refer it back to the department to do an internal investigation.
All right. Thank you very much, Commissioner.
Thank you. I think it's Ms. Lawrence, yeah.
Thank you.
Thank you, Chief Commissioner. I'm interested that we've had a number of witnesses speak to the primary benefit of having public hearings is it enables the Commission to demonstrate accountability to the public. And I'm just interested as to how you do the same and achieve the same result without going public with public hearings.
We publish reports at the conclusion of hearings. We then decide which ones are appropriate, and there are. Our legislation's in a bit of a state of flux at the moment as to whether we, under what circumstances we can table a report in Parliament or publish a report. But generally speaking, we provide an annual report which outlines the matters we've been doing, in general terms, a lot of it's anonymised or redacted, and the results thereof. I've always thought a specious argument to say that you can't, you must hold public hearings to show the public are actually doing your job. I mean, in all my time at the National Crime Authority, we didn't have any public hearings. We were obviously doing our job because lots of prosecutions and successful prosecutions.
Thank you.
I don't think. When you have such extraordinary powers, it's so dangerous that people want to go out beating their chest, saying how great we are. Look at all the damage we've done or what we've uncovered. I think it's softly and carry big sticks the way to go in an organisation such as this.
Thank you. Appreciate your comments. And I noticed that your commission's recently broadening its scope to include lobbying oversight. And I'm curious as to whether you have a view on our draft bill as to whether you feel it's capturing sufficient functions or whether you feel from the Tasmanian experience that there may be other areas for improvement.
On the lobbying, that was part of our responsibilities from the outset. We just didn't take it on. We now have sufficient staff to do it. The two big areas that cause a lot of problems are lobbying and what we call pork barrelling. We've produced papers on both, and I think, and subsequently New South Wales, Victoria, I think, have produced papers on pork barrelling as well. I've got to be frank, I think they're the sort of matters that should be covered by organisations such as an anti-corruption commission. I haven't looked at the act specifically as to see whether or not I think it's wide enough to cover that sort of behaviour. My view is that sort of behaviour should be.
Thank you.
Mr. Lim.
Thanks, Chair. Thank you, Chief Commissioner. Commissioner, in regards to the warrant powers available to the Tasmania Integrity Body, what are the protection that exceeds for journalists and journalist sources? And does Tasmania have any provision or similar law, notably qualified privilege?
I'm not sure we'd have qualified privilege as such. And as far as protection of journalist sources are concerned, I don't think there's particular protection. We have the part of the problem is we would not have the power to go to the journalist to get the information unless they're a public official. No, I may be wrong about that. I'm just trying to think through the provisions. Oh, I noticed, I'm sorry. I can't recall an investigation where we've actually approached a journalist for any information.
Thank you for trying.
Anything further? No. Senator Scarr?
Thank you, Chair, and thank you for joining us, Commissioner. It's greatly appreciated. In answering one of the questions, you did talk about the extraordinary powers of commissions such as this, and you also made a reference to considerations that could arise in terms of public or private hearings if there were a likelihood of criminal charges perhaps flowing from an investigation. Do you think, in terms of a decision as to whether or not a hearing should be in private or public, the Commissioner should specifically consider whether or not the holding of a public hearing would have the potential to prejudice a future criminal trial?
Definitely.
And that should
be
one
of the major reasons. It should be a paramount consideration.
So given its paramountcy, it should be specifically referred to in the bill?
Yes.
Okay, thank you. I'd like to ask you a question in relation to the role of the inspectorate, what's called the inspectorate or inspector under this bill. And we received a submission from Mr. McClintock, who's going to appear later today as a witness, and Mr McClintock has great experience discharging the responsibilities of an inspector. And I just wanted to put a quote to you with respect to his experience, if I could, and just get your reaction. So I quote from paragraph 11 of his submission. In my experience as Inspector of the New South Wales ICAC, the Northern Territory ICAC and the New South Wales LECC, the probable performance issues, and this is relating to an anti-corruption commission, are A, failure to give adequate reasons for conclusions of misconduct, to use a general term, made at the conclusion of an investigation. B, failure to accord procedural fairness. C, failure to consider the rights of persons not under investigation and so cause reputational or other harm to them. D, investigation failures resulting from incompetence or lack of training on the part of agency staff, end quote. Would those be the matters which you think an inspector or inspectorate with an oversight role of an anti-corruption commission needs to have particular regard to?
Yes.
And in addition to that, Mr McClintock puts forward the proposition that it's important that any such inspector or inspectorate have a proactive, ongoing, real-time supervisory role, and they shouldn't simply be reacting to complaints that are made after the fact. So the language, and I am paraphrasing to some extent, but the language he proposes in terms of the functions of the inspector should include, and I'll quote in this regard, to audit the operations of the National Anti-Corruption Commission for the purpose of 1, monitoring compliance with the laws of the Commonwealth, 2, detecting agency maladministration and officer misconduct. So he, end quote. So in his submission, he's saying, well, look, the particular nature of the complaints and the function the inspectorate should have regard to relate to complaints relating to maladministration or officer misconduct. It's not human resource type issues within the commission, and also it's important that it be an audit and monitoring role, not simply reacting to complaints that are made after the event. So I'm interested in your views in that respect.
I agree with him there as well. I think it's also important to note there should be a distinction between an oversight committee and an inspector. The inspector should have those roles, but not necessarily the oversight committee, because an oversight committee usually consists of politicians, and when I was the National Crime Authority, we had some concerns about leakage of information flowing from responses given to the oversight committee.
So it shouldn't. So just teasing out that issue, it shouldn't be the responsibility of members of the Parliamentary Oversight Committee to delve into the innards of an ongoing investigation and second guess the Commission with respect to particular steps it might take in accordance with that investigation. It's more an oversight, a helicopter view of how the Commission's functioning. Is that correct?
That's correct. And if an investigation's finished, and perhaps they can take a deeper view, but you should have an inspector or inspectorate which has the powers or the ability to do the things that McClintock suggests.
Okay, thank you. I'd like to move on to the issue of communication between the Commission and people who've referred a matter to the Commission, or people who are the subject of an investigation undertaken by the Commission. And under the draft bill, anyone who is the particular subject of a finding of corrupt conduct has a right to be notified, so the Commissioner must notify them in that regard. But the Commissioner is given more discretion, or is given discretion, with respect to notifying someone of the result of an investigation who has referred a matter. So it's not compulsory to notify them of the result of the investigation. and also is given a discretion as to whether or not to notify someone who's been the subject of a complaint where no finding of corrupt conduct has been made at that point in time. So the issue has been ventilated before us as to whether or not there should be some sort of positive duty upon the Commissioner to inform someone who's been the subject of an investigation, the result of the investigation, or at least some sort of higher standard that needs to be met, some guidance given to the matters which the Commissioner should have regard to in determining whether or not they shouldn't be advising someone of the result of an investigation. I'm just interested in your practical views with respect to that matter.
Several parts to that. Of course, anybody that's been investigated must be given procedural fairness before you make an adverse procedure, any sort of finding, and we of course do that in Tasmania, and I assume most commissions do. To inform somebody that there's been an investigation and that there's been no adverse finding would depend on various circumstances, because often you'll get a series of complaints against an individual which may be split into several investigations, or you may have to actually have another matter arise while you're investigating the first one which doesn't fall within the terms of reference or the terms of the investigation, and therefore you may compromise a parallel or subsequent investigation being investigated. So as a general rule, I don't think there should be just left in the discretion of the Commission, not a mandatory reporting or informing. The other point about it is, if you carry out an investigation, have a problem informing the complainant about the result of the investigation, but I do have a problem. There may be problems in getting the investigative material, because a lot of that will infringe upon the rights of people who know nothing about the complainant, who have given evidence, and I think it's fairly important to protect people who have done nothing wrong but have come along and assisted in an investigation, especially in an organisation with personal relationships. I'm going into personal relationships considered.
Right. So I appreciate those different elements that need to, different factors that should be considered, and hence the reason for the discretion. At the same time, just thinking aloud, you can understand the situation of someone who becomes aware that they're subject of an investigation, and it could well be that colleagues have been approached to ask them questions. They might have been compelled to appear as a witness and propositions put to them, and they're carrying the mental stress of that. And if whilst it's outstanding, in inverted commas, from their perspective, whilst they haven't been advised of any finality with respect to the investigation, you can envisage, or I can try to envisage, the pressure that puts on them, and hence their desire for some sort of finality with respect to the process in a timely fashion. How should we practically deal with that sort of issue?
Well, the way in which I would deal with it, if we were aware that a person has become aware they're being investigated and they're cleared, we'd tell them. I agree with you, it's unfair to let somebody carry the burden of not knowing whether a matter has been against them, they've been adversely affected by it. And part of the trouble we have is, coming election times, you get politicians making allegations against other politicians, going to the press and saying, I've referred so-and-so to the Integrity Commission. And I think then it's really important that we let the person investigated know that there's been no adverse finding. And as I said, if we become aware that somebody is aware they've been investigated and we're deciding not to go any.
We missed the end of that.
We missed the end of that.
Could you just repeat the ending, Commissioner, of your comment there? We just...
Okay. In my view, if somebody has become aware that they're under investigation and that no adverse finding has been made, they should be told that no adverse finding has been made.
Okay, thank you.
But sorry, just on that,
Sure.
there's a number of potential outcomes once something's referred to an integrity agency. One is that the complaint had been investigated, but there was a decision. The complaint had been reviewed, but there was a decision not to investigate it. One is the complaint had been reviewed, a decision was taken to investigate, but after the investigation, it was found that there was no substance to it. And then I suppose the third is decision was referred, it was reviewed, it was investigated, and there was a finding. Is there a process that you have to deal with those first two, where it's been referred, been reviewed, but a decision was taken not to investigate? And then the second, where it was referred, reviewed, investigated, and a conclusion was made that there was no substance to it. Do you respond or do you inform?
We usually inform the complainant.
You inform the complainant?
Yes.
But I suppose that I understood your evidence earlier was you thought that in those circumstances the person, the subject of the complaint, should also be told. But that's not what happens in practice in Tasmania?
No, sorry. Let's take the first circumstance. A complaint's made, we triage it, decide that there's no substance, doesn't go any further. We tell the complainant. There's no point. Well, sorry, we don't tell the person who's had the complaint made against them.
But what but you gave the example of, in the heat of an election campaign, politicians throwing allegations at each other. I've referred this off to, they've referred this off to. You don't have a process in your system, despite being aware of that, of saying, well, actually, we reviewed it and determined not to investigate it.
I'm sorry. This is part of the problem. We don't have provision in our Act which makes it an offence to publicise the fact you made a complaint.
Yeah. And I'm not suggesting there should be. That's not what I'm suggesting. I'm dealing with your...
think there should. No, sorry, I think there should be, because of compromise investigation right from the word go. If somebody comes out and says, but if a politician makes an allegation against another politician, and we decide not to investigate it, we generally don't say anything publicly about it. We assume the public is probably aware that because no adverse findings been made. But I suppose if it doesn't prevent a person who has a complaint made against it to say the complaint went nowhere because I haven't been contacted.
Well, that's a stretch, isn't it? If you haven't been contacted, you may not know. Well, what about in circumstances where you've reviewed it, investigated it, and then determined there was no substance to it?
Well, once again, it's I'm trying to think of an actual situation. We usually don't come out in public and say we've investigated X, Y, and Z and made no finding and made no adverse finding. If a person had been vilified publicly about it, there's no reason why we couldn't do that.
Yeah, and in fact, you would, if in both of those circumstances, you would only make a public statement if the referral was already in the public domain, because otherwise you would just be unilaterally causing potential harm. But where the allegation's been made in the public domain, you don't have a process in place. But do you think there probably should be a process in place?
I'm
more than happy for you to take it on notice, Commissioner, and come back to us.
All right, I'll do that. I'll have a bit of reading to do with the hands for that.
Thank you. Ms Lawrence, have you got
just
one further question?
Little ones, hopefully. I understand that you're also on the AAT, and we've had a lot of discussion over the last couple of days about approaching the AAT for warrants. and whether you have any view about that, and in particular with what level of qualification one should have before signing off on a warrant.
My view is that warrants should only be signed off by a legally qualified person. I also wonder about the level. I've got to be a bit careful here because I'm probably maybe going against AET policy. But I would have I'd be a lot more comfortable with warrant only being signed by a deputy president or a senior member.
Thank you. And with respect to the term of the Commissioner, at present the bill's proposed to be 5 years. Given that this will obviously need to be a newly established agency, do you feel that the term might need to be revisited for at least the first term to extend it beyond 5 years? The Commissioner from Western Australia suggested 7 years, and I understand 7 years is international standard. Do you have a view about that?
I think that initially 7 years is probably right. My term's 5-year term. Story. I think 7 years. I think 7 years is about right. I've got to say. The only trouble with 7 years is if you make.
Sorry, we just missed the last bit, which probably was important to the caveat.
The only problem with 7 years, if you make the wrong choice, you're stuck with it a bit longer than you would be on a 5-year term.
Sure, and that really goes to my last question, which is around the appointment of the CEO. So the bill as proposed has, quite a robust process to the appointment of the CEO, and in the unfortunate situation where the CEO needs to be dismissed, that's for the Governor-General to decide. There doesn't seem to be the same provision for the dismissal to be on the recommendation of the Minister and, by extension, the Commissioner. Do you have a view about the relationship between the Commissioner and the CEO that we should maybe think about? Or do you think that's satisfactory?
I haven't worked out how the interaction between the Commissioner and the CEO on the federal thing. As a general rule, I would have thought the CEO, if the Commissioner's lost confidence in the CEO, the Commissioner should be able to make a recommendation to the Minister, to the Governor-General, to dismiss the CEO.
Thank you.
Thank you. I think that's...
I've got a follow-up question, if I could.
Yes.
Sorry. Just in relation to the terms, and we haven't canvassed this before, so I appreciate the line of questioning which triggered the thought. There's a distinction drawn between the term of the Commissioner and the Deputy Commissioners can potentially be appointed for, I think it's 2 consecutive terms of 5 years. But it seemed to me you could have a situation where you appoint the Commissioner, and this might be an argument for the 7 years, but potentially you could appoint a Commissioner for 5 years, you've appointed all the deputies for 5 years, it's a new commission, and then you lose them all at the same time. And from a continuity perspective, it would be important for at least one of the senior leadership team to be ongoing, which might be a reason for having different periods of term for the Commissioner as opposed to the Deputy Commissioner. So, for example, you could have a Commissioner for 7 years, the 2 Deputy Commissioners could 5 years, and then one could be reappointed for another 5 years. So you at least have one person there to provide that continuity. Does that make sense?
Yeah, continuity is very important. I think you need a minimum of 5 years. The National Crime Authority was a 4-year appointment, and that just wasn't quite long enough. And it had the J. Edgar Hoover clause, and you couldn't be reappointed. Whereas in Tasmania, it's a 5-year appointment, and you could do more than 10. And we don't have a Deputy Commissioner, but if you're going to have a Commissioner and Deputy Commissioners, that they should have overlapping terms of appointment.
Okay, excellent. Thank you. No further questions.
Okay, thank you very much for your attendance here today. If you have been asked to provide any additional information, would you please forward it to the Secretary within 5 days from today? You will be sent a copy of the transcript of your evidence and will have an opportunity to request corrections to transcription errors. And again, thank you very much for taking the time to speak to us. We really do appreciate.
But could I just mention, I have a fairly horrendous week coming up. I may or may not be able to comply with the 5 days. I'll do my best.
We understand. But again, thank you for giving us this amount of time. Thank you. Right. I think we might have the Law Council on the line.
Is it the Law Council or Human Rights Commission?
Oh, sorry. No, Law Council. Law Council. We've got 2 of the 4. I think. Can I just? There's 2 of the 4 we're expecting. I think. 2 more. We'll just perhaps. Well, can I just ask? Are you expecting the other 2 people?
Yes, we are. Committee members, we are expecting 2 more. One is just coming on now.
Great, thank you.
And one more witness to join.
Thank you. All right, we'll just wait for that other witness.
Thank you.
So we're still, yep, so we'll just wait for a short period.
So I must say this.
Isn't it?
I had the Human Rights Commission.
Did you have a background?
I did study law.
I think, no.
I didn't get to finish my law degree.
I'm going to that.
We are the R-rats.
Right. Okay, thank you. I think we will start. I think you might be missing one of your number, but can I now welcome the Law Council of Australia to give evidence today. For the Hansard record, would you please state your full name and capacity in which you appear before the committee?
Madam Chair, my name is Tas Liveris. I'm the President of the Law Council of Australia. And I just have Ian Blumenthal, our other witness, is just sent a message saying he's having trouble connecting, so hopefully he can resolve that shortly and join us.
Thank you.
I'm also present, Madam Chair, David Neal, Chair of the Riddle Law Committee.
We're having that. You're quite faint. You might need to turn up the volume. Could you say that again?
Yeah, David Neal, is that better?
Marginally, a little more.
Turn it up to 11.
Yeah.
Chair of the Criminal Law Committee of the Law Council.
That's fantastic. Thank you. And finally.
And Leonie Campbell, Director of Policy, Law Council of Australia.
Thank you. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. We have seen your extensive submission, but I do invite you to make a brief opening statement before we proceed to discussion.
Thank you, Madam Chair. The Law Council of Australia welcomes the opportunity to appear before the committee this afternoon. The Law Council has long supported the establishment of a National Integrity Commission, and we are pleased to see the introduction of these bills as a positive step. Corruption has many corrosive effects on society, including on democracy and the rule of law. It's essential that Parliament provides for proper scrutiny of the draft legislation to ensure the final model for the National Anti-Corruption Commission is fit for purpose. The limited time provided in which to provide submissions on the bills has constrained the Law Council's ability to consult at the level of detail that we would otherwise have preferred, and our views are therefore preliminary. The Law Council welcomes many elements of the bill, including the Commission's ability to investigate serious or systemic corrupt conduct across the Commonwealth public sector, including through the establishment of broad referral pathways. The ability for the Commission to operate independently of government, subject to parliamentary committee oversight, the exclusion of the judiciary from the committee's jurisdiction, noting the government's in principle support for the establishment of a federal judicial commission, an emphasis on the Commission's preventative and educative functions, and the provision for whistleblowing protections, noting intersections with the Public Interest Disclosure Act and recognising that broader reforms have been promised. There are, however, certain areas for further consideration that the Law Council has raised in its submission, including our consistent view that hearings should generally be conducted in private unless the Commissioner considers that a closed hearing would be contrary to the public interest or unfair to the person. Measures can also be adopted to increase the fairness of public hearings. The need for a reasonable suspicion threshold to be in place for the Commissioner to investigate a corruption issue, and for mandatory notification by agency heads. Removing future corrupt conduct from the definition of a corruption issue and tightening aspects of the corrupt conduct definition. The proposed abrogation of privileges such as legal professional privilege and the privilege against self-incrimination when a person is giving an answer or information or producing a document or thing under an oath to produce at a hearing. And in that former respect on client legal privilege, the committee will have received, as we sent through to the Secretariat this morning, a table comparing client legal privilege provisions across certain jurisdictions, and we ask that the committee receive that as an aid memoir to our submission. We also have raised issues with the approach taken with regards to post-charge coercive powers and post-charge disclosures of information to a prosecutor, noting that it's critical to preserve the distinction between the investigative nature of the Commission and the criminal justice process. And finally, the appropriateness of existing safeguards and oversight mechanisms for intrusive search powers given to the Commission and other eligible law enforcement and security agencies more generally, particularly with respect to telecommunications interception and surveillance. The Law Council is committed to working with the Parliament to ensure that the Commission has the requisite powers needed to address integrity concerns, balanced with appropriate safeguards and oversight to ensure that it generates and maintains the highest levels of public trust and confidence. Thank you, and we are happy to answer your questions.
Thanks very much. We're just searching for that further submission or document that you suggested that you sent.
Yes.
When we can see it, I will formally get it submitted in evidence. But we don't seem to have it at the moment, although, of course, now we do. Thank you. Before we commence then, can I ask that the document presented by the Law Council be accepted as submission number, what number will be?
To be determined.
A number to be determined and be authorised for publication. Would a member like to move that, please? Thank you. Moved, Dr Haynes. Thank you. So if I can now go to questions. Senator Scarr.
Thank you, Chair, and thank you to the witnesses for appearing today. I'm going to go through some of the recommendations that the Law Council of Australia has made in its extensive submission, which have been the subject of some commentary during the week of our hearings. And as I do so, I'm going to put some propositions which have been raised during the course of the hearing as to why a different view might be taken to some of the recommendations which have been put, because I think that will help tease out some of the issues which have been the subject, in some cases, of competing submissions during the course of the week. So the first recommendation I wanted to refer to from the Law Council was the need to, or the recommendation that the words "or that could adversely affect" should be deleted from paragraph 1A of the draft bill. And it has been raised during the course of this week, well, what's the problem having that particular phrase contained in the bill, given that we want to make sure that there isn't a technical reason as to why a claim or an issue of potential serious or systemic corruption has been raised, is not considered because the definition is too prescriptive. So what is the particular concern with respect to that phrase, "or that could adversely affect"?
Senator Scarr, just before we finish, your colleague, Mr Blumenthal, is going to, we hope, join us through the phone. So, but we're just working on that for him. So he'll be with us through chorus call, just to keep you abreast of what's going on. So sorry.
Thank you very much.
Sorry, Senator. Ian Blumenthal joined by phone. I had some difficulty with the WebEx. Apologies.
Thank you. So Mr Blumenthal is there. I think I probably have to just tell you that your evidence will be recorded by Hansard. It attracts parliamentary privilege, and the giving of false or misleading evidence is a serious matter and may be regarded as contempt of Parliament. But if I go back to your question.
And Chair, just for the benefit of Senator Shoebridge, because I know he listens to my questions carefully, I just asked a question of the Law Council of Australia with respect to their particular concern regarding the phrase "or that could adversely affect" in clause 8.1a.
Senator, the specific concern with that clause is that it is unduly speculative. And that is something that we think is problematic, because if the intention of those words is to deal with a wider category of corruption, it's noted, we've drawn attention to the fact that there are conspiracy and attempt provisions that are already captured within the definition, and that the words that could adversely affect in that sense appear to be somewhat vague and potentially redundant. Our concern is that when the Commissioner is undertaking the task of analysing corrupt conduct, it is preferable and indeed desirable that that be done measured against a greater objective specification by reference to definitional concepts, rather than something that we suggest is rather vague and curiously inserted.
But don't you need a degree of uncertainty in there? Because you could have the best laid corruption plan in the world, but if you hit a public official who's, rock solid, unable to be swayed, the best laid plans will come a cropper. You need to have a kind of a degree of uncertainty about the likelihood of it affecting the outcome. If for that reason, and I can think of many other reasons why you'd need a degree of uncertainty about whether it will be effective in corrupting.
But that doesn't take note of the fact that there are attempt and conspiracy provisions in there which capture that conduct in the kind of example that you referred to.
But it may not have, you may not have got to the full attempt point, might you? You might be in the still planning and conceiving point.
Well, then doesn't that create the task for the Commissioner to determine whether the conduct would fall within an attempt or conspiracy?
Well, I don't think that quite answers my point, but I've interfered with.
Just to use a quick example, though, like the case in Western Australia that took some 4 years to investigate because it was a crime committed over a 10-year period. Where when the key person involved in the corruption was looking to take a redundancy, those that were endeavouring to corrupt the public servants started grooming or began the process to start grooming others. I would have thought that was an attempt, in terms of that could adversely affect other public servants that the Commissioner would be highly interested in investigating.
And if it is an attempt, and I don't make any comment on the specific case that's referred to, but if it is an attempt, then it will be captured within the definition of corrupt conduct that is otherwise set out in Clause 8.
But no, Ms. Lawrence was putting to you not that the attempt had happened, but they were getting ready for the attempt. They were doing the preliminary steps to be ready for the attempt. They were laying the groundwork down.
Exactly.
And surely you'd want that kind of conduct to be captured.
Thank you.
The trouble is where you intervene in a timeline, and the usual process for all offence-type conduct is a reasonable suspicion that the person has done something which breaches the law. That surely be enough in most cases, but it is the sort of basis on which police officers all over the country already intervene in what they suspect to be corrupt conduct or whatever other offence it is that they are investigating.
But
that's a standard approach, used all over the country and well known to courts, police officers and people generally.
Except in WA it took the CCC to investigate it because the health department didn't pick it up, and that was the value of having a dedicated commission that could look at those matters and cast the net wide enough to make sure that it was thoroughly investigated and the crimes dealt with.
Well, again though, why would the Criminal Conduct Commission in Western Australia have a reasonable suspicion when the Education Department or whoever the other department was did not have that? And you run a danger for the commissions themselves if you make these thresholds so incredibly vague, so that if someone is conspiring to do something or if someone is taking steps to do something and have engaged in conduct that the relevant person, in this case the Commissioner, reasonably suspects is corrupt conduct. That's that draws a reasonable balance between the ultimate vagueness of something which could happen versus something which, based on the basis of steps taken,
But that misses the distinction. In fact, it's good that you raise it, because the distinction between what a corruption commission is doing in this instance and what the police are doing is really critical. The police are there to identify and punish crimes that have happened. And a big chunk of what an anti-corruption commission doing is preventing corruption and preventing the activity happening. And the definition that the part of the definition that we're addressing goes to that corruption prevention role of an anti-corruption commission, and it is quite distinct from the role of the police, and it's one of the reasons we have them.
I beg to differ, because what police are doing and what the commission is doing is investigating. Now, what they do by way of prevention might be one thing, but before they take steps to commence an investigation of whoever the suspect is, surely there needs to be some threshold where, before they intervene in a very dramatic way in the life of some citizen who might be completely innocent of any misconduct.
Well, on your model,
they are both investigatory agencies, really. The police are investigating potential criminal offences. This body is investigating corruption offences.
But on your model, there'd be instances where the Anti-Corruption Commission was aware of preliminary steps being taken, plans to corrupt, but they hadn't yet been perfected. They may have detailed evidence of it. And on your model, they'd have to hold off and wait until those plans had taken a degree of perfection before they could intervene. And that seems to me to be contrary to the idea of an anti-corruption commission whose job is to prevent corruption in the first place.
The real traditional difficulty here is between thoughts and action. And where, as you say, someone has taken steps either by way of planning, in which case there would be a conspiracy, or conduct be identified, and then if that conduct or those plans reasonably raise the suspicion in the mind of the commissioner, there's the grounding. I mean, anything. The trouble with the word "could" is anything is possible. It really doesn't limit the field in a way that's satisfactory when citizens are entitled to know where the boundaries are between good conduct and bad. And it's an old problem in the law, and there's a lot of experience around those sorts of issues about when does someone go beyond merely thinking about something to actually doing things. And it's a matter of judgment, and the best we can do, and vague enough anyway, but the best we can do is equip the commissioner with the tools, the conceptual tools that have worked well for police and courts around the country for now hundreds of years.
Senator Scarr?
Okay, I'll move on to the next recommendation. I should say this process is generating the process I was hoping it would in terms of the exchange of ideas. So the next recommendation I wanted to refer to was that paragraph 1E in relation to concerning corruption of any other kind be either deleted from the bill or clarified by way of including an exhaustive list of the types of conduct that would be captured. So I'm wondering if you can... there has been some debate during the course of the week as to whether or not you need 8.1e as a general catch-all because there may be emerging types of corrupt conduct that it's difficult to envisage and perhaps clauses 8.1a to d haven't entirely captured the field. So there is some benefit in having a general catch-all provision. So I'm interested in the Law Council's view as to why it should either A, be deleted, or B, specific examples given.
Senator, might I say it follows in a sense from the previous discussion. Again, the concept of corruption of any other kind we've suggested is vague and uncertain and circular, and therefore is undesirable in legislation of this kind, which benefits from there being greater prescription over what type of conduct is captured within the remit. I might say to the point that you raised, Senator, with respect to, and is replicated in the explanatory memorandum about having some inbuilt flexibility as a catch-all to deal with emerging and new types of corruption that might arise. An important part of the bill is the 5-year review in clause 278, and we suggest that it is far greater should there be conduct that emerges that is not captured within the scope of the legislation, that to be dealt with in a targeted and prescriptive way at the 5-year review, rather than leave open the uncertainty and ambiguity and vagary that exists with an attempt to put in a catch-all in the definition of corrupt conduct.
Okay. I'll move on to the next...
You're moving on. Do you mind if I ask?
No, please. I'm intending you have the opportunity through you, Chair.
If that's all right, Chair.
Yep, go for it.
It's not just at large, though, is it? The 81E uses the concept of corruption, which is it's a word of the English language that has bounded meaning, and it's also to be read in the context of the rest of Section 8.1 and the Act itself. So it's not an unbounded term. It's limited by the concept of corruption and ordinary English usage of corruption, and then it's also read in the context of Section 8, and it's also read in the context of the Act. So it's not true to say it's an unbounded term. It's a reasonably discrete term, isn't it?
I respectfully disagree, Senator. It is a wholly unrestrained and vague term of any other kind.
Well, it has to be corruption. Do we agree with that?
It's any conduct that constitutes, involves, or is engaged in for the purpose of corruption. That must be for the purpose of corruption, but it is then of any other kind. And as the explanatory memorandum makes clear, the intention of that provision is to provide flexibility to address emerging areas. So inherently, its purpose is, as stated, to be at large, to have a degree of broad application, and that is our concern, because we suggest that it's far preferable to, whilst building in some flexibility for the Commission to do its work, but there be a set of objective standards by which conduct can be measured against.
Well, it has to be for the purpose of corruption. Now, what I'm concerned about, if your submission is adopted, is there will be examples of conduct for the purpose of corruption that the NAC is aware of, but if it doesn't fit in 8.1 A, B, C or D, they'll have to say, well, can't do that, not our problem. And that seems to me a worse problem than putting in place a somewhat expansive definition to ensure that we can catch future types of corruption. Do you accept that the inevitability of chopping out 8.1E would be if the NAC at a future point identified conduct that it thought was for the purpose of corruption, but if it didn't fit in A to D, they couldn't do anything?
I suggest, Senator, the matters within 8.1 A to D are very broad in and of themselves. Should, however, there be a known instance of conduct that is not able to be dealt with within those provisions, then that would be dealt with at the 5-year review. But it is difficult to envisage a type of scenario that could not be shoehorned into 8.1 A to D.
Well, I would suggest to you the world is more complex than 8.1 A to D. And corruption and influence and tends to have find a way, and we should be cognisant of that when we're drafting this bill.
Senator, if I could make a point here about principles of legislation and where you're proscribing conduct, there is an obligation on the Parliament to put some sorts of boundaries around the conduct that is proscribing in order that people who presume to know the law will know in advance of what they're doing.
It has to be corruption.
And it has to be serious.
And
serious
corruption.
or systemic corruption.
Yeah.
That seems a pretty good boundary.
And as to the first introductory words of the provision, it's corrupt conduct, and then it goes breach of trust, dishonesty, the various sorts of things that give meaning to the introductory words corrupt conduct. But if it's just open slather, why not just go with the word corrupt conduct at the start? There needs to be some degree of precision about this. It's simply not fair to the people whom the legislation is addressed to say that, or if later, retrospectively, you think there is something else that falls into this basket, we can still catch it. That's unfair.
So one of the one of the issues then, this has been a very useful discussion to tease this out, because 8.1a to D appear on the face of it to extensively cover the field in terms of, at least I'll speak for myself, what I would consider to be corruption. It begs the question in terms of E, well, what's it intended to cover? And that leads to the notion that potentially it's too vague a concept, because 8.1a to D have so extensively, in my view, covered the field as to what normally would be considered to be corruption. Is that a fair comment?
That's the point that we are making, and it's an obligation. Look, in the legislative principles of the Commonwealth, and especially in areas which are criminal law or near it, precision is a required feature of that legislative set of parliamentary legislation.
Senator, could I just add this to that point? And it is the case that if 8.1e is to be retained, it's why it underscores the importance we suggest that a list of examples be accompanied, a non-exhaustive list that would give some greater prescriptive guidance as to the types of conduct that 8.1e envisages it will capture. And so we make that suggestion in the event that the recommendation remains to retain 8.1e.
Okay. Do you want to just, is this a point of clarification?
Well, it's just on that narrow point.
Yeah, on the narrow point, okay.
You made the point of the 5-year review. We put this question to the Attorney General's Department about some examples that weren't covered in A to D but would require E, and they couldn't give an example. But it's not just the 5-year review, is it? The Commissioner may come to the Joint Standing Committee at any time, and then as members of the Parliament can consider that. So it can be reviewed before the 5 years, can't it? If 8.1e was to go.
The legislation's always capable of being reviewed, that is true, but this legislation, of course, contemplates and specifically builds in the 5-year review for that very purpose. And yes, we suggest that is the better time to be analysing any need to significantly expand the definition of corrupt conduct or the meaning of corrupt conduct rather than the use of vague and uncertain terms.
Thank you.
Well, if it was found to be abused in some way, creating identifiable harm in some way, we could deal with that in the 5-year review. The obverse is as good an argument there, isn't it?
Yes, Senator. The 5-year review is an opportunity to review the Act in its entirety and whether it's performing the functions and meeting the expectations of the community and doing the work that it is intended to do.
Okay, I'm conscious that other people did want to ask questions.
Sure.
We've got one more and then we'll go to others.
All right, so I'll just ask one more. I was going to ask some questions on legal professional privilege and privilege against self-incrimination, but I think there's a strong submission in that regard. I just want to talk about retrospectivity, so the consideration of past conduct. And I note that the Law Council's submission is quite clear that this bill would not create any retrospective criminal offences or otherwise impose criminal liability on a person retrospectively. However, a concern is raised in the Law Council of Australia's submission that there could potentially be a finding with respect to past behaviour of potentially of corrupt conduct, and there needs to be some consideration of limits in terms of the Commission's potential analysis of past conduct, given that there could be a significant finding made with respect to past conduct, albeit not a criminal conviction. I'm wondering if you can just outline the reasons for the Law Council of Australia's concern and what you believe those limitations should be.
We've suggested that the types of limitations that investigating past conduct involve would be a public interest component, and that's consistent with our policy in relation to the investigation of judicial officers who are no longer serving, and also not unlike or consistently with Victorian IBAC, that there be a limitation of remoteness that would guide the Commission's work in relation to investigating past conduct.
Would it be possible just to provide on notice a bit more detail with respect to what that might look like? I know we're very short of time, but even if it were just some proposed drafting or something that could at least at a high level inform us as to what that additional safeguard might look like, would that be possible?
Yes, we can take that on notice, Senator, certainly.
Thank you very much. Thank you, Chair.
Ms Lawrence?
Thank you. I'm just interested if you wouldn't mind expanding on your concerns around the need for a reasonable suspicion threshold, because I would have thought that the Commissioner would naturally have that in making a decision to proceed with an investigation.
Well, it isn't the case, because at the moment, Clause 41 simply provides a relatively, again, quite vague pathway in that 41.3 talks about investigation if the Commissioner is of the opinion that the issue could involve corrupt conduct. So there's nothing in the drafting at the moment that imports any other criteria or threshold.
Except that it's the only, just to qualify, that you didn't add the final few words, which I think were the important part, is that the Commission...
That is serious or systemic, of
correct,
course.
so it's not about making a decision on the investigation, it's about only proceeding in the event that it is serious and or systemic. So presumably you couldn't make that call without having done first initial work, which would then satisfy surely your concern that there's a reasonable suspicion to elevate it to one being deemed serious or systemic.
Firstly, I did not mean to diminish the significance of that vision in full. I was just short of words of mine, sure. But certainly at the moment, it simply uses the word could, which is much vaguer. If there is to be a threshold, and we suggest that there does need to be one, it should not be assumed that a Commissioner forming a view that the issue could involve corrupt conduct that is serious or systemic it should not be assumed that there would be a reasonable, that any other state of satisfaction of mind in there. The test of reasonable suspicion is a well-established safeguard. It applies to investigation powers, warrants authorising intrusive and coercive powers. It is a well-settled term. There is a vast body of law that talks about the satisfaction of reasonable suspicion.
But in those
objective elements.
But in those,
and
sorry to cut you
Sorry.
off. But in those other contexts, does that not open it up as another avenue of review and delay?
I would suggest it doesn't. In fact, I mean, the concept of the word could is possibly going to enliven that type of risk rather than something where the state of mind of reasonable suspicion is a well-settled concept that is used throughout legislation, as I said earlier, a state of mind that issuing authorities must reach when they authorise coercive powers to be used and that kind of thing. So a state of mind of reasonable suspicion is far preferable to suggest is a more vague concept of the Commissioner merely being of the opinion that the issue could involve corrupt conduct that is.
But don't you need the word could rather than must or some other more certain word, because that's the purpose of the investigation, to establish that? Like, don't you actually need the word could because it presumes the investigation hasn't made a finding?
Well, it's preferable, we suggest, that the amendment be that the state of mind is that the Commissioner forms the view that there's a reasonable suspicion.
But he would have had to have established enough.
That's just a question of redrafting.
But surely that then implies that there has to be an establishment of some facts to arrive at that. Like, because I just feel like just by the fact that he's having to, or she has to arrive at that the Commissioner may conduct or continue to conduct a corrupt investigation only if, which in itself is pretty strong, only if the Commissioner is of the opinion that the issue could involve corrupt conduct that is serious or systemic, that it's already met the lowest threshold that there is corruption, but is now establishing whether it's sufficiently of the nature of being serious or systemic to warrant a further investigation. Like, I just don't understand your cause for concern to put in another layer that is open to review and delay.
It isn't another layer, and it doesn't open up delay. In fact, if anything, putting in place this objective barometer or yardstick as to when the Commissioner determines to investigate and when they don't is important. It's important from a resource capacity. It's important for the Commissioner in demonstrating and justifying decisions to look at some things and not others. And so that is that level of detail is much preferable to a more vague, open notion of could.
And again, could I add perhaps to what our President has said, that again, this is a very standard threshold. So, some of the thresholds that are in the law would say a reasonable belief, but that's not what's being said here. The Commissioner will have received certain information about certain conduct and is making a decision to deploy very significant powers then in relation to the investigation of that. And surely it's reasonable then to use the words, as you said, would assume anyway, and certainly people, that there would be a reasonable suspicion that the information they've received reaches the level of a reasonable suspicion, i.e. there's a suspicion and there are reasons for that suspicion, which then authorise going into the next step, which involves exercise of very considerable powers. And look, it may be that Commissioners doing this would welcome those sorts of thresholds where they're getting pressure from people to conduct investigations where they don't really think there is substance in the allegation or the information they presently receive. So it works both ways.
Okay.
Might I just add briefly, at a baseline level, if the Commission receives a report from anyone, at a baseline level, then that would be corruption. What this does is greater contextualise and target the decision as to when to investigate and when not to.
Quality control measure.
Thank you, Chair.
Thanks. Mr O'Brien?
Thank you, Chair. Thank you so much for coming before us today to provide your evidence. My concern lies around the definition is very, very broad, and that's obviously been up for discussion, but also its jurisdiction in terms of the people that will come before the Commission. It appears to me that you are inevitably going to find that people come before the Commissioner who don't have the personal financial means to pay for legal representation or the support of an industry body or whoever might be able to provide that legal representation. I notice in your submission you speak to section 280 where the Governor-General may make regulations which may prescribe arrangements for the Commonwealth to provide financial assistance in relation to, and then list those parts of the section. Can you just elaborate on that and possibly explain how we can make this a little bit more appropriate for people who will have no money to pay for legal advice?
Thank you. I might first say that it was a finding out of the Law Council's Justice Report, Justice Project, that was dealt with in 2014, that a justice impact test would better facilitate the efficient use of resources through the justice system, and that is this. If government policy is going to create obvious legal need, then there should be budgeting to meet that need. We have welcomed the resourcing that's been allocated to this Commission, but the point we would make in that respect is this. There's clearly going to be a legal need that will arise from the work of this Commission. We support witnesses and all people coming before the Commission being funded not just for their attendance before the Commission, but also in respect of any review proceedings in superior courts that might arise. And critically, that needs to be funded with new money. It can't be added as a further burden on the already under-resourced legal assistance sector to try and absorb the additional increased need that these bills will create. So that's very important. We have welcomed the clause in the bill that provides the ability for those arrangements to be made, and we very much support the adequate resourcing being given for representation throughout these proceedings in that sense.
So, as I stated before, where the bill says may, do you feel that needs to be firmed up and the wording changed there, or what's your recommendation in relation to that?
We support any measures that would tighten and guarantee that funding. So for may is changed to a must, and if there are further parameters put around the types of the security of resourcing that is directed towards providing legal assistance for the work of the Commission, then that we are supportive of those types of measures. I don't have at my fingertips a form of words or anything of that kind, but certainly any measures that will ensure that people who are brought before the Commission in any capacity have the resources to not only have representation at the Commission, but as I said in review proceedings, is critical to the effective operation of the Commission.
That's all.
Thank you, Dr. Haynes.
It even may consider whether the Commissioner should have a recommendatory power to provide such funding where there's an obvious inequality of resources, as you rightly say, will often be the case.
Thank you. Dr. Haynes?
Yes, thank you, Chair. Thank you to the Law Council of Australia for your substantial submission and your witness today. Your submission canvasses the very divergent views from your member bodies about the necessity of the exceptional circumstances test in the National Anti-Corruption Commission Bill. The Law Council didn't come to a conclusion, or if it did, not explicitly, about whether the exceptional circumstances test was onerous and unnecessary. Can you tell me why the Law Council is unable to form a view about the merits of this clause?
Thank you, Dr. Haynes. It's not that we're unable to form a view at all. We, as I said in my opening, support the position that proceedings should generally be conducted in private, unless doing so would be unfair to any person or contrary to the public interest. Our constituent body members have taken views in relation to this question that are centred around the concept of fairness to any person, and so it is not right to say that we've been unable to come to a position on this very important question.
Would you be able to give me an example, perhaps to help me here, of what exceptional circumstances would favour a finding for a public hearing?
Dr. Haynes, we see in the Victorian model, and we've cited the authority that of R&M and IBAC, this is a paragraph 118 of our submission, that talks about the types of criteria that exceptional circumstances would involve, and also at paragraph 119, the concept of public interest and what that would involve. And as I said, we favour public interest being one of the considerations that's being looked at. So we can point to the authority on that question, but what is very important to recognise is that this is a matter where reasonable minds will differ, but we suggest that the idea of fairness to any person directing that decision, or the concept of public interest as it's established, is a better guiding principle for the decision as whether to hold a public or private hearing.
So if I've understood you correctly then, the safeguards as laid out in the public interest, you would agree with in the bill? And
public interest?
Yes, and a default public hearings you would agree with, private hearings I should say. Yep.
Private. Private hearings?
Yes, as the default.
Generally, unless doing so would be unfair to a person?
Yes.
Or contrary to the public interest?
Yes, absolutely. So I'm just, forgive me because I'm not a lawyer, but I'm just not clear how you might view exceptional circumstances could substantively improve what's already there in clause 73 around those safeguards as laid out. Could you step me through what would be different about exceptional circumstances?
We favour, we don't favour exceptional circumstances, Dr. Haynes.
Okay.
Exceptional circumstances as they're set out by the court in R&M and IBAC,
yep,
as it's pointed out, determined by the Supreme Court of Victoria and upheld in the High Court, provide the type of guidance as to how a commission would approach exceptional circumstances. That is not what the Law Council favours. We prefer a test that is founded in public interest or unfairness to a person.
Great, thank you. I just needed clarity on that. And could you also give me your opinion around the phrase that precedes this, around may give regard to, or whether in fact it should be must, to those safeguards at 73.3?
Yes, thank you, Dr. Haynes. We consider that we don't have an established policy position on that itself, but I will point out that the criteria in 73.3 are on their face good ones. They necessarily, at 73.3c, deals with the issue that I've spoken about, which is the unfair prejudice to a person's reputation, privacy, safety or well-being that would likely to be caused if the hearing or part of the hearing were to be held in public. So there may well be considerable benefit in adopting those as mandatory considerations. There may be some real substance in that view, but that is not one that I have as an established Law Council position in the time that we've had available to make comments on the bill.
Thank you. So just so I can be absolutely clear, then you would be comfortable if we got rid of the phrase exceptional circumstances?
Yes, we don't suggest that exceptional circumstances should be there.
Thank you.
Direct follow-up question.
Direct follow-up question.
As a follow-up, if exceptional circumstances was to go, and I note you don't have a view on whether subsection 3 should be may or must, but leaving that to one side, the criteria in subsection 3, one of the criteria it doesn't mention, and we've put this to many other witnesses, is that it could have a requirement that the Commissioner have regard to whether a public hearing would prejudice the right to a fair trial or prejudice a fair trial. And we heard from the Tasmanian Commissioner that that would be a paramount consideration. And when we have taken others to subsection 4 and say, well, that's a catch-all, but should it be more express? There have been many that have said yes. Well, what is your view on adding to subsection 3 the requirement that the Commissioner consider the potential prejudice of a fair trial?
Could I add something on that front, please, which is that under Clause 74, there's a requirement that evidence must be given in private if giving the evidence would involve information that the Commissioner is satisfied sensitive information. That in turn is defined in Clause 227(3) to include information would prejudice the fair trial of any person or the impartial adjudication of a matter. And therefore, I think that there is a requirement that the Commissioner does consider this one.
Yeah, and could I also add that the issue that has just been raised about the effect of either the investigations or indeed public hearings in relation to them do have very significant implications for fair trials, and the committee in deliberating on this and other aspects of the bill, including those on legal professional privilege and the privilege against self-incrimination, need to be aware of the High Court's series of decisions on these questions in a series of cases which are called Hammond, Lee, X7 and Zhao, where any interference with fundamental principles of the criminal trials may prejudice the opportunity to have a criminal trial, and that is a major issue in considering the operation of this body in relation to cases where it's envisaged or there is in progress at some point a criminal trial. They are very, very significant considerations, and the High Court has been very strong about them.
Thank you both. Sorry, Ms Campbell, you said 227(3). Where does that say fair trial there?
So it's 227(3)(a).
3A?
3A.
A?
That says, could prejudice the security, defence or international relations of Australia. I don't see fair trial there.
I have 227 subclause 3, and then going down, so it's G, could reveal information. Right towards the end of the clause is a K, would prejudice the fair trial of any person or the impartial adjudication.
No, well done. I don't think we've considered that before, so that's helpful.
Okay.
Thank you.
Thanks. Mr. Zapier?
Thank you, Chair. And can I thank the Law Council for its submission. In fact, I believe it's probably the most detailed submission that the committee has received. And I thank you for that, because I'm sure it'll be helpful to both this committee and to the government. My question is simply this. Whilst acknowledging the detailed amendments that have been proposed within your submission, the Society now has the experience and benefit of having looked at corruption commissions around Australia for several years. on balance, and broadly as a matter of principle, is it the view of the society that this legislation gets the balance pretty right, or are there other commissions that already are in existence that have actually got a better framework?
Thank you. The critical task is to establish a commission that is fit for purpose to deal with its remit. And that is, as I said at the start, a welcome introduction and something that the Law Council has supported for many years. What we've pointed to across this being a very welcome piece of legislation and something that the community has sorely needs are elements of the bill we suggest can improve it, can enhance its functions, can preserve the rights of the community with respect to legal professional privilege and the privilege against self-incrimination that affect individuals, that don't affect the legal profession, they affect individuals. We've made suggestions where we see that the modelling of the bill can be enhanced to better fulfil its functions. It's not a case of, whilst we have state and territory models saying, let's just take this one off the shelf. We need to establish a federal anti-corruption commission that is fit for purpose to deal with investigations into the federal public sector. And we have, as I said at the start, we substantially see this in the bill, but we've pointed to those key areas where we suggest there could be improvements made.
So if I could take from your answer, and the critical phrase you use is fit for purpose, and I appreciate that. Again, do you broadly believe that this legislation is fit for purpose, albeit that in time there may have to be some amendments or improvements made to it?
We think at the moment there are shortcomings that need to be rectified, and they're in the broad nature of the matters I outlined in my opening statement and that you see in the submission and the recommendations that we've made. We welcome the bill, and we think it is an important and good and good development, but we can improve it, and that is why we have made the suggestions and the recommendations that we have throughout our submission.
And perhaps finally this, regardless of what legislation is ultimately adopted by the Parliament, do you accept or do you believe that it will still be a matter whereby the questions of interpretation will continue to arise regardless of whatever is finally legislated?
I don't think you ever really, the Parliament ever really enacts a piece of legislation that doesn't invite matters of interpretation, but some of the improvements that we've suggested, and the reasonable suspicion aspect was one of them. We have an established body of law on reasonable suspicion, and that is why we suggest that be utilised. Those sorts of things, I think, on balance, will reduce the amount of interpretive challenge that might exist. But you could never really enact a piece of legislation and say that it's free from arguments about interpretation. It's the nature of legislation.
In fact, it's the nature of lawyers, isn't it? In fact, that lawyers are always going to be. There's always going to be, for every lawyer, there's going to be a different interpretation, or groups of them. So surely, eventually, you have to make a law and put it out there, don't you?
Well, the Parliament enacts the law, that's true. The courts are there to interpret the law. I don't think this is a matter of looking at the legal profession at all. In fact, some of the fundamental principles that we've spoken about at length in our submission don't, as I said, don't involve.
I was being flippant. It doesn't. I was trying to be flippant. No, I was a member of one of your law institutes, so I think I'm entitled to have one shot at you. Okay, so take that as the shot, and don't. It was a rhetorical question. I think on the important matter of legal professional privilege, you want to ask one question?
We haven't had an opportunity to canvass in depth the Law Council of Australia's important recommendations with respect to the maintenance of the privilege against self-incrimination and the privilege that attaches to legal communication, so legal professional privilege. If you could just shortly advise why it is absolutely crucial that this committee give grave consideration to any abrogation of those fundamental privileges, please.
Certainly, in terms of client legal privilege, as I said, it's owned by the client. It's a fundamental tenet that promotes free exchange of information between solicitor and client. It doesn't apply to information that it doesn't protect any information in furtherance of a wrongdoing. So if that was the type of information that was being discussed, then that wouldn't be covered by privilege. Whilst the explanatory memorandum suggests that it isn't an important information gathering tool, and that, again, at a baseline level, clearly it is. A commission would like to see the information exchange between solicitor and client. That doesn't justify abrogating the privilege. These are fundamental and well-established principles that, in fact, promote compliance. If you were to abrogate the privilege, then you have a situation where people would naturally, in the community, be naturally reticent to speak to their lawyers about these types of matters because they're fully aware that that's just as likely to be looked at by a commission in due course, and that is a problematic thing. The abrogation of the right against self-incrimination should apply only to the extent that information is protected by direct and derivative use. At the moment, we see the bill provide some carve-outs for derivative use, and we suggest that is an unhelpful thing as well. Just having said that, I might just turn to my colleagues, Mr. Neal and Mr. Blumenthal, whether they wanted to add anything to that point.
Yeah, I would like to. I think that it follows on from the point about the quality of legislation, that the Parliament should be very reluctant to take away very important principles such as self-incrimination and client privilege without the most careful consideration. One shouldn't imagine that everyone coming before these commissions has done something corrupt, and one should always be conscious of the tendency in some instances for these bodies to basically become very overbearing. If we think just recently about the case of Bernard Collaery, could it be contemplated that someone such as he would have gone before this corruption commission, but without the right to client legal privilege and without the right to the privilege against self-incrimination, keeping in mind too whether these powers will be struck down by the High Court anyway on the basis of the cases that I mentioned to you earlier. But I have actually represented people in similar hearings. They are very much alone in the world. They will often be surrounded by stringent provisions about whom they may communicate with anyway, and they will be confronted by a range of professional investigators and lawyers for the Commission, basically on their own. Now, that is something which requires the most serious consideration, in particular when you are considering, or the Parliament is considering, revocation of those principles which have been very strongly part of our legal and justice systems for hundreds of years, have recently, it's admitted, been revoked in some instances by the Lake Act and by corruption or crime and justice commissions in the states. But if you are concerned as the debate has gone on about public hearings because of the effect they may have on people, consider it perhaps if you found yourself in front of one of these bodies without those sorts of protections and without legal assistance in terms of financial assistance. The balance really between the power of the NAC and the people who are coming before it needs to be very, very sensitively considered and certainly not taken away as it is in this legislation in relation to self-incrimination and legal professional privilege.
I don't see, but sorry to interrupt you there.
No, sorry, please go. Yeah.
No, I don't see the public policy justification being provided in the explanatory memorandum for the abrogation of privilege in the form that is contemplated by this bill, particularly when you compare that to other legislation such as the Royal Commission Act, or perhaps in Victoria the Independent Broad-Based Anti-Corruption Commission, where they recognise that privilege remains a valid claim and even provide a reasonable excuse for not producing. Here we don't even have a reasonable excuse in this legislation for not producing based on a valid privilege claim, and that extends to, I think I saw some questioning previously in relation to the requirement to provide identifying details of a client, for example, and I know that's a narrow aspect of client privilege claims, but the common law courts recognise that there is an exception to the proposition that client information identification is generally not privileged, but it is where the communication has already been disclosed such that the identification of the client amounts to disclosure of confidential information. So where the client identity is so intertwined with the confidential communication, the disclosure of the identity would be the disclosure of the communication. And we refer to Coombs' case in the submission, but this bill just wipes that out. And it gives, and then it says to a solicitor who might object to disclosing that because it would be to breach the common law rule in Coombs, well, you don't even have a reasonable excuse for maintaining that, and you can't claim privilege over something that the law recognises as privilege. Other legislation maintains a reasonable excuse defence. A solicitor will be in contempt otherwise. But coming back to your earlier question about the genesis or the fundamental underlying premise of things like client legal privilege, probably one of the more recent discussions of it is in the Glencore case, where the High Court dealt with the Commission of Taxation. And what they discussed there is this concept of client privilege is itself a response to the exercise of powers by the state to compel disclosure of confidential communications between lawyers and clients. And that's the genesis and the birthplace of this very important privilege, which has been described obviously as a fundamental right, not only to persons but also to our legal system, and a practical guarantee of fundamental constitutional or human rights. And where a parliament seeks to remove that or abrogate that, there has to be a very strong countervailing public interest, I submit, shown. And if I look into the explanatory memorandum, I don't see that when I compare that to other forms of coercive powers, such as in the Royal Commission Act or the Victorian IBAC Act, where they do balance the rights of the citizens and the state, and do permit valid privilege claims to be maintained in the context of corruption investigations or even royal commissions, which I read yesterday one of the witnesses compared this to. So, I mean, it's a very, very important immunity. It's not a sword. It just acts as a shield. It only is a shield against the compulsion for disclosure, and it's there to encourage people to retain lawyers and make full and frank disclosure of all the relevant circumstances to their lawyers so they can get legal advice on things. And even in Europe, the European Court of Justice regards the protection of legal confidence as a characteristic function of a democratic system. And when we see it being eroded in a very broad manner such as this, it is an erosion of a characteristic function of a democracy.
Thank you very much. Thank you, Chair.
Thank you.
Can I just briefly add? I know we're
running on out of time.
Really briefly. really importantly, I'll just direct the committee to Part 7, Division 8, the interaction between criminal procedure and confiscation proceedings in relation to this. And I'll take directly from the explanatory memorandum 7.553, points out that there's limited provisions that enable information sharing and use of derivative material in the event that some of the exercise of those powers or some of the uses of the material are declared to be invalid by a court. So it further emphasises the extent of the erosion, we say, of the right. So I'll just point the committee to that and leave it there.
Okay, thank you. Look, again, can I just join with the rest of the committee in thanking you for your comprehensive submission. The Parliament benefits greatly from the Law Council's engagement with its committees, and I want to acknowledge that benefit and thank you for your continuing engagement through your submission and appearance today. And it is our hope that I know that you have been an active participant in the discussion about the long-awaited National Anti-Corruption Commission, and it is our hope that we can bring to fruition the best NAC that we can. But we have certainly listened to what you have said and read your submission, and again, thank you for your time in being here. You have, I think, been asked to provide some additional information. Would you please forward it to the Secretary within 5 days from today, if possible? You will also be sent a copy of the transcript of your evidence, and will have an opportunity to request corrections to transcription errors. So again, thank you very much for your appearance here today.
Thank you.
Can I now ask Mr. Bruce McClintock, SC, to give evidence?
Thank you very much for allowing me to appear here. Could I just get myself a glass of water? I'm seriously from hay fever, I'm afraid. I'm worried that I might lose my voice in the middle of talking. Could I say a couple of things? Do I need to be sworn or anything?
Yeah, I'm going to give you a warning. So, although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts a parliamentary privilege. Can I apologise that we're running slightly behind time, but you can understand there are significant matters that we are discussing with a range of witnesses. Can I now invite you to make a brief opening statement before we proceed to discussion?
I will make a brief opening statement. I wanted actually to deal, before I actually make the opening statement, with something I heard fall from the Law Council, which, with great respect to them, I think is plain wrong. It's the issue of, in section 43, of the use of the word could involve corrupt conduct. That's an issue that I've looked at in New South Wales myself, because the legislation is exactly the same. The legislation has to use that word. There's no alternative, and I'll explain why. There's no possibility of it working rationally on the basis of reasonable suspicion. As I said, I've actually made a report to Parliament in New South Wales about this. I might say that Chris Merritt, who I understand gave evidence this morning, wrote a column a couple of weeks ago that again completely misunderstood the issue. The point is this: take the analogy of a police officer sitting in a police station. Someone comes in and says to him, "There's been a smash and grab down George Street at Cartier's." Now, at that moment, the police officer has no state of mind except someone has come in and told him there's been a smash and grab. At the moment he walks out the door of the police station, he's commenced an investigation. He doesn't have to have any state of mind except that the information he's been given could involve the commission of a crime. That's the trigger for the start of the investigation. When he gets down to even when he gets down to Cartier and he sees that the window is broken, it may not be a smash and grab. It might be someone who's actually accidentally run off the road. The point about reasonable suspicion is that it kicks in, or its analogues or similar concepts kicks in when you come to arrest or charge someone. The analogy here would be with when the Commission determines to make a finding of corrupt conduct or perhaps even hold a public hearing. But to commence an investigation, which is what Section 41(3) is about, cannot involve any criterion of reasonable suspicion. It just has to be that the information given to the Commission, if it turns out to be true, could involve corrupt conduct. That's the word that has to be used. There can't be any other way of doing it. I've said this repeatedly in New South Wales, and it does tend to fall on deaf ears, which, may I say, and I'm not here to big note myself, I really am not. I've been involved in this area for 20 plus years now. There's no issue in the legislation or in the actual operations of these agencies or similar agencies that I haven't looked at some stage. Twice, I might say, in 2005 when I did the inquiry into the New South Wales ICAC Act then, under the Carr government, and then in 2015 when I did it with Mr Gleeson, the former Chief Justice, under the Baird government, the same issue about the controls on public hearings and inquiries came up, and on both occasions we considered it and came up with something very like, may I say, what's in section 73(3), but without the exceptional circumstances criterion. Now, can I say one thing about that? And I appreciate that I'm not here to talk generally about... I appreciate the reason why the committee wants me is to talk about the role of the inspector, but there is a real factor that I don't recall, and I haven't been reading all the Hansards, obviously because of my interest in the area. I've been following the committee hearings. But there's a real point about having public hearings that I can't speak for Mr Gleeson, the former Chief Justice, I can speak for myself. The decisive factor in my mind in wanting public hearings and leaving the decision to whether to have them to the Commissioner, with taking into account the criteria that appear in New South Wales in, I think, Section 31(1) of the New South Wales Act, but are roughly similar to what's in Section 73(3) of the bill, was the fact that it is extremely dangerous to allow agencies like that to conduct their operations in secret. You must expose them to public scrutiny, and you must expose how they carry out their operations to public scrutiny. And the only way you can do that is by having public hearings where the press can go along. If I were to ask you, each member of this committee, why you think that reputation issues have been, say, sacrificed in New South Wales, the reason why is they've been reported in the press. And the operations of the New South Wales ICAC have been made available for public scrutiny. That's the reason why the concerns that have been expressed about the Commonwealth Agency have been expressed, because people know what's been going on in New South Wales. I might say that, in fact, there's nothing wrong with the New South Wales legislation at all. The problems with agencies like this, and there are limits to what you can do with legislation. I hope I'm not sounding that I'm being too didactic or lecturing, but the real point is that ultimately the quality of these agencies depend upon the people who are appointed by the government to run them. And if you appoint a zealot to run an agency like ICAC, you'll have problems, obviously. If you appoint counsel assisting who want to grandstand and get their name in the paper, rather than behaving like prosecutors are supposed to behave, which is fairly put the evidence before the tribunal, you'll get problems. Now, the legislation there's no way that an Act of Parliament can control, except by specifying in broad terms, the people who get the job, qualified to be a judge of the High Court or the Federal Court of Australia and so on, as is in the bill. But that's the real thing, and that's where agencies like this go wrong and cause problems. It's not so much because of what's in the Act. And it can be a very serious problem or serious deficiency to try and be too prescriptive about things like putting in exceptional circumstances and so on. Ultimately, you have to appoint the right people and trust them to get on with the job. If you appoint the wrong people, it won't matter what's in the legislation, I'm afraid. I'm not suggesting that... I do remember one particular commissioner when I mentioned to him during the course of the 2015 inquiry that the Hong Kong ICAC has its own armed and uniformed police force, his eyes did light up. But I'm not suggesting that it should happen here. But that tends to illustrate the problem. I've strayed a little bit away from what I wanted to say in opening, but although I did want to deal with the point about about public hearings and so on, and the essential nature of public scrutiny. As for the role of the inspector, I think personally that it's absolutely critical, given the various other controls or limitations on control of an agency like this, that the inspector be placed proactively in a position to deal with problems that come up inside the agency. You can give that various names. In my submission, I called it an audit function, largely because that's what it's called in the two pieces of New South Wales legislation that I've had to deal with as Inspector of ICAC from 2017 to 30 June this year, and now as Inspector of the Law Enforcement Conduct Commission. But there's no particular magic in words. It's just that the person, the inspector, should be empowered to be able to intervene in the operations of the Commission if he or she thinks fit. I am aware, and I know there was evidence this morning about this, that the Commonwealth Ombudsman has certain specific audit functions, but those are very limited and very technical. And I had something completely different in mind when I said what I said in the submission. The Commonwealth Ombudsman will audit and already audits along in relation to the other agencies, telephone intercepts, controlled operations and so on. In fact, my office as Inspector of LEC in New South Wales has the same function in relation to all of the New South Wales agencies that carry on similar powers. The powers in question are to monitor technical compliance with the legislation, like are the requirements to get a warrant for a telephone intercept under the Telecommunications Interception and Access Act, have they been satisfied? I had something much broader in mind, which I think actually is fundamental. And I can probably illustrate it best by explaining what I did when I was inspector and what my successor is doing now. In New South Wales, as Inspector of ICAC, I carried out an audit of the conduct of counsel assisting in a couple of inquiries because I was sufficiently concerned about what I'd read as to what was going on to think that I should actually look at it in my capacity as inspector. The reason why I had to do it in the way I did was because of it's not so much a technicality, because of an issue with the New South Wales Act. Counsel assisting at an ICAC inquiry is not an officer of the Commission, and therefore the inspector has no direct jurisdiction over counsel assisting. The inspector does have jurisdiction, though, over the commissioner who was presiding, because that person is an officer of the Commission. And so if there'd been a wrongful failure to supervise the counsel assisting by stopping him being rude to witnesses or insulting and so on, or being unfair, that could amount to misconduct on the part of the Commissioner. And I only came to the conclusion that I could not make a finding of misconduct against the Commissioner, but I did describe the conduct of counsel assisting in the particular matters as unfair and inappropriate. Now that's a proactive thing, and I did it. The issue was passed, but I did it because so that the Commission going forward would have a report, my report, that they could show to barristers who were going to be counsel assisting and saying, that's not how you do it. You do it like the inspector said you have to do it. You behave like a Crown prosecutor. You behave fairly and impartially, and you don't unduly try and prejudice people. My successor as Inspector of ICAC, Gail Finesse SC, is presently carrying out an audit in relation to ICAC and witness welfare, the welfare of witnesses in inquiries. That's something that I wanted to do myself, but I didn't get around to it because of timing constraints and so on. And because unlike now, up to June 30, I had an active practice as a barrister. I don't anymore. As you know, there have been a number of suicides of people involved in inquiries. I'm not trying to minimise it in any way, the sadness of that, but they were all people who were peripherally involved in the investigation. I remember absolutely vividly, back in the early 90s, I was counsel assisting myself in an inquiry at ICAC into corruption within the town planning department at Randwick Council. And on the Sunday before the inquiry the public hearing was due to start, I got called into the office because one of the witnesses had committed suicide the day before. He was not in any sense a target of the investigation at all. He was a solicitor. I had the harrowing experience. He recorded his suicide note on a tape recorder over about 40 minutes. I had the harrowing experience of having to listen to it. But surprisingly, it is the people who have self-harmed in relation to these inquiries have rarely, to my knowledge, actually been the primary target. They're always people caught up, like the one in the inquiry into the Wang Jiangmo funding, Labor Party funding issue in New South Wales. But the next thing I'd like to say about the role of the inspector, and I'm sorry if I'm straying, is that while I'm aware that the Ombudsman is the inspector of the ACT ICAC, I don't think that the Ombudsman is the appropriate person to be inspector of an agency like NAC, the new agency. You need someone who can talk on equal terms, so to speak, with the Commissioner, and who you need to be effective in these roles. You need there to be a relationship of trust and frankness between the Commissioner and the Inspector. The way I've always seen it is that the attitude of the Inspector should be one of it should be cooperation, but not capture. You do not let yourself become captive to the agency you're supervising. You need to have a mutually respectful relationship, but you don't want to. But you don't ever let yourself or your independence be compromised. Now, as I said, you need someone who can meet on equal terms, so to speak, at least equal terms with the Commissioner, and whom the Commissioner can take notice of. Someone like that really needs to be a special purpose inspector of this agency. I don't think there's any way around it. There are other things I
think we might get to our questions if we can.
Yeah, I know. I am sorry. I've carried.
No. What you're saying is extremely important, and I for one am quite happy that you strayed outside what you were saying. But I know that there's and we are interested in the inspectorate. But and feel free to go to other matters. But I think there are some specific questions.
Fire away.
But I for one am quite happy to have heard what you said about other witnesses, because it allows us to pause to reflect on what others have said. Many people have referred to your submissions, so in support mostly, I think, too. So we're quite interested to hear from you about that. So can I ask Senator Scarr, I think, did have some questions to start us off, and then we'll ask others to do so as well.
Yep. So thank you very much, Mr McClintock, and I for one really appreciated your submission.
It's a pleasure, and may I say this: if there's any assistance the committee feels it needs in future, I'm happy to help. I mean, in many ways this is a once and once only opportunity. Once you get the act in, it's very hard to change it, and I'm happy to help.
So I wanted to give you an opportunity. You made a very strong statement in your submission that certainly captured a lot of people's attention, and I'll quote it for the benefit of Hansard. Unfortunately, Part 10 as presently drafted is defective and not fit for purpose. It addresses a false issue, corrupt conduct within the NACC, and fails to give the inspector the essential power to ensure that the NACC both complies with the law and behaves fairly, end quote.
Yeah.
So I just want to give you the opportunity to put on the record how you think the draft bill missed the mark, as it were, in terms of the role of the inspector and what we should consider the role of the inspector to be in this regard.
I'll put it this way. The false issue I was referring to was, of course, the corruption issue within the agency. When you look back at the definition of corruption, that is never going to occur inside an agency like the NAC. I hope you don't mind me calling it the NAC. I assume that's how you...
No, that's been our term.
You see, it's not the bomb. you're putting a judge or a judge equivalent in charge of the agency. A very senior legal practitioner. And the thought that there'll be actually corruption within the anti-corruption agency is just fatuous. I've been looking at these agencies, I've been looking at the New South Wales one for 30 years now. It never happens like that. Those are not the problems. The problems are, as I said in my report, incompetence things. You know the old line, if you've got a choice between a conspiracy in Australia and a stuff-up, go for the stuff-up every time. It's always the stuff-up. You've got failures to accord procedural fairness to people. You've got unfairness by counsel assisting because barristers are barristers. They like the showtime. That's the things that you want. They're not corruption issues. They can be misconduct issues. And the defect in the legislation I saw was to put something in and give it major prominence, the agency corruption issue, I'll call it, which will never happen. It just won't. And fail to focus on the things that the inspector can really do that can make this agency work properly and effectively and fairly. You are empowering an agency with major powers, like the power to overcome the privilege against self-incrimination, which I might say, if you don't have the power if the Commissioner doesn't have the power to do that, you might as well not have the agency. He's got to have that. I don't have a view about, I was thinking of the law code, I don't have a view about the privilege against the legal professional privilege, although I could see some problems if you did try and abrogate that. But the privilege against self-incrimination you must have that, you must be able to overcome that to have an effective agency. Of course, you wouldn't be able to use the evidence in subsequent proceedings. That's a different matter. But you have an immensely powerful agency. The courts are not a good way of controlling agencies like anti-corruption agencies. Why? Because they've only got the administrative law remedies. They can only intervene basically if there's been an error of law or something like lack of procedural fairness. The inspector is cheaper, and because he's funded by the government and can deal with complaints of misconduct or unfairness with at much less cost and, may I say, much quicker generally, although if you check back on the history of my inspector, there were issues about delay in determining things before I became inspector. But it's much cheaper, much more effective to have a person like that who can do that. The second point, and this is the point that I really was trying to emphasise in my opening remarks, is the audit power. You need something so that the inspector can proactively intervene to ensure that the agency is conducting itself, I'll use a general term, properly.
Just drilling down into that particular point, that audit power, as you describe it, is important. Otherwise, the inspector is just waiting for a complaint and reacting to a complaint.
Yeah, exactly. But you also need, and I think this is in part 10. You also need the power, a power to the inspector to act of his or her own motion. And you could put that in the complaint section so that it's really the commissioner, the inspector, making a complaint to himself. I'll give you an example. I'll take it from, if I'd been inspector in 2014 when the inquiry into Margaret Cunneen was announced in New South Wales, I went on record in the press at the time as saying I did not think that investigation should have happened because it did not meet the criterion of serious corrupt conduct or systemic corrupt conduct, which I might say that language I was responsible for introducing into the New South Wales Act in 2005, in the 2005 report. I said publicly that at the time. Now, if I'd been an inspector, as I became 3 years later, I would have called for the papers of the relevant committee of ICAC that had made the decision, and I would have investigated whether I thought that decision was appropriate. It may not have amounted to misconduct, but then I could have turned it into an audit report and examined the basis of it and whether I thought it complied with the direction in the legislation about serious and systemic corrupt conduct. It's those situations where you need that kind of proactive power, so that the agency is kept properly under control. Now, hopefully, I have to say those powers probably should be used rarely. It probably will be used rarely, given the calibre of the people I expect to be appointed as the senior officers and commissioner of the agency. But it's still important that it be there. Because human beings are human beings. They make mistakes. I have the greatest respect for the then Commissioner of the New South Wales ICAC, but I personally thought at the time it was a mistake to carry that investigation. It should have been investigated.
So then, Mr McClintock, in terms of the types of complaints that the inspectorate should consider, so you talked about first the audit function, but secondly, there is a role in terms of considering complaints. Your submission indicates that the type of complaint that the inspectorate considers should be defined in such a way that the inspectorate is not considering things like, which I would call human resource type issues that might go to the Fair Work Commission, or other such administrative matters dealing with the internal administration or human resources of the Commission. Is that correct?
That is correct. The reason why I suggested that really I really came to understand why you should say what types of activity that should be the subject of complaints is because in my capacity as Inspector of the Northern Territory ICAC, I was getting complaints of workplace bullying and harassment from employees within the Northern Territory ICAC. Now, I'm not equipped personally to deal with those matters. I'm a lawyer, and also I might say in the Territory there's an exceptionally able Commissioner of Public Employment, and I was able to refer those complaints to her to deal with. But it would be much better if those complaints went directly to someone with the expertise, rather than the inspector, who I see as having a distinct function, basically of dealing with, of making sure the agency behaves with propriety, in both ways.
Can I go quickly to some of the other points you've raised, which haven't been canvassed?
Because I think others do want to
all right, I'll try and do it as quickly as possible. You note that Clause 183 of the bill. You note Clause 183 of the bill, but you submit that there should be a provision that provides specifically that the inspector is not subject to the NACC itself.
Yes.
The question has been posed, and I'm not sure if you heard the testimony earlier in the week from I think it was the Victorian IBAC Commissioner, that there needs to be some sort of oversight of the inspector or inspectorate, and it begged the question in our minds, well, who watches the watchman? Who's watching the watchman?
I'm giving a speech next week called Quis Custodiet Ipsos Custodes, who guards the guardians. In fact, about the roles of inspector. You're absolutely right, and I'm not unsupervised in New South Wales. There are two supervising agencies. There's the Standing Parliamentary Committee, and if I actually engaged in some form of corrupt conduct myself, I would be liable to investigation by the New South Wales Ombudsman. And I would have thought that the person to investigate the NACC inspector would be the Commonwealth Ombudsman. Okay. I would not for a second suggest that the inspector should not be subject to his or her own integrity supervision. Plainly, he or she should be. Is
that role of the Ombudsman, is that something that should be specifically contained in the bill, do you think? Do you think it's covered anyway?
I think it's covered anyway, but it would be, but it might be prudent to make absolutely sure about that, because you'd never want someone with the powers of the inspector to be completely unsupervised. I was going to say something else about that. It's really about the reason why you need a provision like that. There have been situations where, particularly in New South Wales, the relations between the Commissioner and the Inspector were poisonous, and that's an absolute disaster. It really is. And while it never happened, you wouldn't want the Commission suddenly deciding to pull the Inspector in and have a little conversation with him about the performance of his role, subject to the compulsory powers. And that's the reason why you really have to have a provision, I think, like saying that the inspector is not subject to the commission itself. If you added there, but is subject to the ombudsman obviously in more parliamentary or legislative language than I've just expressed it, that I'd have no problem with that at all.
Thank you, Chair.
Dr Haynes?
Well, thank you very much, Mr McClintock, for your submission, which has been enormously helpful, and for your witness today. And thank you for your opening statements, which also clarified some issues we've been discussing for a few days. You just touched on the Parliamentary Oversight Committee, and I'm curious as to your opinion on the legislation as drafted for the Oversight Committee and your views in regard to the depoliticisation of the appointment of the Commissioner and indeed the Inspector. So your views, as this is drafted at present, there would be a government chair with a casting vote. There have been other models proposed whereby two members of the government and two non-government members might decide or have some decision-making power, or that there be a non-government chair of that oversight committee. Do you have a view on that?
I have to say that, and this is based on my experience, the model in New South Wales and in the Northern Territory is a government chair. The government has the majority in the reps or the Legislative Assembly, and therefore has the power. I have honestly never noticed any political bias whatever in their conduct or their supervision of my office and of the ICAC. Not at all. I've only ever seen a desire on the part of the members of the committee to do the very best they can by the agencies in question. Not everything that they've said have I agreed with, but I've never had any cause to doubt their sincerity, or to think that the fact that it's done, that there's a government majority or a government chair, has impacted on their role at all. And in fact, in many ways, depending on what's actually been happening with the agency, you'll find the government members are the more hostile towards the agency than the opposition or the crossbench members. But I have to say that I think that's one of those areas that look significant now, but probably will not turn out to be significant. I could be wrong, and perhaps something might be said in favour of removing the possibility right now. But I don't have a strong, based on my experience, I don't have a strong view about it. I have to say that I'd appeared in parliamentary committees as a witness before commencing to deal with the New South Wales one in 2017, and I've got to say that one of the things I learned is what a powerful instrument for democracy the committee system actually is. I have been really impressed, and I don't think there'd be any difference. I don't think there'd be any difference in this place than there would be in New South Wales. I really don't, but. I'm not quite sure that was what the answer you wanted, Dr. Hayes. But
I love an optimist.
Well, I appreciate it. It is an optimistic view,
yes,
but it is based on experience. But as I said, on the other hand, there is merit to say to be in avoiding the problem now. I can understand that. I don't have a strong view. Either way. I do think that whatever the composition of the committee is, it'll perform its functions admirably.
I guess goodwill could go either way with whoever's chairing a committee or whoever has a casting vote.
I mean, look at all you got to do is look at the way this committee's been behaving. That's been impressive, I have to say.
Mr. McClintock, I mean, self-praise is no recommendation, I might say. But Mr. McClintock, could I ask just further to that your opinion around parliamentary oversight and the budget for this proposed National Anti-Corruption Commission? Could you share your views on that, please? And you know where I'm going. I'm curious to see the sanctity of sufficient resourcing for a NAC into the future.
That's absolutely critical. I don't know whether you're familiar with the debates in New South Wales and what happened there. There was an Auditor General's report 2 years ago, which I shouldn't be unkind, but I think the then bureaucrats expected to be a hatchet job on ICAC. It turned out, and its budget practice, it turned out to be just the opposite. And the New South Wales Auditor General recommended budgetary independence for the agencies in question, ICAC, Law Enforcement Conduct Commission, and so on. There are different models you can have. Ultimately, there's got to be parliamentary oversight of the budget. Personally, I would take it away from the. I would have some form of independent modelling away from the executive, because it's always very tempting, even for reasons not involving a desire to control or restrict the operations of the agency. It's always very easy to think, okay, well, we've got to cut something in this budget. Well, we can shave. We'll put in an efficiency dividend, a misnomer if ever I heard one, and slice 10% off the budget, and that can be very hard. It could be in New South Wales. That led to the New South Wales Commission it had three investigation teams, and had to cut them from 3 to 2 as a result. And that should not happen.
Could I ask you would the Parliamentary Budget Office be such a place that kind of independent modelling could take place?
I think the members of the committee would know the answer to that question better than me. From what I understand, it probably would be a suitable place. Although, as I said, my knowledge is fairly limited. But I'm less concerned with the actual model, provided there is an independence from the executive and an oversight by Parliament itself. Perhaps it might just be the Senate of the.
Some people have suggested a tribunal.
Oh, you can over-egg this pudding. You can go too far. Like, I saw one proposal to have another judge approve of the decision to have a public inquiry. I don't know if you've appointed a judge or an ex-judge as the commissioner. I don't know why you'd put another one there. The inspector might have a role if in certain circumstances. And I might say in New South Wales, I know I'm straying for your question, Dr. Haynes, but before the inspector was created in 2005, there'd been a thing called the Operations Review Committee, which was made up of people like the Commissioner of Police, the head of Department of Premier and Cabinet, worthy citizens, and so on, who had oversight of the Commission decisions, including the decision to hold a public inquiry. Now, what had happened was, because of the amount of work that the ICAC was doing, it became completely impractical to continue. It just ceased to function properly, which is the reason why I suggested the introduction of an inspector. The office wasn't given the specific powers of dealing with having public inquiries, but as I said, in certain circumstances, that's something I would have intervened with had I been around in terms of the Canini case.
I forgive you for straying from my question, just to hear your view on that a further judicial oversight of a public inquiry. Can I just ask you, given your comments then about the budget and about budgetary efficiencies, in your experience as Inspector of ICAC in New South Wales, do you think it's suitable that this National Anti-Corruption Commission inspector role is part-time, as is suggested in this bill, or should it be full-time?
The option is there for it to be part-time or full-time. That leaves it up to the Attorney-General to make the decision, and that's specifically in that provision. I'm inclined to think it might be worthwhile leaving it as it is for this reason, Dr. Haynes. It's going to be, well, let me explain the issues as I see them. In New South Wales, I was able to do that job 1.5 to 2 days a week. It was part-time. That meant that sometimes when I was running cases in my practice as a barrister, that I wouldn't do anything for 3 weeks, except on weekends or when something urgent came up. But then I give 5 days to it. The workload as Inspector of the Law Enforcement Conduct Commission is actually heavier, but it's not full time. The inspector, the job as inspector, I think, at the start, will be mainly setting up an office, getting the right people, working out how many people you need, but it will take time, probably some years, before the flow of work coming in from the Commission, because it will take time to get going too. Although I appreciate it is also taking over an operating agency now, ACLI. So I suspect that that in the early days it would be appropriately to be part time, but that's the sort of thing that I would have thought should be left to deal with to the people in question. And you'd hope that if the inspector said, well, I've been able to do it 2 days a week now, Mr. Attorney, but now I think it really is time for it to be a full-time job, and then change like that. I think I'd leave the flexibility there and leave it up to the people, Dr. Haynes.
Can I ask a follow-up question
Sure,
just on that?
yeah.
We had evidence from the Victorian Inspectorate, Mr. McClintock.
Mr. Moran?
No, actually, the Executive Director, I think, of Legal. And they said the Victorian Inspectorate has a wider remit.
Yes, much wider.
However, they estimated that 40% of their time was dedicated to discharging their obligations with respect to IBAC,
yep.
And they had a complement of 27 full-time employees, which indicated to me that it is going to be important that the Inspectorate is appropriately resourced, and there's at least a body of experienced people who are there working full-time, especially given when this kicks off. It's going to be so important that the Inspectorate is right on top of everything that's happening from day one. That's my concern. Your reaction?
I agree completely. What I'd envisage is that whoever was the inspector would spend probably 3 to 4 months getting the office set up, then review the situation, and that might well be full time. Then you'd expect the inspector to make a decision at that, having got the people he or she needed, to make a decision then as to whether by that point there was enough work coming through from the Commission to warrant his or her full-time appointment. But you'd imagine that you would want a number of full-time employees of a relatively senior level. In New South Wales, because of we are trying to do it efficiently. I share my staff with the Inspector of ICAC, and there are putting aside the staff that I have who do the monitoring of the TIs and the controlled operations and so on. I have 2 staff. A principal legal advisor whom I share with the ICAC inspector, and a business manager who I also share. Okay. Now, I don't think with an agency the size that the Commonwealth Agency is going to be that level of support would be appropriate. Okay. I think you're going to need more.
Okay, Ms. Lawrence, have you got a question?
Yeah, sorry, Patricia, we've only got a couple of minutes left. So I just had 2 questions, if we can squeeze them in a couple of minutes. I've
got as long as you want.
No, but I think we've got another person coming straight on. So I was interested in your suggested clause, amendments to clause 184. And in the 1A of that, you speak to auditing the operations of the NACC for the purpose of monitoring compliance and detecting agency maladministration and so on. And I was just concerned to understand when you say auditing the operations that that's not limiting to looking at the decisions of the Commissioner. As in, like, I just want to see, is that broad enough to say, is operations also include?
I would have thought so.
Okay. Because when you just have monitoring compliance with the laws, I just thought, well, because just for context, so we heard from the Commonwealth Ombudsman who spoke to his role in relation to the NAC and in relation to oversighting the, again, the operations of the Commission, making sure that also that they're in compliance with the law. But he doesn't go to assessing the decisions of the Commissioner.
There might be slightly different issues in relation to decisions, but if it were appropriate, I did not intend to exclude that. In New South Wales, I had complaints about decisions that had been made, And I've had, and as Inspector of LEC, I've had complaints about decisions that have been made. And in one case recently, I can't give the details. I instructed sorry, that's not the correct way. I recommended to the Commission that it reconsider the decision it had made. I have a power to recommend, and if they don't accept my recommendation, under the legislation, I can require them to explain to me why they didn't accept the recommendation.
So that currently the bill doesn't allow for that, and does your clause amendment address that?
I certainly intended to do it. I think that's probably a good example of the fact that one mind can never cater for every possibility that may be thought desirable. But I certainly didn't intend to exclude anything. I thought the inspector should have the role to cover every activity of the agency.
And the other part of my question was, we've heard from, I think it was actually in the context of Victorian Inspectorate, that having the capacity to be that where the Commissioner is required to give notice of intent to, say, for example, use coercive powers, rather than auditing them after the fact. So I just wondered whether you saw that as a role that you would want to see included in this inspectorate.
There's never anything wrong with having an obligation to inform, because if you have an obligation to inform the inspector can then make a decision as to whether he or she wants to intervene. And I might say that I can see a benefit for having such a notification regime, because it gives early warning. And when you think, the Cunneen case provides a good example. If the then inspector had been informed in advance of that decision, he could have intervened at that stage if it thought appropriate. I'm only using that as an example, of course, but sure. No, I agree, in other words.
Thank you very much. Thank you, Chair.
Senator Shoebridge.
Thanks, Ms. McClintock, and nice to see you. I think there are powerful arguments to say there should be a full-time inspector, but one of the arguments against, and particularly if additional work is given to the inspector in the course of amendments if they're accepted. One of the arguments against that might be, given the nature of people you'd want to have as inspector, potentially senior members of the legal profession who may have multiple interests, if you insist upon it being a full-time position, you may limit the gene pool.
That's very true, Mr. Shoebridge, but that relates to something that I've said on many occasions. But the gene pool for these positions is pretty narrow already. Qualified to be a judge. And governments always think that the old phrase, none of them got sacked for buying IBM. It's probably not very informative in 2022. But no government ever got criticised for appointing a retired judge as commissioner. And they're not necessarily the right people to do it. They're managing a substantial government agency for a start, and they don't have administrative experience. They've just been barristers like you and me, and where you're just running a cottage industry with a personal assistant, and it doesn't equip you to manage a government agency.
This one's a politician now.
Yeah. Well, I accept the managerial description of the profession up to this point, 100%. Yes.
But the attraction for me originally with being Inspector of ICAC New South Wales was that I could do it part time and still carry on being a barrister. And I appreciate your point. That's probably another reason for leaving it flexible. But then on the other hand, the other thing too, I've got to say that I'm probably the oldest person in the room, so I can say it. The other problem with using retired judges is they tend to be in their 70s. If you could get someone young and able and in their 50s, you're doing better. There are issues about these things.
We saw their IT skills. Really first class.
Well, that is true.
That's right. But I do like my favourite evidence today has been young and able in their 50s. I really endorse that.
Well, actually, Mr. Shepherd said it right. I actually mean it. As you get old, you get tired. But I probably shouldn't stray from the topics that you're asking about. But I understand the problem. Whether given the constraints of the office, it can be possible to do it part time is a different matter. It's going to be supervising a big agency, and it's going to be important to do it right. I mean. The other issue, of course, is if it's full time, it'll have to be in Canberra, full time in Canberra, and that itself can cut down the gene pool. No,
massively.
Mr. Zappy, did you have any questions?
Perhaps just one.
Who would?
Mr. McClintock, I appreciated your opening remarks where you talked about the nature of the character of some of the appointments to these positions. Is it your view that the section of the proposed Act which deals with the removal of people from this office should or could be expanded?
Oh no, I don't think that. No, you've got to put them there, and only. What is the provision? I have looked at it.
Yeah.
It's an address of both houses, isn't it?
Yeah, it has to go to Parliament.
Yeah, it's an address of both houses. It's the same basis as
Clause
removing.
250.
It's the same basis as removing a judge from memory, or something very, very.
It's very similar, and I don't know the details.
You see, there's. An address of both houses, and it's misbehaviour and so on. I would leave it as that. That you've got to have the protection of the person, of the head of the agency from removal, by if he or she does something that the government finds unattractive or a majority finds unattractive. I don't regard that as a remote possibility. If you think, well, it wasn't removal of a commissioner, if you think about how the South Australian agency was neutered by almost unanimously by every member of the South Australian Parliament, and that, I only use that to illustrate that there's a real risk. I would leave that as it is. It's too dangerous. You see, you're putting the commissioner in there to make unpopular decisions. You want him to do that. You know, it's what the agency comes with. I mean, the decisions in New South Wales to investigate Gladys Berejiklian was not a popular decision, but it was the right one in the circumstances. You know, but it wasn't popular with the people in general because she was a very popular premier. But sometimes the agency has to do things like that.
This is also why you have a prohibition on reappointment.
Absolutely.
Because it can't be curry in favour for reappointment.
Absolutely. There's got to be a limit. I actually think the inspector can be 10 years under legislation. I'm not sure that's not too long. I would like very much another term as inspector of the New South Wales ICAC, but I was content with the 5-year term limit. You've got to have something like that. I shouldn't speak in. I do sound as though I'm lecturing you. I don't mean to, but I regard that term limit as absolutely imperative.
Thank you.
Thank you. Can I just summarise a couple of points that you made just to make sure that I've got that clear? What you say about section 184 1E1, basically about the functions of the inspector, is that you believe that we should have there should be the ability to do things of your own motion, not just by complaint. Is that what you're saying?
My primary problem with Section 184 is that it shouldn't have the stuff about corrupt conduct at all.
Right.
It should have something along the lines of what I put in the submission, that proactively investigate the activities of the agency to make sure it's complying with the law and behaving with propriety.
So it shouldn't be narrow about the corrupt conduct of I meant that.
Yeah.
The corrupt conduct of the organisation itself, but what it requires is this not administrative but wider view. As you say, it depends on personalities. It depends on exactly what you said. People who respect each other in the two positions, who are probably peers, who can go, it'd be like going in your chambers down to the next person, to the other SC down the road and going, what do you reckon about this? That's the sort of thing you're talking about, isn't it?
Yeah, it is.
Okay. And so it's saying, so you can't just look at the corrupt conduct, you've got to look at its operation and from a further away. And so can I just ask you that one example you did give us about what you did in relation to the council assisting. So that wasn't about that was nobody's complaint, was it? It was something that you observed.
Well, it did come out. It did come out of a complaint.
It did come
but
out.
But I didn't feel I could uphold the complaint. But I thought there was. the complaint was actually made by the former New South Wales Police Minister, Mr Gallagher,
Right.
who had resigned on the spot, in effect, after a counsel assisting had put to a witness, you and Mr Gallagher entered into a corrupt conspiracy to break the electoral laws.
Yeah.
And Gallagher resigned that day. I didn't feel I could uphold Mr Gallagher's complaint, but I thought there was something that had to be looked at, and in the conduct of counsel assisting, and that's why, prompted by that of my own motion, as it were, I undertook to audit what had happened in the inquiries involving that, and indeed other counsel assisting.
Yep.
I interviewed other counsel assisting and talked to them and so on.
Yep.
But it was done of my own motion, but prompted by a complaint.
Okay. That clarifies it. So, look, thank you very much for your attendance here today. We've very much appreciated your contribution and appreciate too that you went beyond your submission, but I think that was very timely in doing so, and I, for one, absolutely appreciated what you have had to say.
Thank you very much.
I don't think you have been. Were you asked for any additional information?
No, I wasn't. But if the committee wants any further information, I'm more than happy to ask it. I don't regard my role as just finishing right here and now. I mean, I've had I don't want to sound too pure or anything, because I'm not. But I've had a long-standing interest in agencies like this. I've seen them operate well. I've seen them operate badly. I know where the problems are. I've tried to control them. Sometimes I've succeeded. Sometimes I've failed. And there have been failures on the part of the inspector. But I do have an absolute commitment and belief in that an agency like this should exist, and that it should function properly. And I think the inspector is a critical part of making it function properly. And to make it function properly, the inspector's got to be given the right powers. And I don't think those powers in there now do. With great respect to the draftsman from the Attorney General's Department, that they don't really understand the issues that the inspector's there to deal with.
Yeah, no.
If you look back at the reports I did, you can see I thought about these things carefully, back in 2004-05. And
yeah.
Sorry, I'm delaying you getting onto the admirable.
No, we are. The human rights.
Professor Rosalind Croucher.
We've got to deal with somebody from overseas. But Senator Scarr has a question on notice.
Question on notice for you, Ms McClintock. I found your commentary in relation to the could argument very useful. I'm not sure Senator Shoebridge was here at the time, but I'm sure he'll find it useful when he reads the Hansard. Can I also ask you on notice to consider the Law Council of Australia's submission with respect to clause 9(1)(c), where they not now,
no,
we don't have
time.
time.
I'm sorry. I know you want to get rid of me,
but they're arguing that that lim 9(1)(c) of the definition of corruption issue should be removed from the bill. So if I can just ask you to take on notice.
I will.
And perhaps just a short expression of your view on that. I'd find that useful, as I found your other view with respect to could.
I know what the answer is, but I'll put it in writing.
Just for the record, I would have been here if I could.
Okay. All right. We're here all week.
It was an uncertain at the time.
Okay.
Senator, I'm a witness. You're a senator.
Okay. Finally, you will be sent a copy of the transcript of your evidence, and we'll have the opportunity to request corrections to transcription errors. So thank you again for being here. Can I now welcome the Australian Human Rights Commission, who've been patiently waiting to give evidence today. For the Hansard record, would you please state your full name and capacity in which you appear before the committee?
Thank you, Chair. I'm Emeritus Professor Rosalind Croucher, and I'm President of the Australian Human Rights Commission.
Thank you.
Thank you, Chair. My name is Lorraine Finlay, and I'm the Australian Human Rights Commissioner with the Australian Human Rights Commission.
Thank you, Chair. My name is Llewellyn Spink. I'm a senior lawyer with the Australian Human Rights Commission.
Thank you. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I now invite you to make a brief opening statement, should you wish to, before we proceed to discussion.
Thank you, Chair. I will take the opportunity to make a brief statement. The Commission supports the establishment of the National Anti-Corruption Commission and commends the government's commitment to strengthening corruption prevention across the public sector. In 2005, Australia ratified the United Nations Convention Against Corruption. The convention includes an obligation to establish entities or persons whose core focus is combating corruption through law enforcement. Establishing the National Anti-Corruption Commission will support Australia in complying with this and other obligations under the Convention, as well as the Convention's overarching aims. In February 2021, the Commission made a submission to the Attorney-General's Department consultation on the then exposure draft of the Commonwealth Integrity Commission Bill 2020. The Commission notes that many of the recommendations that we made in response to that consultation have been addressed in the current bills. The Commission supports many aspects of the current bills, particularly A, the equal application of the jurisdiction of the National Anti-Corruption Commission across the public sector, B, its ability to launch own motion inquiries and take referrals from members of the public. C, or thirdly, the safeguards around its independence. Fourthly, the protections for whistleblowers, witnesses, and people subject to adverse findings. And fifthly, its ability to hold public hearings. However, the Commission has some concerns in relation to some elements of the bill, which we've addressed in our submission. First, while we broadly support the jurisdiction given to the Commission, we are concerned with the scope of Clause 8(1)(e) of the bill. The clause provides that corrupt conduct includes any conduct of a public official in that capacity that constitutes, involves, or is engaged in for the purpose of corruption of any other kind. Sorry, Chair, I'm getting a lot of interference with noise. It sounds like there's a lot of papers perhaps being juggled in front of microphones that are live.
Yeah, I think the Secretary just might have stood up and shaken her papers, but she's gone now, so we've got the very, very quiet assistant.
I do appreciate, Chair, you've had a long day, a very intense hearing.
It's not finished yet.
We've listened in. I'm in Brisbane at the moment. Commissioner Finlay is in Melbourne, and Mr. Spink is in Sydney. And so we've been dialing in around the edges of our other commitments to hear the very excellent interrogation you've had of the witnesses. So, look, returning to my opening statement, the catch-all phrase gives the Commissioner a broad discretion to decide what falls within the scope of, quote, corruption of any other kind, and expand the jurisdiction without further parliamentary approval. Secondly, I won't be long. Secondly, the Commission has concerns with warrants being granted by nominated AAT members under the Surveillance Devices Act and the Telecommunications Interception and Access Act. Provide an additional level of protection, we consider this power should only be exercised by eligible judges. This would mean that warrants are granted by a person who is ordinarily a member of the judiciary rather than a member of the executive. We consider this to be appropriate in the circumstances where the National Anti-Corruption Commission, as part of the executive branch, is investigating the public sector. Thirdly, while we consider that the National Anti-Corruption Commission should have the ability to hold public hearings, We recognise the impact such hearings safety and well-being. Accordingly, in our view, clause 73(3)(c) should be a mandatory consideration of the Commissioner when deciding whether to hold a hearing or part of a hearing in public. We note that the Honourable Robert Redlich, AMKC, Commissioner of the Victorian Broad-Based Anti-Corruption Commission, raised similar concerns in his evidence. Fourthly, we consider that there is uncertainty around the requirement of exceptional circumstances for the holding of public hearings. In our view, clarification is needed to ensure that this requirement achieves an appropriate balance between the impact of such hearings on individuals and the interests of open justice. In conclusion, I would like to reiterate our support for the creation of the Commission and many of the protections for human rights that are provided by these bills. However, as I've indicated, we consider that some further protections or clarification of current protections are necessary. Thank you, Chair, for the opportunity to assist the committee.
Thank you. I might open the questions then. You've raised that issue of warrants for the NACC and saying that they should not be issued by AAT members. Why do you say that? And I guess, not putting an answer in your mouth, but is it because you're concerned about the politicisation of the AAT?
Chair, I will defer to my colleague, Commissioner Finlay. Our concern is that they not be members of the executive. Commissioner Finlay, perhaps I could invite you to answer the Chair's question.
Thank you, President, and thank you, Chair. Our concern is, as President Croucher relayed, that general principle concern about the importance of the separation of powers and making sure that we do separate the judicial branch from the executive branch in terms of the issuing of warrants. We think it's particularly important in this context, given the role that the National Anti-Corruption Commission will have. Given that they'll be investigating corruption issues in the public sector, we think it's particularly important that issuing of warrants is done by the judicial branch as opposed to the executive branch. And our views in that matter are in no way intended to impugn the integrity of the AAT or the work that they do, but it does reflect that broader general principle about separation of powers.
Okay, because the concern I had was that you were actually saying that, public servants and politicians should be subjected to a different issuing regime for some other reason, but you are saying, you are saying that, but what you're saying is it's about what branch of government they're from, and that is why you don't want people in the same branch issuing the warrant. That's what you're saying. Okay, so it's not about politicisation, and it's not about the way in which it's exercised on behalf of ordinary citizens. It's the fact that they're in the same branch. I'm paraphrasing what you said, but to understand it, that's the point, isn't it?
That's correct. It's not aimed particularly at the AAT as an institution. No. It is about those broader principles of the branch of government, and in particular the context in which the National Anti-Corruption Commission will be doing its work.
Yeah, okay, there's a follow-up question on that point, and I have another point.
Thank you for that. It is one of the consequences of which branch they're in is that Superior Court judges have tenure and generally don't go looking for other jobs afterwards, whereas members of the executive have limited term appointments, 5 or 7 years, and if they're going to be exposed to very sensitive information, there's just an extra risk that one day they'll have to go looking for another job. Is that another consideration?
That is a consideration, and certainly I was listening to the evidence immediately before us, and it has the same flavour as some of the issues that were raised there about why you might have term limits in relation to certain parts of the National Anti-Corruption Commission and the inspector that relates to that. So it is those general principles that aren't unique to this commission, but which do have a heightened importance given the type of work this commission will be asked to do. Okay.
Thank you, Chair.
So your submission also says it's important for the commission to include criminal and non-criminal conduct within the scope of the commission. I think you say that at page 7. Can you expand on that for us? And how can non-criminal corrupt conduct damage the integrity of public administration?
I'm just wondering, Chair, Mr. Spink, would you like to handle that question?
Thank you, President. Thank you, Chair. The definition of corrupt conduct under the bill includes conduct beyond that which is criminal conduct. Conduct which may not necessarily rise to the level of criminal conduct can still cause some issues of public distrust or concerns around the government. And so that is why it's important that this conduct also be included within the scope of the bill.
Thank you. I ask you that because some submissions and evidence has been urging us to focus only on criminal conduct, but I'm interested in, the effect of non-criminal conduct on the integrity of public administration. So you agree that that can flow from non-criminal corrupt conduct? Yes, thank you. Let me ask, is there other questions? Yes, Dr. Haynes. Sorry, Mr. Zapier.
Thank you for your submission. Look, I've just got this question, and it relates to, again, your submission, which on page 5 says that Australia's rank on the Transparency International's Corruption Index has declined by 12 points since 2012. Can you provide some reasons as to why that decline occurred? Or why you believe it occurred?
Mr. Spink?
We might have to take that question on notice to have a look at the factors that the Transparency International body has looked at while in calculating that ranking.
Okay.
Thank you.
Thank you.
Dr. Haynes?
Yes, thank you to the Australian Human Rights Commission, to each of you. Thank you for your submission and your witness today. Your submission noted a number of issues with the exceptional circumstances test, and I've just heard you now, Emeritus Professor, indicating your preference for Section 73(3) C to be mandatory rather than not. I'm wondering if that was made mandatory around the safeguards for public hearings, if in fact you would agree that the exceptional circumstances phrase or test is no longer necessary, and we could thus remove any confusion about when a public hearing might be held.
And perhaps I can call upon Commissioner Finlay in relation to this point. Thank you. Thank you, Dr. Haynes.
Thank you, President. Thank you, Dr. Hayne. Our view in relation to that would be that making that consideration mandatory would provide an additional protection and would help to lessen the concerns that we have about the risk of public hearings in terms of the reputational damage that may be caused. It wouldn't remove them entirely. It is one of the challenging things about this legislation, that it really is striking a balance between very important fundamental rights, on the one hand, to ensure that there are public hearings where that's appropriate so that the educative function of the Commission can be fully realised. But on the other hand, recognising that this is not a court and it is dealing with allegations that can be incredibly serious, and we've seen through other commissions in other jurisdictions the incredibly damaging effect that that can have on people when there are public hearings. So there is a need to ensure there are those procedural protections provided, and in our view, while making that a mandatory consideration would be a positive step, it wouldn't entirely remove the concerns that we do have, and the need to ensure that public hearings, when they're held, are very carefully thought through.
Thank you. Could I ask you then, in regard to Section 73 4, that subsection 3 does not limit the matters to which the Commissioner may have regard. Can I ask you if that provides you with some additional comfort around those safeguards, or do you think there should be additional tests? Could you give me your view on that?
If I may, President Croucher, it does provide us with some additional comfort, but again, they're not mandatory considerations, and so it is a need to, I think, ensure that depending on the particular circumstances, appropriate factors can be taken into account. So we would be provided some comfort, but again, the rights and concerns that we're dealing with are incredibly significant, and there is a need to ensure that public hearings are held when appropriate, but to recognise that there are some very real risks that do attach to that, and some very real damage that can be caused to people in going through a process that is public, but that isn't a judicial process and doesn't have those same due process protections attached to it.
Yes, I understand. I guess I'm trying to understand whether the exceptional circumstances test adds value or adds confusion, and if we were to replace the word may with must have regard to the 5 key safeguards plus additional matters that the Commissioner may have regard, whether in fact we need exceptional circumstances added there as well.
And I think our view would be that it does, but we have in our submission recommended that there be some further clarification provided by the government as to exactly what those exceptional circumstances might be and where it is envisaged that that balance will be struck. Because the really important thing about this commission is how it operates in practice. And so having a very clear understanding of what factors will be taken into account and how it will work in practice is incredibly important. We think the exceptional circumstances test does add value, but it would benefit from clarification and certainty, and that's why we've made the recommendation we have in our submission.
Ms Finlay, would you have any advice to us? Would you have some ideas around what those exceptional circumstances may be?
Certainly, Senator. However, perhaps, my apologies, Dr Haynes. Certainly, however, it may be more useful for the committee if we were to take that on notice rather than simply putting forward an example without giving it due consideration. Because again, one of the things that is really important when considering this legislation is not to consider just individual sections in isolation, but to look at how it will work together as a whole. So when putting forward some examples for you, it would be useful to be able to give that a little bit of thought to make sure that they are well thought through and really do address those issues.
I appreciate that. Thank you very much. And if you could take that on notice, I'd appreciate it.
Thank you. Mr Lim?
Thanks, Chair. At paragraph 64 of your submission, you say the availability of judicial review in the legislation provide a significant safeguard for individuals subject to finding or decision of ICAC, of NAC, page 13. Can you explain why judicial review is important?
I can start on this and then I can invite my colleagues, Mr Lim. Judicial review of administrative action is one of those key law protections. The judicial review of administrative action is also within our constitution as a core principle of the rule of law and the separation of powers. The Administrative Decisions Judicial Review Act created an additional path of judicial review. But judicial review is part of our important integrity rule of law structure when it comes to administrative action. So that would be my answer. Commissioner Finlay, do you wish to add to that?
No, President, I think that was a comprehensive answer.
Can I add one more? In your submission, you recommend that clause 8(1)(e) to be amended or removed, and it provide the Commissioner with significant discretion to expand its jurisdiction without parliamentary approval. You have noted new specific limb of corrupt conduct could be added to the jurisdiction of NAC using disallowable instrument. Noting this clause was created for future and emerging form of corruption, I was wondering whether you may have an example of a current grey area in which you were concerned that the power would be used, or even at the time of writing, whether you have come up with any example to inform this recommendation?
Thank you, Mr. Lim. I'll ask my colleagues if they have a suggestion. There may be a suggestion. I will invite Commissioner Finlay first.
Thank you.
Thank you, President. Thank you, Mr. Lim. I do note from listening to some of the evidence that was given by the Attorney General's Department earlier that they were unable to provide an example that fell within that particular limb that wasn't already covered by the other limbs contained within the definition. And that would be one of the concerns that we do have, that in an attempt to future-proof the definition, there's actually a subsection there under subsection E that creates quite a vague, potentially broad opportunity to expand the jurisdiction of the Commission in areas where there hasn't been the ability for people to identify precisely what type of conduct will actually come within the subsection, and in a way that gives the power to decide upon that jurisdiction to the Commissioner rather than to the Parliament, which is again why, in our view, that definition would be better amended to ensure that if there is the need to extend the jurisdiction of the Commission down the track, that's done through the Parliament rather than through a vague piece of drafting that where the drafters themselves haven't really been able to identify what type of conduct they're talking about.
Thank you. No further question.
Is there any other questions from anyone? No, I think we're done. Okay, thank you very much for your attendance here today. We really appreciate both the work that you do in day to day, but also the work that has been put into this submission to inform us of the view of the Commission. You have been asked to provide some additional information. Would you please forward it to the Secretary within 5 days from today, if at all possible? You will be sent a copy of the transcript of your evidence and will have an opportunity to request corrections to transcription errors as well. Again, thank you very much for appearing. We do appreciate it.
Thank you, Chair, very much, and good luck with your work.
Thank you.
Thank you, Chair.
Thank you.
Can we just... I think we're waiting for another group, but could we maybe off broadcast? Thanks. I think we might commence. Can I now welcome participants from the whistleblowing, what day is it? Whistleblowing House in the Netherlands to give evidence today. For the Hansard record, so the Hansard is our recording of this, would you please state your full names and capacity in which you appear before the committee?
Okay. Good evening. I believe it's already evening for you there. For us, it's early in the morning. My name is Christine Verbraken, and I am a Senior Policy Advisor at the Prevention Department of the Dutch Whistleblowers Authority. So that's the official translation of the name of our organisation. And winging me is my colleague Petra Melis, and she's herself. She's one of our legal advisors.
So if you could, just for the transcript so they can recognise your voice, can you say your name as well?
Yes, my name is Petra Melis.
Thank you. So although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament of Australia and therefore has the same standing as proceedings of the respective houses of the Parliament of Australia. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence today will be recorded by Hansard. It does not, however, attract parliamentary privilege under Australian law, but you will be bound by any of the laws in your own country for evidence of this type. I now invite you to make a brief opening statement before we proceed to discussion. But what I might also do is, you have, I think, sent us a document that you do want to rely upon. And so for the purposes of our proceedings, we will note that that document has been presented by your organisation, and it will be accepted as a submission number to be assigned and will be authorised for publication. So I just need a mover from the committee. So Dr. Haynes has moved that. So what that means in our context is we will publish for the public on our website. We will show them that document because we've put it into evidence. They will be able to access it on our parliamentary website. So can I now invite you to make that brief opening statement if you so wish to?
Yeah, thank you very much, and thank you for having us this morning. I'm very pleased that we have the opportunity to present the workings of the Dutch Whistleblowers Authority for you and for the people in Australia. I would like to begin with some key features, as you can also see in our presentation. Our organisation was established by law on the 1st of July 2016, so that's now more than 6 years ago. What is important is that we are an independent state authority, which means that our competent minister and its government administration has no power to intervene in our internal workings. So they cannot look into any cases, reports or any findings or advice that we give. We report directly to Parliament, and our chairman and board members are all appointed by royal decree. The whole of our office, the whole of our organisation consists of between 25 and 30 full-time equivalents. This fluctuates a bit. And our board consists of 3 people who also help us on a daily basis. They are very actively involved. And we have 4 different departments: a staff department, advice department, investigation and prevention department. We can also rely on an external advisory committee. That is our sparring partner, our sounding board. When we have difficult questions or challenges, they help to think it through with us. And we have currently an annual budget of €4 million. Maybe I can briefly say something about the different departments, so you have a clear idea of what their tasks are. Our advice department, well, that is basically the first department that people from the public, if they are looking for help, will come in contact with. They give them free advice and guarantee absolute confidentiality. They are a sounding board for reporters and potential reporters and trusted persons. Trusted persons are people in organisations where employees can turn to if they want to have a confidential conversation about things they are faced with at work. What is important is that the advice that they ask or they are seeking should be a work-related topic with public interest. So that means if there's an individual conflict between an employee and his or her manager, that has no real public interest for us. So that is not part and parcel of our task. But say that an employee knows that his employer is dumping waste in a forest. That is of public interest because, of course, there are environmental hazards, even public health hazards. So that is definitely something that we will take on board. Our colleagues of the advice department will also always stress the importance of legal aid, and will look if the advice seeker needs mental support, and then there will be referral to a professional psychologist. If the different criteria are met, so if the question they ask us is work-related and has a public interest, but is also reported to the proper authority, then our colleagues will write a service letter, which simply states that indeed we take your question on board and we will guide you. And that is important. They offer guidance, but no advocacy. So the reporter will always remain in charge of his or her information and the report that he or she does. If needed, they will also refer to our investigation department decision totally lies with the whistleblower himself. That brings me to our investigation department that investigates wrongdoings and retaliation. The wrongdoings, again, have to be work-related and of public interest. And the retaliation is, reporters state that because of doing the reporting, there have been taken some reprisals. But any oversight or inspection agencies that are competent, they have to do their work first before our investigation department starts conducting their investigations. Their investigative powers consist of looking into and asking for any documents they might need. They can conduct interviews with people involved, and they can also conduct on-site investigations, so within the organizations where the wrongdoing has taken place or is taking place. The result is that they will write a report with all their findings, which is publicly published, but is also minimized. And they will offer in their report advice, which they will monitor to see if that is carried out. Unfortunately, no other interventions can be done, so we cannot take any sanctions or freeze the work relationship, so we cannot guarantee that the reporter will not be dismissed. And then our prevention department, so that is where I work together with 3 other colleagues. We promote integrity management in organizations, both public, semi-public and private. So we would try to help them set up a strong integrity management system and help them develop that. We do that by making practical tools and disseminating them, also all kinds of instruments that can be helpful. We write and publish brochures, fact sheets. We also have an online integrity self-scan for organizations to use. And we sometimes also conduct research on integrity-related topics, such as recently we've done one on the implementation of the whistleblower procedure and the success factors that are crucial to make it work. We have done one on the functioning of trusted persons, on integrity management, and the role and function of integrity managers in organizations. We also give a lot of presentations, guest lectures, and take part in all kinds of network activities to ensure information and knowledge sharing. So today is a good example of that. We report to Parliament, but also to the public, and we do so by our year report. Here are some results. Well, you can see in the presentation some results of last year. We received 289 requests for advice. We started and finished one investigation, but had 7 others ongoing. And my department received and answered 179 questions. So just to give you an idea, what is the output? And today, and I will not delve into that right now in detail, but you can go through it in the sheets of the presentation. We are currently working very hard on the implementation of the EU Whistleblower Directive. As you know, there is an EU directive to protect whistleblowers, and all EU member states have to transpose that into national law. And in the Netherlands, we are still working on that very hard. We are not alone in that. In total, I think there are still 17 countries in the EU that are still in the process of getting this transposition done. But if you have any further questions on that, myself and my colleague Petra will be more than happy to answer questions you might have on that topic. So I hope I've been managed to stay within the 5 minutes of the brief presentation.
You've done incredibly well. Thank you very much for that. Dr. Haynes, did you want to start?
Yes, thank you so very much, Ms. Verbraeken and Ms. Melis. It's very generous of you to come before the committee, and thank you for making haste given our confusion on the times. We very, very much appreciate this. Thank you for the explanation too of how your whistleblower authority works. We're very interested in what you do because we have a gap in our system here. We don't have a specific body to investigate reprisals against whistleblowers, and we have many circumstances whereby whistleblowers have had what we might consider extremely unfair treatment as a result of them trying to do the right thing. Can you tell me, please, I noticed that you said that you can't take any sanctions when, in fact, you find that there's been wrongdoing afforded to a whistleblower. Could you explain to us, please, what happens when you make a finding? Where does that go then?
Okay, as I said, that all the findings are published in a report, which all the people involved receive, but is also published publicly on our website. And this report can be very important for the whistleblower, because then he or she can take it, for instance, to court when he or she wants the fact that he has been retaliated against to have that addressed. So I think that is a big plus for whistleblowers to have that report and to show it has been investigated. These are the findings. And indeed, there is a causal link between the fact that I reported something and certain measures, reprisals that my employer took. And so then the judge can take that into consideration. Petra, do you have anything to add to that to answer the question?
Yeah, just one thing. At the moment, we're very sorry that we can't take any sanctions, and it's something that we would like to have in the future. But for now, this is the only thing we can do.
Can I ask you, and maybe Ms. Meles, you could answer this, in terms of the success in the court system when the whistleblower takes the report from your body and attempts through the court to get some compensation or some recognition, how successful are they? Does it carry a lot of weight?
We don't know yet, because we don't have much examples of cases where the reporter went to court and sorry, my English is not as well as...
It's fine. It's better than our Dutch, I would suspect.
100%. So there aren't many cases where the reporter went to court with this evidence of our report. So I cannot answer the question very well for you. I'm sorry.
That's all right, and I appreciate that your body has only been in existence since 2016, and you needed to get established, and people needed to understand what you do and come to you. I'm curious, actually, and very pleased to know that you have multiple departments. That you have an advice department, and can you tell me that in giving that advice, your experiences of that and how people find that advice and whether that in fact satisfies people's emotional distress and concerns about being a whistleblower, and what you've learnt in those 5 years around that advice department?
We don't have any customer satisfaction inquiries, so I can't give you any hard data. But what is important is that all people that turn to us will receive an answer. So we always listen to how we can help them, even if we are not the competent authority to actually do things for them. We will refer them and we will always listen. So everybody gets an answer, which is for us very, very important, that nobody is left out in the cold. Because often it's not clear for people to what authority they should actually turn to. It might be quite complex. That's also depending on what it is about, the field of expertise. So we will definitely show them the way. And also the potential reporter or whistleblower will indicate what he or she needs. That can be very different. As I already said, many people might also need some psychological support. And then we will also see if there might be possible risk of retaliation. So we will really look into their personal needs, which might differ from case to case. So it's difficult to just give one global answer on how advice seekers feel after they have been received by our colleagues of the advisory department. But this is actually the department that most people will get in touch with, because that is sort of the start of the whole trajectory. Most cases will not come to the investigation department, though that is basically the exception as far as I can understand. But many people will actually be in touch with our advice centre. And so, yeah, I can't really say any more than that because we don't have any hard data on how pleased people are with the advice that they are given. But I don't have the impression that we get many complaints, because if people would be disgruntled and very dissatisfied, I think we would hear about it. But maybe Petra has some additional information on that.
No, we have not many complaints about people thinking that they're not being helped at our advice department. So I think it's a very good start for people to see where what steps they have to take and still get protected when reporting a wrongdoing.
Can I ask you, you were established in 2016, you're an independent authority of the Parliament, and you report to the Parliament. Why did the Parliament see a need to establish the Whistleblower House? What brought it on?
Well, there were several things at a certain time that just came together and that created a momentum. There had been a number of high-profile whistleblower cases in the Netherlands that attracted, of course, also a lot of media attention. And whistleblowers indicated that they had been left out in the cold and that cases had gone horribly wrong with a huge impact on their lives and also of their families. So there were some pretty dire cases. So they also asked the attention of politicians and people from Parliament to do something about it. And at that moment, there were already several different organizations in the Netherlands working on different aspects of what today the Dutch Whistleblower Authority does. So there was an organization that was specialized in integrity management, but then mainly for the public sector. But there was already a reporting channel where whistleblowers might get advice. So actually, they brought three different organizations that already existed together as the foundation to establish the Dutch Whistleblowers Authority. It took quite a number of years to get it established, because also we are established by law, so a law was needed to be drafted and voted. And that was not an easy thing to do. It took quite a long time and a lot of debate in Parliament. And then after a number of years, we've done an evaluation. So in 2020, we evaluated that particular law by which we were established, and we also gave Parliament a number of points of feedback and suggestions for improvement. And as today, and as we are today working on this transposition of the EU directive into national law, we are striving and pleading that they will also take those points of evaluation into consideration to update and to improve the law that we will be having shortly, we hope.
Thank you very much, Ms. Verbraeken.
Senator Billick.
Thank you. Thank you so much for taking the time to talk with us today. I'm not sure what time it is there.
It's now 9:34 in the morning, so
Great.
9:30. Yeah.
Well, thank you. Thank you for speaking with us. I'm really interested in your prevention committee, and you talked about a range of tools that you use to improve integrity within organisations. Can you very quickly outline to us how you do that? One of the roles of our committee will be education and prevention. So I'm really interested in how you go about that.
Yeah, thank you very much for your question. I'm one of the colleagues who work for the prevention department, so I'm very enthusiastic about working there. And we offer our support to organisations, so to employers. And we would like to see them establishing a strong integrity management system which includes all kinds of different measures, elements. So setting a very clear strategy to work on integrity and so to prevent integrity violations and corruption from happening. And so that's why we are called prevention. So it all starts with working on integrity, so to avoid incidents and then also to avoid the fact that reporting might be needed. How do we go about that? Well, we look for instruments that we can develop so that organizations can really use that. So it's not only preaching and giving presentations on how important integrity is, but we look for what they specifically need to improve integrity and to avoid incidents. So one of these examples is that we've made this self-scan tool. It's an evaluation tool that all organizations, both public, private and semi-public, can use for free on our website. It will ask 35 questions on 7 different topics, which are foundations of an integrity management system. And at the end of filling out all these questions, they get a graphic representation of where they stand with their integrity management at that particular moment in time. They will also see where they can still improve matters. And we, in that same graphic report, we give them also tips and advice on how to improve those particular points. They can use it as often as they can. If they want to do it today and do it again, like say in 6 months, to see if their extra methods have then they can do so. But for us, what I wanted to say is that we can also see the global result of all these scans that are being done in our self-evaluation tool, and that gives us a very good idea what sectors are struggling with what topics and where, for us, the new challenges are to offer new advice and information and tools to help them improve their integrity management. So one of the things that we see across the board for all sectors is, for instance, that they are struggling to communicate about integrity, and integrity in all its forms. Like, why is integrity important in our organization? We have a reporting channel, how does this work? But also if there are incidents, what they can communicate about that. And so we are working now on a project to give organizations good practical tips on how to improve to communicate about integrity.
Is there any obligation on the organisations to actually implement your programs?
Well, they are not obliged to implement our programs, but there are certain laws, and there is one on the European level. There is a directive that at least certain organisations which, for instance, are active on the stock market and or that have a certain turnover of certain amount of million euros, that have to take certain measures, for instance, to promote inclusion and diversity, but also integrity and anti-corruption. So it's not any law in the Netherlands that actually obliges all organizations to take integrity measures, but on higher levels and for certain organizations, especially the bigger ones, they have certain legal requirements that they have to meet, and then they can use our instruments. Peter, do you have anything to add to that? No.
Okay, thank you for that that answer. The other question I had for you was, so you've been running for 6 years, and obviously it took a bit of time to get set up and run and all, but have you got any advice to us about things you've learnt through the course of the work? Like, would you change anything that you're part of, or yeah?
Okay, I've only heard this from my colleagues who were there from the start, because I only started working for the Dutch Whistleblowers Authority last year. But the beginning was rather rocky. When the Whistleblowers Authority was opened. Of course, that was announced in the media, and a number of whistleblowers came with cases that were quite old, so that went years back, and they were not quite happy, of course, with the way those cases were handled. But that meant that it was also very difficult for our colleagues to investigate these cases because they were quite old and situations had changed, of course, in the meantime. And they were flooded a bit by all these older cases. So that was quite difficult for them to tackle all these cases, which were very complex and rather old. So it took quite a long time before the public actually saw any real results from the Dutch Whistleblowers Authority. So there was a bit of critique also, because it took a long time before people actually saw that we were really working on cases. So I would say make sure that also all your processes are thought through, that you have also a clear and common vision, because that was also difficult for us in the beginning, because it started from 3 different already existing organizations that were brought together. They all had their own working processes and goals, and so they had to find how to work together and to have a common goal and to be very clear in who does what. And one of the things that is also important is, for instance, that the cases that VICE is tackling and the investigations that are being done by our investigation department, that they don't mingle, so it stays very separate, and they don't exchange information they should not. So you have to be very careful with that to make sure that everybody stays objective and impartial. So those things are very important. So I think expectation management to the public is very important, so that people know what they can expect from this authority and what not, because you cannot tackle everything. So you have to be quite clear on that. So take enough time to prepare everything and to make sure that everything is transparent and clear, and that also behind the scenes that you know where you stand for and how to go about it. Peter, do you have any other topics or points of advice?
No, I totally agree with what you just said.
That's lovely. Thank you for that.
Thank you. Senator Shoebridge.
Thanks, Chair, and thanks to the two of you for joining us today and sharing your experience. Your jurisdiction, or what you can look at, is both the public sector and the private sector. Is that right?
Yeah, that's correct.
And in your experience, where is most of the work or the reports coming from? Is it mainly coming from the private sector, given the size of the private sector as against the public, or do you have a handle on where the bulk of the reports are coming from, public or private?
I know for the advice department that actually at this moment most requests are from the semi-public sector. So based on the figures of last year, you can also see in our year report, which is also published online in English. So you can find our year reports also in English on our website. And then in second place, it was private sector, and third place, public sector. Why that exactly is, we are not entirely sure why the figures are like that. I believe that it was for, I would have to check, the problem I heard I would say it was 55% semi-public, so schools and hospitals.
Yeah, I saw that. I saw that. I was a bit confused what semi-public means, but that's kind of schools and hospitals and statutory authorities. What is semi-public?
Maybe Petra can give some more examples to make sure that the distinction is clear.
No, that's correct. So schools, universities, medical organizations like hospitals, I think that's quite about what is semi-public, yeah.
So that's a little bit over half, then a little bit over quarter is the public sector, and then about 20% is private sector. Is that kind of the mix?
Yeah, so that is for the requests to our advice department. I don't know how it is in terms of investigation. You should also be able to find that in the year report, but I don't have these figures now at hand. So I do not dare to answer that question because as it's a public hearing, I do not want to make any mistakes.
No, that's... and I had a look in the material you sent, and I said that there were 2 published investigation reports for 2021. I'm not particularly familiar with your website and I couldn't find them on the website. Would it be possible for you to share them with the committee, the 2 published reports that you have, the English version of them?
I don't think we have any English versions of our reports. I think they're only in Dutch. But maybe if you could specify what exactly it is that you're looking for, that maybe we can...
I was just having a look at the investigation reports. You say that there's 2 published investigation reports, but if they're only in Dutch, that wouldn't assist me, because of my tragic monolingual status. Could you give an indication, though? I think your published reports are anonymised in some way. They don't include names.
Yeah, absolutely.
What was the rationale for that? Why is it anonymous? What was the thinking behind that?
That's a good question because we are still also having discussions on if this is absolutely necessary. Is there a way that we can name, for instance, the employer that is actually amiss? Today we've decided to keep it anonymized for a certain serenity, I think, but it's still debated. I don't know if Peter, because she might be more involved in the weighing the different options on that.
Yeah, it's what the Parliament wanted in the time, so that's why it's anonymized, because they didn't want employers to be named and shamed by when they're under investigation. Yeah, I think it's the naming and shaming what scared people to call names in the report, and especially of the reporters, they're anonymized because people are scared that they won't report anymore if it's publicly known that they were the ones reporting the wrongdoing.
So some of it is to protect whistleblowers, but also some of it is to protect the employers. It's a bit of each, is it?
Yeah, and for now we're investigating if it maybe it's good to publish the names of employers because we don't have any sanctions, but in the eye of prevention, maybe it's better to call their names.
Yeah, indeed. Well, thank you very much for your assistance.
Is there any further? No, I don't think so. So can I thank you very much for your attendance today. It's been fantastic that you've been able to join us and give us an insight, and I think also insight into actually how it works, but also I think your observations about the start-up of it and putting different organisations together is very helpful as well. I don't think we asked you for any other things, but we will certainly look at the resources that you have sent us and the website as well. You will get a copy of the transcript of your evidence for posterity, I guess. You can say you've been in Australia. That could go in one of your reports, I reckon. Reach out, and you will have the opportunity to request corrections to the transcription errors if there are any errors, and the Secretariat will liaise with you about that. But really, again, our heartfelt thanks for you taking the time to explain how your organisation works, and we're about to finish our day, so but good luck with the rest of your day. Thank you very much again.
Yeah, thank you very much. It was an honour and a pleasure to be able to assist you in this way. So get in touch if we can be of any further assistance.
Thank you. Thank you very much.
Thank you
very much.
Have a lovely evening. Bye-bye.
Bye-bye.
Good morning.
And so I will now, proceedings are now suspended until 8:30 a.m. Friday, the 21st of October. Thank you.
Thanks, Chair.
Oh, sorry, I'm wrong. It's 9 a.m., not 8:30. Thank you. 9 a.m.
Sleeping. Another half hour of my life just came back.